everyone. Welcome to the 2026 Entertainment and Sports Sections Bootcamp. We have a really exciting day of learning ahead of us. I'm Nancy Prager. I'm the chair of the section, or whatever you call it. And these are our lovely chairs of this event. We are very organic, and Ashley has stepped out for a minute.
Mitchell. I am the vice chair of entertainment. Very excited to have you all here. We hope that you learn a lot, eat a lot, and enjoy the discussion.
Good morning, everyone. I am Brianna Smith. I'm a member of the entertainment section, and like Josie said, I hope you guys enjoy the panels. And that
we're really excited to have everyone here. Sorry, I'm not.
So our first panel of the day is going to be on film and finance, legal and business issues. Our lovely moderator, Chiquita Banks, will be leading the discussion. She's going to tell you a little bit about her panelists, and we're going to dive right in.
And I'm going to tell you something really quickly about Chiquita. Chiquita is an incredible tax attorney. She focuses on film tax credit and also film finance production. She started out in-house at accounting firms and then went in-house to companies like Disney and other places, and has spun out on her own. Provide services to a wide range of production.
I'll bring t-shirts by later, everyone.
and so I've introduced Chiquita, and now she can introduce her panel.
Together, people. Good morning, everyone. Good morning. Come on now, the State Bar, we can do this. As introduced, I'm Chiquita Banks, and our panel today is about the capital stack and explaining to everyone these film finance concepts and legal issues surrounding the capital stack. And before introducing my panelists, I want to give you a little bit of introductory information. So what is the capital stack? For those of you that didn't get a chance to read the materials, it is essentially the full hierarchy of financing sources used to finance a film. It typically includes soft money, as Nancy talked about, that's tax credits and incentives, rebates and grants, senior debt, subordinated debt, equity, and other financing tools such as crowdfunding. Understanding this stack is essential because it tells you who gets paid, when they get paid, and what protections they have. In the last decade or so, specifically because our panel talks about the shift of the stack. Since the advent of streaming, the streamers used a cost-plus financing model to pay their independent producers. However, that shifted today. Streamers have pulled back from that and are forcing producers such as Anthony to return to multi-source rights-based funding and financing. Additionally, lenders have tightened their underwriting standards. Interest rates are higher, production costs are higher. All of these things is making it a challenge now, more so than ever, to fund film projects. So as a result, today's capital stack is much more complex than it's ever been in the recent past. And as every single layer of the stack introduces unique legal issues, we've assembled this panel to tackle those issues and to give you a 50,000-foot understanding of the things that we all do on a regular basis. Now, I'd like to turn it over to my panelists who are excited to impart information. I made Steve tell a joke at the end, so hopefully you'll get a laugh if we have enough time. I'm going to now turn it over to my good friend, Marissa.
Good morning, everyone. Can you guys hear me okay? Okay, there we go. My name is Marissa Crespo. I actually have my practice based out here, Crespo Law Office PC, but I'm also licensed in New Jersey and New York as well. My practice pretty much consists of the entertainment transactional work, focusing on film, television, new media. But in addition to that, I also do IP transactional work, so handling copyrights and trademark registrations, licensing activities, as well as trust and estate planning for creative professionals, business owners, and athletes. So while I'm here today on this panel to talk about film finance, but also look at it too from the perspective of the production legal, taking it from the paperwork to the actual final delivery and all that is entailed in between. So that is me. I'll turn it over to Ms. Keisha.
Good morning. I am Keisha Perry Walker. I am a, hard to believe at this point, 20+ year practicing entertainment attorney. All on the transactional side. I started in music and then segued into film and television, which a lot of my practice consists of today. I started representing producers, content creators, talent, and now I do all of that plus full-on production legal services as well. Similar to Marissa, I also handle copyright, trademarks, as well as holistically advising clients on not just protection for themselves and the properties that they are creating, but the long-term game as well. Like, how are they able to monetize that, which is where the financial, the way that we set things up financially for them can either help or hinder that. So that's me.
Hello, everybody. My name is Anthony Short. I'm a film producer. I started, in post-production and delivery of feature films, and I've worked my way all the way back up to now I'm developing films. My main focus of expertise is physical production. So I work mainly as a line producer on projects that have already been developed. But I do have a couple of packages that are in development that require financing. And so that's what I think brings me to this panel today is talk about that kind of thing. I just recently wrapped a movie with Anthony Mackie on Thursday, and then starting prep on a new movie today, actually. I've got a whole office right now waiting for me after this panel.
Thank you for coming to hang out with
yeah,
us this
thank you.
morning.
I'm a little tired right now, but yeah, and so I'm an independent producer, so that's the different kind of perspective is that I don't work in a studio system. I work in independent, which means we definitely need financing and creative ways of funding these kind of projects.
I am Steve Weisenecker from Barnes and Thornburg here in Atlanta. I practice entertainment law as well and work in film, television, and video games on finance and tax issues. I think the most important clients for this discussion today are I represent a lot of the banks and special purpose lenders that work on independent film projects and utilize a lot of the capital stack as we're about to talk about today, including tax credits, distribution, foreign distribution, paper from streamers, and other similar situations to take advantage of ways that you can create collateral that a lender can provide the financing for independent films. So that's me. And then my joke, I did find a dad joke that was clean and turned to a trusted source called Grok. And so it's not very good.
I'm gonna laugh. Don't
yeah,
worry.
yeah. Okay, good. It's what is a cinematographer's favorite drink? Draft beer, but only if the lighting is right.
Thank you, Steve. We're actually going to start off with you because we're jumping headfirst into debt. Okay. Lenders, as we teed up, have become much more conservative than ever. What specific collateral, covenants, or delivery protections are you seeing lenders institute in 2026? And if you don't mind, please explain some of the different collateral.
Oh, yeah, sure. So the traditional lending stack, is going to start with you're going to have equity, obviously. So you have a certain amount of equity in the project, but then you're going to look at foreign pre-sales. That's a common asset that's used. Of course, tax credits or production incentives, depending on where you are going to be another part of it. Any sort of distribution guarantees, streamer paper. So when a streamer agrees to acquire your project, they'll do something sort of like used to be a negative pickup, but they won't provide any financing at the beginning. They only give it at the end. And then, there's a lot of other creative ways to try to finance it as the situation has changed. And Shakita, you brought it up, and the reason banks have become a lot more stringent on their requirements is performance issues. I mean, that's what ultimately has led us to the situation that we're in right now. You have foreign distributors going under or becoming a banned country such as Russia, where the bank can't take their money if they wanted to. So you have a number of different situations that are causing that situation. You've got, like I said, lack of performance. I've got a great example. How many people here saw Horizon, the Kevin Costner film? Yeah, there are 3 banks that went against that. So, and there's 2 sequels to it. So you can imagine what fun people are having in recovering that. So about $600 million just down the tubes.
Yeah. Well, Anthony, from your side of the table, what is the most challenging part of satisfying these lender requirements? How do you manage those expectations during production?
So yeah, the struggle I have is performance is an interesting way to look at it too. It's the value of what the projects are that we're making versus the cost to make them, which is where I spend a lot of my time. And it's really hard to be able to raise the right amount of money to do it properly, get the right value out of it, and by servicing debt. A really big problem we're having is just interest rates and carrying costs in order to service the money that we need in order to make the product and to even sell it. It's really at a weird cross section right now where we're really kind of in the red. Like to be able to get enough money to even make it is really kind of non-existent. So that's a big thing.
I can imagine. I also want to add in, because Steve brought this up, lack of performance. I'm seeing quite a few bad actor producers these days. Anthony and I actually met on a troubled project. And we noted during the project when we were trying to work on getting the incentive was used as collateral for a loan. And the producers didn't have correct documentation, correct information, and they were uninterested in repaying this loan. The loan has essentially been to litigation. The client won on the merits, and now they're trying to collect. The problem is the producer is not focused on delivering the project at all. He has now moved on to a different project. So even if we'd be able to collect if this project was going to make some money, and it's a great project. It's, watching the dailies and the scenes, it's amazing, but the producer is no longer focused on it and does not care. And it left producers like Anthony, myself, the lender, it's leaving us all with a bad taste in our mouth. So it's not just lack of performance because something happened and, you lost your lead or something along that line. We have a lot of bad actor producers that are also out there as well too. So part of the job of the lenders and the attorneys, poor Steve, is determining whether or not, the producer is credit worthy in addition to the project. Now, Marissa, you brought up during our prep call the importance of how shifting production delivery requirements are happening right now. What changes to production delivery requirements are your clients experiencing, and how do you advocate for your clients in this instance?
I mean, a lot of it really comes down to, the importance of having the chain of title together early on. It's so important because that's really going to be the linchpin of your hang up. And getting the funding, having the project deemed actually delivered. It's usually chain of title, your insurance, if there's music that's involved, getting those clearances. So the earlier that you can actually advise your clients and understanding what is the IP? Like, what is the chain of title? What's missing here? And let's fill in the gaps early on, the better. Because really what this is all about is risk allocation. And so to investors, they want to know that they're investing in a project that is sound, not always about just the creative aspects. So the more that that paperwork is actually in order earlier on, the better, especially since even with MGs, that's all tied to the advances usually tied
What's
to
an MG?
the minimum guarantees. So minimum guarantees, let's say with the distributor, they're not going to give the full amount. They usually will hold back and give increments based off of submitting those deliverables. So advising the clients early on and actually doing the due diligence in the beginning is really important. I worked on a project where what was crazy is that no one had actually ran the copyright report. And when the copyright report was ran, this was going back like 10 years, there were a bunch of liens that were actually put on the copyright record. And they were getting ready to start filming within 3 weeks. So don't know how that happened. It was a lot of cleanup work. We're still going through it. But it's just really interesting that, people were willing to invest money, but no one was doing that check. But you never want to be in the position of representing the client who didn't do that check as well, right? As a producer. So producers, their role, and Anthony, you could back me up on this, is not just producing a great film, but actually delivering. That's really where your credibility stands.
Yeah. Something that I'll add to that as practitioners, especially when we are representing, whether that's the producer or the investors, is making sure that we are doing our due diligence to advise clients. Because especially on the independent side, there are a lot of gaps that I see where a producer comes in, they say, hey, I'm about to produce this project, and they may have limited knowledge when it comes to certain elements. So they may know how to do what is not physical producing. And that is a huge difference for clients. Those who are more strategic or executive producers, they have brought it together. But then those people who are on the ground physical producers and then having a line producer, that's a stark difference. And I have worked on projects where all of those people are in place and we have been able to run smoothly. And I have worked on projects not so much, and my phone rings every 5 minutes because there's a question or there is the attempt to shift what should be done by a physical producer onto my desk as an attorney. So you also have to have those boundaries and understanding what your job is versus the client's job, but also how to advise the client. And I even find that with a lot of independent producers, I find myself also having to refer seasoned people to them so that we can then satisfy what is necessary for the investors so that they're not in default, because that opens up a whole nother can of worms for us representing clients.
Yeah, so you're not only the counselor, but you really do advise on a day-to-day basis, whether you want to or not, from that face you're making.
I'm sorry. I'm gonna need another credit.
I know, that's right. So Anthony, have you used mezzanine financing on any of your recent projects? And if so, what trade-offs did you have to make that, to close that layer of the stack?
Yeah, just recently on the last film we did, we needed a certain amount of equity put up in order to get the ball rolling. And so we structured a mezzanine that set pretty far back in the waterfall, but owned a bigger piece of the back end, and that was the trade-off. It was an interesting offering that we put on the table, and we ended up getting our first $1 million secured that way. So yeah, it was an interesting trade-off, and so far all the producers that put in the money, it was a total of 6 of them that put in different pieces. They all seemed very happy, and we just wrapped that one on Thursday. So
Keisha?
Oh, no. May not know defining the mezzanine
financing. Oh, right. So mezzanine financing is your subordinated debt. Essentially, you have your senior debt, that's your first in debt. However, there are often times where that still leaves you with a gap or additional funds that you need. You may have your equity, you have your tax credits and incentives. And oftentimes the equity is not just the producers, but you have equity investors. Steve talked a ton about senior debt. But there's also a large group of individuals and special purpose vehicles that will lend after you already have everything, either for finishing funds or just to hit that gap. One of the interesting things that I've seen with mezzanine financiers is that they ask for the moon and everything and the stars. They want just as much as your senior debt, your first in debt. I'll give you an example on a project that I worked on, and I represented the lender. Keisha laughed. On this particular project, this was a $4 million project, but they got down to post-production and needed an additional $250,000 to finish out post. They cannot go back to their producers, cannot go back to their equity investors, cannot go back to their senior lender, which was TPC, for additional funds. They'd already blown pretty much their delivery requirements, and this was the last amount of money that they needed to close out and finish this project. Well, the lender knew that. And because the lender knew that, he wanted every single thing possible. He wanted top billing on every poster and every advertisement. He wanted an entire row of seats at every single screening. So that's ABFF. It went into ABFF. That's friends and family screenings. That's the official screening. They wanted 6 different producer credits. 6 different credits. Do you know how hard that is to get 6 different producer credits? Right. From a distributor, in addition to the producers who don't want to give that, but they had to meet all of those requirements. Why? Because they needed this money, and the lender knew that they needed this money. So the trade-off was give them whatever they want so we can get this cash, so we can close out the project and make it to ABFF and get distribution.
And at that point, they were strapped for cash. And instead of coming back to their attorney to negotiate, they decided we're going to take whatever because we don't want to spend any more money.
Yeah, the producers had no attorneys on the other side. And just because I'm a fair person and I knew the producers, I sent a text message like, y'all need your attorney in this. I don't understand. But they didn't want to spend any more money with their attorneys. They didn't have any more money. And so they took the terms that the lender gave, and they were horrible terms, everybody. Horrible. Absolutely horrible terms. So what can you do? Keisha, you're a jack of all trades. You talked about how you've not only worked in film and television, but also in music as well, too. Music catalogs are increasingly being pledged as collateral for film financing projects. What unique legal issues arise when securing and perfecting interest and royalty streams?
I think it goes back to what Marissa touched on, which is understanding the title. Because again, when people are pledging these catalogs, but if you don't fully own it, or whoever is lending against it does not fully understand what their ownership percentage is in the catalog, then the value against what you are lending may not match. So when you are representing lenders, you have to make sure that you are bringing in reputable companies to be able to appraise, do the due diligence and the background work to make sure that, one, whoever says that they own it, they actually own it. And the percentage of ownership is there, and what is the value of that interest. And the other thing that I would just say is making sure that how your client, and because I sit on both sides of the table, I'm always thinking about it from a 360 perspective. But if you are representing the investor, you also want to understand, where does your money fall in the waterfall, right? And that's super important to always understand when you're representing the investor, because sometimes they're like, oh, well, I thought this was going to be a short-term loan. The other thing is, when you do have these mixed forms of collateral,
make sure that you properly understand the expectation of your client that is an investor, because the way things will work in the music world is not necessarily the way that they will work in the film and television world. And then if you are representing the production company, again, making sure that they understand what the expectations are from the for the investor that is coming to the table. I cannot speak enough on managing the expectations and making sure that whatever the party's expectations are properly, because when disputes happen, whatever that agreement, that's going to be the first thing that they go to in order to determine how to resolve it. And you don't want to be the attorney that didn't properly do it, or properly draft the paperwork, because our job as counsel is to not only see what is happening, but what could happen.
Yeah, absolutely. So I think we beat debt over the head enough. Let's jump into soft money. And this will be likely the smallest part of our conversation. We have some juicier issues a bit later. So soft money is tax incentives, rebates, and grants. This is money that doesn't have to be paid back. So what's the goal for producers and for their counsel? To increase and have as much soft money as possible. Now, Anthony, when you're choosing a jurisdiction to film in, how do you balance creative needs with incentive value? And what legal or complex or compliance issues tend to surprise producers?
So I get a lot of people coming to me that ask me to do what's called a variance on budget. So a producer maybe has started a project a couple of years ago or even just recently, and they put together a temporary budget of what they think it might cost. For Georgia, they usually come to me and ask me to say, in Georgia, what would that tax incentive look like? So I go through and I give an opinion and or give some advice on how to maybe do things a little different to increase the incentive qualifies here in Georgia. In the last few years, I've been taking that as putting on the hat of more of a development producer, looking at projects that I'm developing, and I think that's more the question you asked is that where. So if I'm going to take that and I'm not putting my Georgia hat on, where do I go to other countries and or other jurisdictions that are looking at doing it? And so the creative is definitely an interesting one. I was involved in a project that we were trying to bring it to Georgia. It was how I got involved originally. Nancy actually knows this project quite well. And so the project was a story. It's based on a true story that actually happened in Portland, Oregon. And we were trying to recreate it here in Georgia, which we do all the time.
Right.
And so I got involved in the project, and as it started developing and started going, we kind of decided that, the school that this story was about was actually in Portland, Oregon, and the school itself was still there. It's about a deaf community and a deaf school, and how the school was never funded with over all these years. And that's what the story was about. Funny enough, 20, 30 years later, that school still hasn't been funded, and it was still preserved in the exact same way it looked back when the story was originally took place. So in that scenario, it was much more about creative than it was about jurisdiction. We were like, the school offered the entire campus for our story, for our film to go and shoot the movie in the actual place where the story took place.
So in that case, you chose a jurisdiction with the lower incentive percentage over a higher because the creative led.
And once again, I put it to the test with the production value. Here in Georgia, the amount of money I would have had to put into a school to make it look like that, the production design and the reconstructing of a school to either finding a school that kind of looks like it, and, do it was. It really was kind of a balance. Maybe we didn't get as much tax incentive, but it made a lot more sense from a cost analysis. So I think that's an example of, creative over finance. Outside of that, the traditional sense is you have to look at, where you can maximize the dollar. New Jersey is really, big right now. A lot of people are asking me to do variances on New Jersey, and then here in Georgia. But me personally, because I'm selfish, I try to convince people that George is the
To
best
come on
place to go.
home.
Yeah, that's
Mhm.
right.
Yeah.
I like to sleep in my own
Smart
bed.
man. Yeah. Smart.
Yeah.
Steve, what are the most common legal pitfalls you see when producers try to monetize their incentives? And how can you how do you counsel to make sure they get the best bang for their buck, but are also in compliance?
Yeah, so it's a complex issue. But just to back up a little bit, so I don't know how familiar folks are with production incentives. Obviously, the Georgia Film Tax Credit's been wildly popular beyond our wildest dreams, but production incentives are money provided by jurisdictions, whether states or countries, to bring film projects and video game projects to their jurisdiction. They will provide you, whether it can be a transferable tax credit like we have here, it can be a returnable tax credit where you file an income tax return and you get a certain amount of money that can be refunded to you in two ways.
And that's paid by the state.
Paid by the state. Then
Mhm.
there's rebate programs paid by the state. All of these are financeable. Someone will lend against them, whether specialty lenders or can be part of the broader capital stack if you go in that direction. So, there's a lot of different issues because that a bank, lender, a financier, or producer should be looking at when looking at a tax credit or production incentive. And the most important one is they're all not created equal.
Yeah.
So just because, as he was talking about, he talked about, hey, 30%, that sounds great. Or you go to New Jersey, you're going to get 40%. Well, there's a whole bunch of hoops you have to jump through to get all those amounts. So you need to make sure you have a great team in the production that knows what they're doing, knows how to document all these things, knows how to work with the state. They know how to submit on time. They have accountants that are going to do not only production accounting, but
Steve, you're answering my next question.
okay. Sorry. You get me wound up about production incentives. I'll just keep going. But I think the other part, I think important part of the due diligence process is what's going on in that jurisdiction. I have 3 projects that shot in South Africa last year. If you Google South Africa and their film office, you'll find out they have not paid for the last 2 years. And those unfortunate producers borrowed money against that project. So now we are all in a big situation with all 3 of them going, how are you going to pay us back? And because if you've secured, like we did in this instance, against the copyright, I now get to own an independent film and figure out how to sell it, right? So, and a bank is not interested in the best deal. They're interested in the deal that gets them repaid as quickly as possible. So, it's an unfortunate situation. It's not within the control of the producer, but that's just the situation that they find themselves in. So there's a lot of different issues in looking at these incentive programs.
Absolutely. And I think Keisha talked about this a bit earlier, assembling the right financial and production team and how you have to advise your clients sometimes on the right folks to put into the right place. Keisha, what have you seen when people or producers did not put the right folks in the right places? You have a couple of war stories that are, change the names to protect the innocent.
The guilty.
Yeah.
Well, I was being nice.
It becomes a disaster and a headache. There are some things like the story that Steve just told where the producers, they don't have control over an office not paying out on incentives. However, for those producers that know that they don't know it and refuse to surround themselves with people who do, they get themselves into a lot of trouble. And we know that a lot of times when it comes to independent film producers, they will try and, leverage the sun, the moon, the stars, their firstborn, their homes, all things in order to get that money to make that project. And when they don't have the right team around them, they don't have people who know or someone who can guide them when they do it wrong, then now the sun, the moon, the stars, their firstborn, they come calling. Because at the end of the day, unless you are dealing with, what we call vanity investors, people who are more concerned about the credit than they are the money, and they're not hard up if they take a loss. It's not as big of a deal, then but that's such a small percentage of the investors that we deal with.
Right.
So now
Most
they
get
have to
into
deal
it
with,
for money.
right.
It's a business transaction. Mhm.
Right. It is a very slim, but that is also what makes finding capital so hard for and it's not even just independent filmmakers. That is like one of the hardest things. It does not matter who you are, right? To be able to obtain capital because of the fact that you have so many producers and production companies that don't know what they're doing, who have obtained capital, have not repaid it. So an investor is now burned. And when someone that does come along, like an Anthony who knows what he's doing, it's hard to get people to write a check because of those people who have made it difficult. It really just comes down to making sure that we are advising our clients, utilize your resources and know what you don't know, and for what you don't know, get people who do. And sometimes that is where our value as attorneys comes to the table, to be able to say like, hey, I see that you don't know. And sometimes that is a hard conversation to have with clients, because they will be indignant, loud and wrong, even though they know that they don't know. However, if you are having those conversations, you also have to have the ability to say, listen, I see that there is a gap in your team. Let me recommend a few people that you can talk to who are knowledgeable and reputable, and go from there. And I know several times, even when it has come to tax incentives and different elements of the financing, I've had to say, hey, I'm going to put you in contact with Chiquita, and you guys can have the conversation. I have brought in line producers for clients or consultants so that they can actually comply with what we have put on paper. So it's a disaster when they don't know. And, I don't ever want to discourage or crush anyone's dream, but it's like, it's either we are having the sobering conversations so that dream does not become a nightmare.
Please, absolutely.
I was going to say, I'm also in the world of representing, indie filmmakers, like true indie micro budget as well. So a lot of times they're always wondering, how can I get to the money? And the thing is, listen, it's like a chicken and egg thing. You can get to the money. We actually finally made it to get to the money, right? But the ways that you can do that, and I think for us in the room, it's incumbent upon us as attorneys to really help coach them on understanding that it's a business. A lot of times they're very much interested in the creative and don't want to learn the business structure. Put it back on them too, as much as that we're educating on, like, here's, the tax incentives. Here's how we can structure it, understanding. We call it the capital stack, but I call it the scaffolding, right? Because it's constantly evolving and changing, and you're building it as far as the financing goes. And so since they're really in the indie world, a lot of times they're tapping even their friends and family. They have to make sure that they understand what they're investing in, right? Because that's a security transaction if they're talking about equity. So a lot of it is also educating them, letting them know that you are a resource to them, but they still need to do that work too. So it's a little bit of that relationship. Otherwise, it's going to be a headache, right, of a process. They're not going to get anywhere and not know how to actually move their projects forward, and not just think of it as a one-off project. They need to look at their production company as a business. So how do you scale your business and make sure that your corporate structure is actually organized, how you're structuring each and every project, amortizing costs across, if you're in the business of filmmaking? Those are the types of conversations that I enjoy having with clients, just because it's really taking them from thinking about themselves as just a filmmaker to being their own brand.
I love that. And you all teed up the conversation on equity as well, too, and the importance of equity to the entire financing pie. So, Anthony, when you're pitching equity investors, and you never know, there might be some people in here who's interested, right? These are well-paid attorneys in front of you. What expectations do you set in terms of recoupment, timelines, and distribution realities? Now make me look good and set great.
Yeah, I mean, I guess it kind of depends on the project, but if you're talking about just your senior equity positions,
Mhm.
yeah.
Yep.
Um,
How long do you generally tell them it will be before they're paid?
it's going to be a while.
Right.
Yeah, it's going to be a minute. Yeah, it's trying to find what you had mentioned, Keisha, the vanity investor. That usually is a different kind of conversation. If it's somebody that's really looking at investing this in the long term, but they want they're going to want a certain return back in order to make it make sense. Yeah, I usually say 3 years, to really set that expectation up top. And that depends on how much we've already had developed and already, how close we are to go to the production. If you're early on, there's still development to be done.
Right.
There's still going to be a runway. And sometimes that commitment's not necessarily cash in the bank right now. That commitment can do a lot of good. If I know that commitment's there, you can hold on to that money, let it work for yourself until for it.
Right. Because when you have some money,
Exactly.
you can get additional money.
Yes, exactly. And then I can leverage that to start getting some of the debt pieces in place and start getting the, figuring out the rest of our production plan before actually calling on it.
Got it. So Marissa, when you're representing an investor, what are the most important investor protections that you negotiate today?
I mean, really looking at, the waterfall is so important. Like, when are they actually going to get paid back? So understanding, depending on the type of loan that the type of investment that they're giving, is it equity, is it senior debt? And making sure that the terms really match, and understanding who else is also involved in the process, and whether or not what it needs to be drafted in the intercreditor agreements, subordination agreements, even the subscription, the operating agreement, they're going to invest in, they're an equity investor and they're investing in the SPV, making sure that the operating agreement also matches and coincides with the waterfall definition too, so there's no ambiguities. So really it's just clarity around knowing exactly where they fit in the waterfall and how they're going to get their money back, and not just the recoupment, but also the premium that they receive as well.
So Steve.
Yes, ma'am.
IRS section, love this tax talk, you guys. I promise it's good. Bear with us.
If you let CWB and I keep going at it, we'll talk tax all night long.
All day. IRS section 181 can be a meaningful tool for attracting equity investors, but it's also a misused and misrepresented tool. Can you share a little bit about this federal deduction?
Sure. I guess the most misused part and misunderstood part is that it currently has sunset. So it is not in effect for anything that hasn't started shooting as of the end of last year. There is a pending bill called the CREATE Act, which would bring it back. And with all the budget negotiations that are happening or not happening, as the case may be, there's some talk that it will be reintroduced there. But it is a form of accelerated depreciation, which means that an investor that owns the copyright can write off their investment, and there are ways to make it larger than their investment in the project. What it is not a transferable production incentive. It is not a tax credit. It's not a lot of things, and not everybody can take advantage of it. You have to have a certain amount of active or passive income in order to take advantage of it. And so it's a lot of things, but it is not whatever most producers, except for Anthony, would tell you that it is. And there are a lot of scam artists out there that sell this to producers and financiers. And it just doesn't work that way. And if it goes wrong, it goes real wrong. It's real bad. And the feds don't play. So, but it is, if you know what you're doing and you structure it correctly, then you can certainly take advantage of it. And certain investors in certain situations can take advantage of it as well. It also helps for high net worth individuals that have family members that want to get into independent filmmaking. There's a number of situations where it works. That is assuming it comes back, which it keeps going out, and then it comes back, and it keeps being shoved into all sorts of reconciliation bills. So I expect it to come back, and most folks do. The CREATE Act, Senator Warnock is one of the big sponsors of it, and now includes also music recording in it. So it's another reason I think the Recording Academy and a number of other groups have been up on Capitol Hill trying to push it. So I do expect it'll come back, but what it is not right now is it is not in effect.
It is not current law. So Keisha, how do you explain waterfall mechanics to newer investors?
Simply put, it's who gets paid when money comes in, who's in first, second, third, fourth position. So that the waterfall is normally broken out in detail in the operating agreement for the SPV, so that each, I guess, level of investor is aware who gets paid ahead of them, and what that payment looks like. So that's the, like your paycheck, FICA, all of the unemployment tax, Uncle Sam, those are going to come out first. Waterfall is essentially equivalent to your paycheck. Those people get paid first, then all of your deductions and, those things. But that's the easiest way to break it down.
And Anthony, from your perspective, what's the most common source of dispute when it comes to the waterfall? It's not enough money,
Yeah,
Keisha said.
I think everybody, from my perspective, it's the premiums that tend to get put onto the waterfall. So, senior equity gets their money back plus 20%, and then the people behind them, tend to, I don't know if it's necessarily, a lot of times it's trying to explain, where you sit in the waterfall and
the
why.
people who don't have the premium
And the people that don't have
like
the
it,
premium
yeah.
and why, right?
Yeah. So Marissa, how do you draft to prevent those conflicts?
Well, it's definitely important of defining gross receipts or gross revenues and also net proceeds, right? Being very clear about what is actually considered gross before any of those deductions versus all that get, as Keisha said, all that gets kind of deducted out before each of the investor participants actually receive their portion. And so usually, with senior lenders, they're going to be closer to the top. But like your equity investors, those that are taking more of the risk, right? Because they're seeking part of that investment, and the net proceeds portion. I'm trying to talk this morning, excuse me. They're going to see theirs fall a little bit differently and further down in the waterfall. So that clarity, I think, is everything, and making sure that it's cross-referenced as an exhibit to each of the investor agreements, right? That's something that's really going to be key. I think too, we're talking about this in the context of independent financing, but I think also when we're thinking about co-productions, that's also the world of film finance. Being very clear between the parties, how they're getting paid, especially if they were sharing in marketing costs, sharing in any type of fees that were taken off the top. How that gets allocated between the parties, I think, is very important, because I think that's where a lot of confusions arise when you're looking at it from that perspective as well.
And also making sure, again, that they have the right team of people that are tracking all of those costs, because our agreements speak to it. But if you don't have the documented costs, then it's very hard to say this is owed to me, and your client does not have proper receipts. So training them on the importance of how the finance thread runs through everything.
And sorry, the question that you asked me earlier, how else to protect the investors, making sure they can actually see the budget, see, any type of the cost reports. Some investors are a little bit more hands off, some are more hands on. I think the more money that they're putting in, they should see how that money is actually being allocated and resourced. And what I find, which I think is crazy to me at times, when producers don't even have cost reports, right? They don't actually go through the necessary tools. And that's a quick and surefire way to end up in litigation, right? Just off the fact that you can't know exactly how the money is spent, or the accounting records are produced by DFS.
Yeah, and Shakita, I think it's also important, to have a collection account manager in place. There's several specialty companies that do that. And there's a collection account management agreement that documents all of this waterfall very specifically. It can be confusing, and they're lengthy. They're written by they're standardized forms, but they're written by usually foreign companies, because being here, they realize you're going to be sued if you're the collection account manager. So they put themselves in far-flung locations to make it expensive to do that. But they, it's invaluable in that they can, they're the ones that are responsible when money comes in, it gets paid into an account, and they then pay it out according to the order that they've been instructed to do.
Well, I think this is a perfect segue into our very last issue, which is profit participation reporting and accounting practices. The TSG versus Disney lawsuit, and it's in your materials. It's only a complaint because it's settled out of court, right? I'd love to see what that settlement looked like. Steve, can you tell us a bit more about this particular case or complaint? And what it alleges.
Yeah, so it's funny. It's very detailed complaint that talks about Hollywood accounting, which is, if you're in the music industry,
Hollywood accounting.
Yeah, exactly. Which is a misnomer on both sides. It's very similar to record label accounting.
Yeah.
It's very fuzzy. There's not a lot of accounting, and usually money doesn't come out the other side.
And not very many chances to audit
it
either.
Yeah. So this complaint, deals with a very specific primary financier that put money into various projects that were very successful, but they were not getting returns on their investment. And what had happened is the portfolio had been sold off through a series of mergers, and their priority position as the equity investors in these projects had been they've been subordinated without their permission,
and diluted.
Yeah. So it just got worse and worse as the portfolio was sold more and more. And so despite the success of a lot of the projects, it's worth reading. It's very, very long. But it's
interesting. It talks about companies that we know and love. TSG used to be an Fox projects, Fox Entertainment, and then Disney bought Fox. Essentially, they said ever since Disney bought Fox, we've not seen any money. So we have this profit participation agreement, and the studio accounting practices are Hollywood accounting, which is not real accounting. So it's an amazing read. You have, time to read 73 pages. If not, just look it up.
There's lots of articles about it when
Absolutely.
It came out, and once again, there were lots of lawyers involved in the process. There were lots of lawyers and accountants involved in the lawsuit and the eventual settlement of it. But there are successful examples like Legendary that did really, really well, and sold for billions of dollars to Fortress back in the day. So there are ways that it can be done, and there are ways that it can be done incorrectly.
Well, I think that just to wrap it up, what do we tell our attorneys, and what as attorneys do we tell our clients? We need to make sure that we, depending upon which side you're on, we're negotiating audit rights. We need to make sure that there are transparency provisions so that, as Marissa said, you have the opportunity to go in and audit and look at the budget, request cost reports, and to understand your timelines as it relates to film tax credits, incentives, or any soft money. And it also talks about distribution window obligations in that particular complaint as well, too, and how they can oftentimes be manipulated. This case came about in 2023, so it was immediately, during and after COVID. And at that time, Disney changed a lot of just like the remainder of the studios, changed a lot of distribution windows from theatrical to streaming. And as we all know, didn't necessarily share streaming numbers. So that was one of the chief issues in the complaint. So everything we've talked about today is really about making sure we have transparency either for the producer or for the equity investor or the lender. And I hope that you all got some great information from this. We're going to open it up to questions, but I just have one quick round robin of questions for my panelists. MCU or DCU?
MCU.
MCU. Anthony?
Well, my wife was worked for both of them. So right now, DCU.
DCU. Okay. Keisha?
MCU.
Absolutely. Okay. Marissa? MCU. Okay. So MCU hands down. Sorry, Anthony. Okay. Another movie. Boys in the Hood or Menace to Society? I know, right? That was a hard one.
That's
okay.
a hard one.
That's a hard one. Gotta pick one.
I'm gonna go with Boys in the Hood.
Okay.
Yeah.
Dang, Menace to Society. Okay. Hey, Kane, I miss you, boo. Oh, dog, right. Yeah. Like, okay, let's talk about that later. The last one is Avatar or Titanic. Boom.
Yeah, go with Avatar. I worked on that one more. So.
Oh, okay. We got money off that. That's
Yeah.
important. We like to open it up to questions. I'm sorry we only left 5 minutes for questions. Does anyone have one? Omara.
I don't need to stand right. I just
No, you're loud enough.
Great. Thank you. Thank you for that. So my question is regarding, we're talking about the waterfall and the transparency. If you have a client that is doing business with a production company that has received a major production company, not a vanity production company, major working active production company that is receiving major funds from investment companies and private equity firms, how do we control, as in my client who's going to actually do the work, go out and do the actual production on the film, how do we control whether we're getting cross-collateralized or whatever they owe the investor, and how do we control where our money comes out at the end of the waterfall, considering our deal, we don't have any, we're not in privy of contract with obviously the private equity firms, the production house is. So they're giving us money that they receive, let's use $1 million. Let's say they got $2 million from a private equity firm to do a bunch of productions. They then hire us, my client, to do the productions and to actually do the film work. How do we control the waterfall when we have no idea what their deal looked like with the private equity firm in terms of how we're gonna get our money and when?
Client, the PSA.
Yes.
Yeah.
So
Yeah.
if your client is the production services company pursuant to a production services agreement, that becomes very difficult because they are work for hire.
Yep.
And because they are a work for hire, you know, they are brought on as a third party, so they wouldn't necessarily have privity of contract unless it's something that you are able to negotiate. I have.
Even if they're participating on the back end like a partner, 50-50?
Now, if they're coming in 50-50, then I would say instead of allowing your client to be brought in via PSA, they need to JV.
Yeah.
They need to
Okay,
JV.
so
Some kind of co-financing.
Okay, so
It needs
okay.
to be
It's a different
co-pro, not a
agreement.
PSA,
Mhm.
because if they're brought in as a work for hire, then they're, you know, it's just like a major employer.
Yeah.
You wouldn't have that control because I've had clients who've been brought in as a PSA in that very way, but the production company blew the money.
Mhm.
And so they took probably about a good 25 to 30% of the budget and went and bought a house and then told the production services company, this is what you have to produce the project with. So those are controls that you don't have unless you are doing a co-pro or JVing with the company, and then you have that visibility.
Okay.
But not
So
under
if you have a
PSA.
JV, then what do you suggest in terms of the waterfall, that the provisions that you put in to protect yourself in a JV situation?
Well, and to be clear, if your client is a production company, they're going to be on the level of when the producers get paid. So there are still going to be like those debts or the equity and those people who are going to get paid before them,
Mhm.
they're just going to be paid on the same level with the production company versus ahead of them.
But they
you know?
should have transparency into the waterfall so that they can know where they fall.
Exactly. That should
And
be outlined.
and depending upon the relationship with the financier, maybe that's a conversation. I don't know how the relationship.
But is it standard to ask for subordination agreements, to ask for the things like to see where we fall?
I think it's standard to ask for the things that you need. So, and I would do that. And if I know you, you probably already did.
I did. I just was asking if it was correct after I did it.
Yeah, nope, it's correct. Yeah, if you're a back end participator and that's part of, and you're being paid out of the waterfall, it's standard to ask for that to make sure that funds are being collected correctly and dispersed correctly. Again, and it may be worth it to make sure that there's a CAMA and make sure that there's a collection management account. If your client has additional funds that they want to put into it, to make sure that that happens. That way it will be all independent.
And some of the companies that provide the camera services are like Vintage House and Freeway. Those are like the top two that they usually come up a lot. So in case anybody was wondering who are these companies, how do you find them?
You said Vintage House and
Freeway.
What was the first one?
Vintage House.
Vintage
Oh,
with a
I thought
F,
it was
yeah.
vintage.
It's like vintage with a
That's
V
what I
and it's an
said.
F, yeah.
It's a different house. That's different.
With an F.
One more question.
One more question. We're ready.
Broadly speaking, is the capital stack in episodic television like this at all, or is it completely different?
In independent television production,
Yeah.
it could be, but in general, no, because it's done, the financing's done completely differently.
Okay, thank you all.
First of all, I want to thank Bill for subbing on the sports side. I'm sure I guess he's a pinch hitter. I'm sorry, Russ couldn't be with us today. Russ was with us last year, but now we get to work with Bill. And Bill and I actually touched base earlier this year. One of the things about being a member of the bar is we are a regulated industry. And I don't know, how many of you think of yourself as a part of a regulated industry? I mean, right, but only a few people raise their hands. Like, I never really think of us as regulated, and I ran into it because one of my goals as the section chair was to get the bar behind an effort to have production council covered by the tax credit. And there's a Supreme Court case that basically means that we are almost like a mandatory union because we're a compulsory bar. And that was a really interesting experience for me. But also as chair, I get asked a lot of ethics questions, or I'm told of challenges people have faced. So I thought having an ask the general counsel anything about ethics would be a wonderful way to get started. So Bill is subbing, but Bill has an incredible amount of experience, ranging from being a county and city attorney. How long have you been with the bar also?
12 years.
12 years, but he also teaches. So I'm grateful for him to be here to share some insight with us. So I thought we'd start with one of the biggest challenges our members face. I think more so than in other industries, which is conflicts of interest. Because if you're representing a band, there's 4 members of a band, you're dealing with conflicts there. If you're a music lawyer for a long time, you might have worked with a label, and now you've got an artist that's signing to a label. There's just a myriad of places where you can run into conflicts. So I guess we'll start with sort of the idea of joint representation, which is, when you're representing a band or a group. I mean, the same thing happens when you're setting up an LLC for a new company. So it's a similar kind of issue. How do you suggest navigating that potential minefield of conflicts?
Well, conflicts of interest are probably the number one thing I will answer on ethics duty. It's not the number one reason we get bar complaints. Number one reason we get bar complaints is lawyers won't call their clients back.
Oh, interesting.
But the number one question I get asked is, and it's always very complicated. Nobody ever calls me up and said, I represented the husband in a divorce, he fired me, so I decided to represent the wife. Oh yeah, that's a conflict. That's a simple. It's usually a lot more fact intensive, as I would imagine yours are. So when you're representing multiple people, the rules you need to look at is Rule 1.7, which is our basic conflict rule, 1.8, which is a former client, 1.9, and all the way up to 1.18, which is prospective client. That really has more to do with confidentiality, but still can do with conflicts as well. So when you're representing multiple people, the first thing to do is pay attention to our rule that has to do with communications and make sure everybody understands it. So if you've got 4 people that you are representing, and the 4 people maybe in their mind represent one, the band or whatever it is. So to them, it's like, well, you're just representing us as one thing. And you have to explain to them, but one of you may have a different point of view later on. And if that happens, I can't represent you any longer. And that person may say, okay, but then you turn around and look at the other 3 and say, nor can I represent you any longer. I can't represent any of you if the conflict, depending on what the conflict is. And so everything is so fact specific. I wish I could just paint with a broad brush and say, this is what you do, A, B, C. This isn't like that. Right. And we're glad to talk to you about it and try and walk you through it. But the main thing is just to make sure that everyone says, look, if a conflict arises, I may have to withdraw from this entire representation.
And I appreciate that it's sort of like fair use, which many of us deal with. There's not one specific way we can answer. But like one thing I do when I'm dealing with multiple parties is in my engagement agreement, I have a provision that explains that I represent the entity to be formed, or I represent the entire entity, don't represent any of you individually. If there's a conflict that arises, I will have to withdraw. I can't represent any of you, including the entity possibly. And then I have them initial it.
Well, our rules require that any waiver of conflict of interest must be in writing, which would be the next step of this. Now, you've also got Rule 1.13, which is if you are representing a corporation or an entity or a government or something like that. So if you're representing the organization, the band itself, or whatever it is, or if they've got a corporation or an LLC, and you can say, that's my client, not you individually. Then you have further duties that go beyond conflicts, that if you've got 4 people that form a group and you're representing the group, you represent we'll say an LLC, you don't represent the individual members. You tell them that I don't represent you. I represent what's going to be best for this organization. And then if somehow or another somebody comes to you and wants to talk to you, you're going to have to say, whoa, wait. Whatever you're about to tell me may not be confidential, because I don't represent you. I represent the organization. So if you're going to tell me something contrary to the organization, I have a duty to share it with the members of the organization who are the organization.
Yeah.
So that's something to always remember.
Yeah, no, that's hard, because that confidentiality of communications, because there really isn't, as long as it pertains to the working of the whatever the entity is, or the partnership is, or the LLC, or whatever it is. Because like, if someone says, I really don't like the way so-and-so is doing something, that also could create another conflict, which is you now have partners that are adverse to each other.
Yeah, I mean, it may be one of those situations where you would just, you guys need to, and then, but I can't get to the middle of that. Now, understand that if somebody is in an organization, as long as it's something that is I mean, like, for instance, if you were representing a band and one of the members came and said, would you do a will for my mother? Sure. That's not a conflict to anybody else.
Right.
It has nothing to do with it. It usually isn't quite that cut and dried. But, make sure that whenever if somebody is, if it looks like it's evolving into a conflict, you need to be ahead of it. You need to be talking to them about it, and then say, it might be best for you to get separate counsel.
I just want y'all to know I'm taking notes while I'm sitting here. Hope y'all are, because this is really valuable. But you just said two things come to mind. One is, if you're in a creative industry as counsel, you might have on our last panel, someone said that they are now developing projects as well as producing projects for other people. So you may be working with someone as an employee of another company, and then they say, hey, I'm now doing my own thing. That's less of an issue in this case. But if you're representing one group and then one of those people comes and says, I want to do a solo project independently of the rest of the group, what do you think? And I just came up with it, so I'm formulating it as, what is that?
Need a heap more facts than that,
Okay.
because it would be, and the answer is yes, no, and maybe, that you have a conflict, simply because if somebody says, say you have a group and it's a musical group of some sort, and one of them says, I'm going to go off and do a little something on my own that's different, then you have to decide, is this a problem to the organization or the people that you are representing? Have you discussed that with them? Is everybody in agreement? That's what can happen. And if they're saying, somebody may say, well, no, you're going to be taking money out of my pocket if you go out and do a solo something. And in a case like that, what you would tell that person is that, no, I can't represent you with that because it'd be contrary to you and my other clients, the group. But it just really, it's very factual as to and if the other side says we don't care, then I would say then that needs to be an agreement in writing.
Helpful. Bill, it just occurred to me, you're from Macon originally, and that sounded like a very Macon based music story.
Oh yeah. I have the Allman Brothers first album hanging up in my bedroom with a note that says, Bill, don't forget to boogie, Greg Allman, ABB.
That's so cool.
Yeah, it is.
That actually brings up sort of some friction points that can arise when you're representing artists. There's a band from Athens that everything they do is equal. Like they don't have any split, that everything it's equal. As far as I know, I don't know this from confidential sources, it's just from pop culture. But there's some other bands where when I was coming up, the lead singer would live in the nicest part of town, and the other members might struggle to pay rent because they had the songwriting rights. So you end up with these sort of unequal ownership issues within a band, and that can create friction. As counsel to a band or that kind of situation, would you advise you need to explain to everyone involved, like when you're signing, like at what point do you tell people to go get their own lawyer when you know that there's going to be a friction point coming up?
You probably need to tell people that they have that you might want to consider an attorney at all times to people, because you don't ever want it to look like that you were trying to keep everybody sort of corralled for your own purposes. But if a group gets together and together they decide that one of them is the face of the group, or maybe more important for whatever reasons or something like that, like Creedence Clearwater Revival comes to mind.
Yeah,
that was certainly his point of view. That everyone needs to understand what they're unique. So I've created this. If that's what we're talking about, I've created this agreement that shows the splits and how things are going to be done. you have a right to take this to a lawyer and get a second opinion on this. And I think that protects you and it protects everyone else, because I think probably, just guessing at this, that what really happens is that they're not really paying attention. They're artists. They're not lawyers. You know, hey, we just want to do our thing. And then later on, when all of a sudden they find out they're not getting money that other people are, then they, are sort of unhappy about it. And it's like, why didn't you take care of me? You were there, you were my lawyer. And you went, wait a minute, I was everybody's lawyer. What do you
So I can share with you, at one point when I was a younger attorney, which seems like a long, long time ago, I thought my practice was going to be representing musicians that were in that exact situation where they had agreed to terms in situations where it was not fair, it was not equitable, and try to get them some stuff, resolve issues. And oftentimes it came down to the only real recourse they had was to go after the attorney or attorneys, but attorney who had represented them. And because of the power dynamics at the time in the industry, people weren't going to do that. And so oftentimes, I think when you think about this from the artist perspective, I think making more disclosures up front is even more important, so they understand that you're not their lawyer. Because that was really sad seeing that these people had no recourse.
Yeah.
But that brings up the interesting thing, which is the industry custom. In the music industry, when I was more involved with it, it was very standard to have an attorney who might be involved with all sides of the deal. Might have written the agreement. This may or may not be a true story. May have written the agreement for the major label, may have negotiated the employment agreement for the attorney, for the head of the label, and then has a band that they're representing signing that agreement that's now being done by that. Never disclosed any of that to the artist. But that was standard practice. Would the bar, like if somebody complained, would the bar say, well, industry custom was that was normal? So does that have any sway over the bar?
No. It doesn't. And the reason why is because it's, I sort of get this out of the way on almost everything that I do one of these ethics presentations or a Q&A like this, is that, do you know how many people the State Bar of Georgia was formed late 1963, took hold in 1964? Do you know how many people we've disbarred in all those years?
Mm-mm. Oh, what?
Not a one. We have no authority to disbar anybody.
Oh, because
only the Supreme Court can do that. Rules that we follow are promulgated by the Supreme Court of Georgia. The flexibility lies with them, not us. And so they don't have anything. Robert's Rules of Order from the parliamentarian for the bar does have some things like that. It says custom, tradition, things like that can, in a smaller deliberate body, be used. But with us, our rules, if you'll listen to anybody doing a presentation on professionalism, they'll say that the Georgia Rules of Professional Conduct are the absolute bare minimum. You must do, that's the bare minimum. You can't go below those at all. And that's true. That makes it sound like we're not as minimal as it sounds, but the rules that we have say what they say. And now there is some interpretation, but traditions and customs are not part of our rules.
That was very helpful. Thank you. That was really, so one of the issues that has come up a lot lately in the world of music is the use of trademarks and band names and kicking members out and all kinds of stuff, so that you might have represented an artist, a band, 20 years ago, and they got big, and then everybody falls off, and this one member is still using the band's name and you're still working with them. And then two of the former members show up and say, hey, wait a minute. We don't want them to use the name anymore or whatever. So there's this dispute much later on. How would an attorney deal with sort of that? It's not like a later rising.
Rule 1.8, former clients when you, again, it would depend on who did you represent in the beginning. So if you represented the people that created the band as if you only represented the entity, one thing. If you represented the members in this, like you helped them form this, and they are your clients, then what our rules say is that if it arises out of the same transaction and event, the representation you have now of a former client or against a former client, if it arose out of the same transaction event that caused the first representation, you have a direct conflict, and you just have to say, I can't be involved in that because you have inside information. Now, let me say this about inside information. We get this all the time. Lawyer says, somebody came in to see me. It was 3 years ago. I don't have any recollection of them coming here. I know what in our billing records, we show that they came, show that we talked to them, but they never hired us. I don't know what they said. I don't know what the thing is about. I have no idea. And now you're telling me I have a conflict because now I'm representing somebody on the other side of this when I couldn't do anything to this person because I don't even know what I talked to them about. That doesn't matter. It's not what you remember. It's what the client or the potential client or prospective client remembers. So if you had contact with them, no matter what you do or don't remember, it sticks. And the conflict doesn't go away over time. It is to the grave.
That is really, and it again brings up a memory from my younger years where an attorney did something I disagreed. Anyway, a different state. But that actually brings up another question, which is when an artist comes in to talk to you about representing them, and then it turns out they're part of a band, and what's best for so there's some very famous bands. You mentioned one, Creedence Clearwater Revival, but there are quite a few other. The Rolling Stones is another good example, where you think that there's multiple members, and John, please help me here, and Phil. You think there are multiple members, but there's really only 3, or even in one case that I know really well because I worked on something related, there's only one. And so you're sort of strategizing the best way to protect whoever that one artist is. Like there's a very famous band and there's only really one person who owns the band and everyone else is a W-2 employee, as an example. If they came into me and they're talking to me and I'm like, well, the best way to set this up is not to be a band, but for you to be the only person. I feel like somewhere along the way, when you're strategizing with a client, ethics becomes part of it, because if you set them up so that they're your client and everyone else is like an employee or something like that, then you sort of get to avoid this conflict issue.
You would, I think. If someone it depends on how they come. If one artist comes to you and says, I want to create a band and I have 3 other people that are going to join me in this, but I'm going to pay them. They're going to be my employees. I'm going to have I want the corporation or the LLC, or whatever it is, whatever the structure may be. And they'll work for me and I'll pay workers' comp. I'll do all the stuff that you do, just like if it was any kind of a business. As long as you're not representing any of the others, then it does sort of keep you away from the conflicts. But you have to remember that if you are talking to the group as a whole, they need to understand who you are and who you represent and who you do not represent. So if somebody in the band says, I don't know that this agreement that I have with, we'll say, the boss is fair, then, you just say, I don't represent you. As long as you're just keeping that arm's length. It's probably not a bad way to organize something if you are worried about conflicts, but that's from the lawyer's perspective.
Right.
Now, from the music perspective, I don't know what would be more advantageous, whether the multiple ownership or single ownership, what's most likely to, I think that, in most bands, cohesiveness seems to be, pretty important. Like when you look at like KISS, which is, who they are is just about as important as what they do.
Right.
So, I mean, and that's something I guess that from an entertainment lawyer standpoint, you have to think what is best for the whole and discuss that with your client. And of course, whoever your client is under Rule 1.2, which is the allocation of authority between the lawyer and the client, if you've accepted the representation, they're not asking you to do something illegal, immoral, or unethical, or repulsive, or something like that, then you either do it or you get out. And I mean, they drive the ship to a certain extent. Now, you can say, what you're asking me to do is foolish. That's Rule 2.1, which is the lawyer as a counselor, where you have a duty to tell, you don't sing sunshine reports to everybody. And if what they're asking you to do is just stupid, you just need to tell them that. That's why they hire you as an expert. You wouldn't hire a doctor to keep your serious diagnosis away from you because he thinks it'll make you feel bad.
Right. I unfortunately run into that a lot. Actually, it leads to a question that I'd like audience participation a little bit. There's not as many bands anymore. I mean, there's a lot of solo artists and a lot of a lot of collaborations, but it's an interesting, I mean, do y'all see that in your practice, that there's a lot of solos and a lot of other sort of ways, but not as many bands?
Yeah.
Yeah, thank you.
I have a question if it's okay.
Yeah.
So it's, I guess, more common that you might have a 4-member band come in and they're talking about forming a, band entity. And then after that, maybe one member calls you, or, they've discussed and they've decided actually this one person's going to own it because they're maybe spending money and they write the songs. But you've already chatted to all of them. And so maybe there's some expectation from the other members that you might be representing them. At that time, is it possible to, pivot and represent that one member and maybe send letters out and, waive any conflict from the other members who were in your first meeting with them?
Well, the first thing that should happen if 4 people come in is, when you meet them and talk to them, say, well, why are you here? If they say, well, we want to form a band, are you asking me to come up with an entity of some sort, a legal entity, a LLC, a corporation, or whatever? If the answer is yes, then who's going to be members of this? Who do you think that I represent? What's my representation going to be? And then you should write a letter of representation to whoever the clients are that sets out the scope of your duties and your responsibilities. So you have it in writing, because it'll be the first thing we'll ask for when they ask you, when that somebody says you operated in a conflict situation. We'll want to see your engagement letter, which we don't require you have one, but it's very important that you do. So the first thing to do when you're talking to anyone is just find out, who do I really represent? That's the most important question with conflicts, is who do I really represent? So if they don't exactly know, or you don't feel like they know, then that's when you need to explain about conflicts, things that could happen, how that if some of y'all get crossed up even slightly, I mean, not to a point where we're all going to split up and hate each other, but it's just like, no, this is, you can say, I may not be able to have any part of that. And that might be when you say, well, why don't I just represent just the entity? And then, instead of each one of you individually. And then, of course, with the entity, it's still tricky because they're the ones that speak for the entity. I don't know if that's what you're kind of.
Yeah. And then after that, if they pivot and maybe one person's going to own it, can you still represent if the other members waive the conflict, or do you have to totally decline representation?
But if they all, I think if 4 people come in and then they talk to you and you figure out what's the correct vehicle to use, whether it's, we'll just say it's a corporation or whatever, or something, and then then somebody calls you back on the band and says, look, we've all been talking and we think that Joe should be the owner of the whole thing. Then that's when I'd say, well, let's get everybody back together and let's talk about this. And then you need to explain to everybody what this means, because if you're going to be a W-2 employee, you could be fired. I mean, I just say generically to everybody, this is what this means. And so you tell me how you wish for me to go forward. And if they say, yeah, we think that's the way to do it, because Joe's putting in all the money, he's writing all the songs, he's doing whatever it is, then what I would do is I'd say, well, if we're going to keep on with this, then, even though it may not be necessary, I'd want a waiver of conflict in writing, just so there's ever a misunderstanding. In at least in the music industry, there's lots of misunderstanding.
And then, I mean, even on the film and TV side, there's
sure.
so many. And then that was a great question, John. Thank you. And if anybody else has some questions, because we're going to wrap up conflicts in a minute and go to the next subject.
Hi.
Will you say who you are? Sorry, that was John C. Or say.
Hi, everyone. I'm attorney Jasmine Robinson, practice entertainment law. My question is regarding your engagement letter. To the extent of including a conflict provision there, is that okay? What can we say? What can't we say? Because yes, conflicts, you may realize they arise when they arise, but just trying to be as proactive with those as possible. What's the smart practices for the actual engagement agreement? Or is that even possible?
Yeah, that is a good question. Yes, it's possible. And yes, that's actually very desirable. If you're going to represent multiple people and you're going to do a letter of engagement to everybody, you do need to mention conflicts of interest and how they can arise. And they need to understand that if there is a conflict of interest between the parties, that it may affect your ability to represent that party or all parties. And so you could leave it sort of broad, but I mean, to mention conflicts of interest when you're representing multiple parties is very, very good practice.
And I have, when I have that situation, I have an initial on my DocuSign. So I have them initial that provision specifically so that I can. But I mean, can I follow on to your question? So I just looked at an engagement agreement from a big law for a project a client is working on. And they have that infamous, I think it was either King and Spalding or Austin and Bird language that says basically we have the right to represent people that are in conflict with you. I know it was an issue like 20 years ago in the state because I remember it becoming an issue. Like I remember there was like I just thought of it and I didn't look up the case, and so I'm blind. But this is a provision that big law has because their argument is you don't know when a conflict between clients might arise. So I've dealt with it in the patent situation where I had a client that was dropped from a firm because if they continued to work when they did the claims analysis, they saw that they could lose, they were in conflict with Gillette, which was one of their big clients. And so they dropped my client because they couldn't continue. But have you ever run into that where you have a waiver of potential conflicts between?
Our rules for the waiver of conflicts of interest say that they must be knowing and understood by the client, and the client must have an opportunity to seek outside counsel to look at that. And if you're just blanket statement saying it and they're not signing off on it, I don't think it does not work with our rules.
Okay, this was a different state. And also full disclosure, I don't remember which big law firm it was that had this 20 years ago. So if it was not King and Spalding and Austin and Bird, I apologize.
It's like, I mean, you can't have something in your agreement that says if I do something bad, it doesn't count. Right.
And so this is a different kind of conflict. These are potential conflicts that we can identify, right, and we can advise our clients that these could happen. And so I like that. I like that distinction. That was very helpful. JJ had a question.
Hey, yes. Can we pivot?
Wait, tell us who you are.
My name is JJ Poole. I'm a sports and entertainment lawyer. I do both sports and entertainment.
And you do litigation.
And I do litigation. Okay, thank you. Can we pivot to sports for a second? I know we've been talking about entertainment, but in the spirit of these blanket style retainers, right? So, you know, I have a provision in my retainers that is similar to what Jasmine had described, what Attorney Jasmine had described in regard to the conflict. However, I have a situation where, you know, I represent the head of player development for a very large university. Okay. but I also represent NIL clients who are possible recruits to the university, and I have a couple of clients that have been recruited to the university. To what extent am I to go back and address whether or not that may be a conflict, especially since I don't represent the university. I represent the head of player development, but I do represent the kid who typically may either not be an adult, so it'd be his parents, and or maybe a young adult whose comprehension of conflicts may not be as developed as more seasoned athlete.
I'm trying to see if I understand what the question is. So you're wanting to know, you have to let them know that you represented.
Yeah, if I've got a blanket statement in my retainer that says I can represent other people as it relates to generally representations in the area of sports, say football, right? That's what we're talking about. All right, and
can I just stop 1 second, JJ, just so I can clarify? So that's a different kind of conflict acknowledgement that happens a lot in the film and sports and other industry, because you may end up representing like 5 different producers of different projects, but they're sort of all swimming in the same pool. And so it's almost more like a conflict acknowledgement that you can represent other people that have similar interest separately, that you're not exclusively representing producer A or sports player athlete A or sports professional B. And so it's just sort of like an acknowledgement. Is that a good way of explaining it, JJ?
yeah, it's an acknowledgement, but I'm asking.
Yeah, and now you've got the follow-up question.
Right, when I do get in those situations and the school begins to recruit one of my guys, and we're now in negotiations with the school, is there a duty for me to go back and to both of my clients in this instance? Because if I'm not representing the school, but the head of player development, and I'm representing the player who is in negotiations talk with someone.
The head of development of player development, is that what you said it was?
Yes.
Does that person work for the university?
Yes, he does. He's the head of the football
Then
division.
he would be part of the university then.
Right. So and that's what I'm saying. I'm asking.
Oh, and
not representing the university though.
Is your representation over when the player development signs their deal with the school? Because you don't represent the school, you've represented him, but you're not working with him on anything he does for the school.
Correct.
Right. I'm just trying to clarify further. So he represents somebody that he signed. This is very much the music.
Who pays the development person?
The university.
Okay, well then they're a university employee.
Okay, got it.
Okay.
So
this person is going to want to pay the least possible, and the kid is going to want to get the most possible.
Correct. Correct. And the kid, I'm representing the kid.
So what were you doing for the development person then?
I represented him on his contract with the school, and I represented him personally.
Yeah. Okay. Now I understand.
Yeah.
All right. So, okay. No, that's something that's different. That doesn't have anything to do with the kid. They don't rise out of the same facts and circumstances.
I assumed that. I wanted to be sure because I still represent.
I thought you were saying you were going to represent the two against each other.
No, I don't think the interests are adverse.
Do it.
Yeah.
Very much that industry example that I talked about for the attorney that had represented, like literally represented the executive.
Yeah.
Got signed to the label.
Right, because he's an executive
and
considered.
then later represented a band that got really screwed by that label and that executive, figuratively. But is your representation, like that's the question that I have. Like that attorney, the one that was in the conflict, said that his representation of the executive ended when he negotiated that agreement for his engagement. Like at that point, he was no longer the client. So the question is, why is this person still your client if you've already finished the deal?
Well, because he's asked me to be his personal lawyer now.
But not for just, but I mean, like if you want the will or he wants to buy a house.
Correct. Every for his
That's-
general needs.
The two don't have anything to do with each other.
Right.
No, that's fine.
Okay, I assumed that was fine. I just want to make
That-
sure because
That was a great example. Thank you.
because he has contact now with my players, and so it may be assumed that since I represent him in some capacity, that I may have some influence over the negotiation in a different way.
I would tell the director, this person, say, look, I represent these kids, I represent these kids. I will have to disclose to them that I have represented you in the past, but it has nothing to do with this. And I'm not going to be representing him to try and give you less and you to try and get you more, because I couldn't do that because obviously it just wouldn't work. So as long as you make it's almost a little bit akin to like with you're an insurance defense attorney.
Yeah.
Who do you work for? It's really not the insurance company, but they sure think so.
Right.
Follow up really fast on that because I'm thinking back to that situation that I was involved with. I think that he did not disclose to the band any of that, but I think if problem like that he was so embedded. But I think that I would also want to make sure that the players don't think they're going to get a better deal because they're working with you.
Right.
Because that's that future. Past success doesn't guarantee future.
Right.
And so I would be very careful about that. That's just me.
That is
Yes,
good.
yeah.
I have those blanket statements in my retainers that say that, but I do not, from what I'm hearing is I need to address it specifically head on.
Yeah, you just don't want to make, but you don't want to make. You're right. Don't make it where it sounds like you have inside baseball and you'll be able to get them more because of your relationship.
I know you wouldn't, but I would also be like, I would tell them like, there's no guarantee.
They don't know most of the time.
Right.
Okay, we've got two more questions, and then we'll end with the last issue. I don't know your name. I'm sorry.
Nicole. I'm Nicole Theodore.
Oh, nice to see you.
I don't have my name tag on. Sorry.
I can see you now.
I do sports and entertainment and some business as well. My question is, and I feel like I should have asked this a long time ago, but I just thought of it when JJ was speaking. When you have multiple clients who are coming to you, if they want to form an LLC for like a production company or something like that, and they're at the very beginning. And so they want to come to me to help form the company. So they've done some pre-incorporation activities. Maybe they voted on officers and all that kind of stuff, had a meeting. When you do your engagement agreement, if I'm very clear in my engagement agreement, I represent the to be formed entity, not you as individuals. Is it okay to have one person on behalf of the entity sign the engagement agreement, or should I have all of the incorporators sign the engagement agreement? I also do a separate conflict waiver that I attach as well, that I do have all the members sign, but I don't know if I need all the members to sign the engagement agreement.
I would have everyone sign.
Okay.
Yeah, because I mean, otherwise there just leaves too much room for you didn't tell me this or whatever. And even though you can say, yes, I did.
Right.
Writing is a very powerful tool.
Right. Got it.
And with DocuSign or HelloSign or anything.
Yep.
Yeah, well, that's the same.
Yeah. No, but it makes it
Electronic is
easy
let
to
you.
send it out.
Okay. I just wasn't sure if having all of them sign the waiver was enough, but got it.
No, I would do both.
Got it. Thank you.
That's a great question. I saw, and tell us who you are. And what,
My name is Ashwin Rozier. I do NIL in sports. I'm also like an NBA agent. So I wanted to piggyback off attorney JJ because like for the NBA purposes, you can't represent a coach and a player. So that's why I was kind of thinking like that might still be a conflict because even the NBA doesn't want you representing players and athletes at the same time. Like you can't represent a GM and represent an athlete no matter what.
In that business.
Yeah,
That's not what he's doing.
That's
That's not what he's doing.
And also, that's the.
I agree with what you're saying.
Yeah, that's the policy.
Because that's what I was like, that's
NBPA.
kind of a slippery slope because even if like you still work for the university type of thing, but you still represent those children. So it's not working for the university, but for him. So like I was thinking like that could still be a potential.
He doesn't represent the player development person in player development.
Well, he's
He
a contract for them. So like, but
No,
I'm saying like
all he
might
did was negotiate his contract with the university. That's come and gone. It's over with. And it has nothing to do with the kids. It doesn't arise out of the same circumstances. So he's done there. So the rest of his representation is just his personal stuff.
And so this is a great example, Ashley, that's a great question. Is that one of the hardest things I had to learn and still sometimes struggle with is the difference between a legal conflict and a conflict. That when that circles back to the regulated industry piece, is that we're talking about conflicts that are under the legal industry, not like
MBPA.
or
situation.
right, but even like there's so many things like so many ways that our legal conflict rules sort of don't make sense if you look at them outside of the law. But then there's also conflicts that are outside, like what you're talking about, that you could say, so that parsing, it's like almost like taking a blade of grass and parsing. But to your point, Ashlyn and JJ even acknowledged this, what I was talking, that story I'd said about the music industry person, it comes up a lot in different industries. Like, I actually, while I was here, I got an email from someone asking, "You know anybody who invests in film?" I'm like, "Yeah, but they're not going to invest in yours." But because I end up like one of the big things I struggle with, and I'm struggling with it right now. So Ashlyn, thank you for asking this question. My clients' relationships are their relationships. So when I'm dealing with like an agent or a management company or anything like that, like I know people but then someone says, "Can you help me find an agent? Can you help me find a manager?" I've built my practice with the answer to that always being no, because anybody I know, unless I know them somehow else, is through my clients, and those are their relationships, not mine. And so that's a confidentiality question.
Could be.
Yeah.
I mean, you'd have to have permission from your client to disclose anything they told you.
Yeah.
Anything that a client tells you in the client attorney relationship is confidential. Even stuff you wouldn't think is confidential is confidential. Whatever they say, even good morning, is confidential. Confidential. When they open their mouth in your presence and you are their lawyer, it's confidential.
Yeah.
And so, you just have to keep that in mind. But it's not unusual, which is a little different, that I get asked all the time, "Could you recommend a lawyer to do this particular thing?" And I can do that. But with the State Bar of Georgia, what I typically do is I just give 4 or 5 names instead of just pointing to one particular person, because we don't favor anybody.
Right.
And that's how you want
I think that confidentiality is such an interesting, because I feel like I hold so many people's secrets. And to be fair, recently someone's child reached out to me with a question. And then this person's parent asked me, and I was like, I cannot tell you because I have confidentiality. And that parent got really mad at me. I may or may not be related to that person. And they got really mad at me. And I put me in this terrible situation, and I'm very upset about it.
Yeah.
But that's the problem with the legal rules that we operate under.
Well, I don't know. It's a problem. It's
challenge.
It's what we are.
Yeah.
If a client cannot depend on your confidentiality, then we're good. You might as well just be a paralegal. Just crank out papers. Really, if they can't, because they're not regulated, but we are. And so, you should be able to go to your client, and your client should be able to say, "Yes, I killed that person," and know that you won't go tell anybody about it. Confidentiality is the backbone of what we do. And that's why you really aren't going to find many times where you pierce that. And some lawyers don't care if they're told or not, and they'll sit there, they're not going to tell because they just can't.
Right.
And so that's important.
I want to piggyback on that confidentiality in the paralegal situation. I think this is often overlooked. How many of you are solos and use like a virtual assistant or something, or even have a paralegal that works for you? You need to make sure you have an agreement with them that has a very, very, very tightly worded, strong confidentiality provision, because they are not regulated by the bar, but you are. And what happens if your staff person does something?
It's on you. period. And I would tell you this, and it's fine to have an agreement with your staff, people about confidentiality, but what we're going to expect is for you to have training. And so, you may have somebody that, I've got a paralegal that knows more than I do. I mean, quite frankly, has been doing this longer than I have, at least at the bar. But we still talk about it. And she may even think, why are you talking to me about this for 30 years? I know what I'm doing. But we expect you to have conversations with your staff. Just so they don't forget, keep it fresh in their mind. What we do here is confidential. Whatever you're writing on my license, and my license is important to me. And you need to make sure. And also, it's that whatever we are told by our clients is very important to them. Even something you may think is trivial may not be trivial to them. Like, for instance, their name. So you may not be able to reveal somebody's name. I know one lawyer in a little town called Fitzgerald that had a client that came after hours and parked in the back and came in through a back door because he did not want anybody to know.
Right.
That's the client's choice.
I had a question I really wanted to get to, but I want to follow up on what you just said, 'cause I think this is important, because I run into this a lot in the entertainment sports space, is wanting to use your clients as marketing for your services. Right. And so how would you go about, like, what are the best practices, do you think, for making sure that you're complying with the rules?
There was, I don't know whether anybody does Martindale Hubble, but if you do, there used to be back in the day, and this shows my age, that they would ask for a list of representative clients. And so lawyers would just start going, I represent this bank, I represent this company, and they would try to just put the best sounding ones in there, of course, because that's to attract other people to call them. Question is, did you call that client and say, is it okay? Because if they don't give you permission, you don't get to market off of them. And there's y'all may know about this, as an old guy from Americus, Georgia, where actually I live there and work here during the week. And he was Reverend Pearlie Brown, and they took a picture of him and used him on a album cover without his permission. And ended up in a big lawsuit.
Yeah.
So you can't use somebody's stuff without them telling you it's okay.
So I know that there are firms that have a provision in their engagement agreement that gives them permission to use their people for marketing. But there's one area that you really aren't supposed to. I've done a lot of research on this, Ariel, which is if the scope of what your services are confidential, like you're representing someone in litigation or in some kind of controversy, there's even a higher standard of not disclosing unless you have like very specific permission from your client.
I mean, again, it'd be a lot of things. I mean, it could be that the litigation is so well known throughout the entire country that it's, it may be a little different, but I would, if you're going to do something like that and have hey, look, I can tell people that I've represented you because it's very important, and that's why I would make sure that was a clause they initialed.
That's a good idea.
And then make sure that they have read it and say, you understand what this means. And that, and it may be somebody that's just not, people know who they are, but they're not famous yet. But they're probably headed that direction. Their opinion may change once they, sell that first gold or platinum.
We only have a few minutes left, and I had a very big issue I wanted to bring up, but I think it's too big to do in a few minutes, but can I throw it out?
Sure.
All right. So the fee arrangement. I've had a few members of the section tell me that the bar has looked disfavorably on taking a 5%. So it's standard in the talent industry, and I don't know about sports. So if someone who does sports can tell me, but in the talent side, entertainment is very standard for attorneys to be paid a percentage of either the transactions they work with on for their clients, which is a no-brainer. That falls well within contingency. But then the second is taking 5% of everything the client makes the same way an agent or a business manager would. And so the look at my notes, sorry, y'all.
Rule 1.5 covers fee.
Yes, 1.5 covers fees,
And
but so does, yes, go ahead.
well, I was going to say, what Rule 1.5 says, if you look at it, and it talks about contingency fees, it says that you can have a contingency fee. What it says you can't do is you can't have a contingency fee if it's a divorce. So you can't say, well, I get 50% of whatever I recover for you. Because one of the reasons for that is because some of what you recover may be things that the client doesn't want to have to sell. It may not be money. And then the other one is you can't have a contingency fee on a criminal case. It doesn't mention anything else. And so the rule didn't anticipate this when it was written. So what I would say is if the rule doesn't say it, then I don't think that we really have a way to go forward. If somebody gets a 5%, whatever the agreement is, I haven't read the agreement, I'd have to see it. But if it's something that is, if you're getting different answers from us, if you've called the ethics helpline and somebody has said, no, you can't do that, and somebody has, just like me, said, yeah, I think you can do that, and you're not really sure, then what I would suggest is a section that you write a request to the formal advisory opinion board and say, we want this clarified. And now if they reject you, that just means we think the rule says what it says. But if they go, yeah, I'm not so sure about that, then that's what they're there for. Now, of course, like everything else in the law, they don't do it overnight. It does take a while. But if that's a concern or something that you're having a problem with, the formal advisory opinion board is the way to go with that. But the rule does not say you can't do what you're doing. That sounds more like a business arrangement. But it says in fees, whatever you charge has got to be reasonable for what it is that you did. And so as long as that's reasonable within the industry, it's what the industry does, and no one is complaining about it. And it's just sort of the way it's always been. And it's disclosed and it's explained and everyone is on board with it. Yep. I don't see an issue with it, but this is that point where every one of us is supposed to say, but the advice I'm giving you is an informal opinion of the Office of the General Counsel, and it does not bind anyone in the Office of the General Counsel. what I say, and it certainly does not bind the Supreme Court of Georgia. So that's, but I don't see that as a problem because the rule isn't.
And that was such a great ending. I will say, if you're doing the 5%, you need to make sure it is in writing. It is clearly stated, and you even put a provision, in my opinion, that you recommend that your client get outside counsel to explain it.
Absolutely.
First, we're going to start. I'm going to introduce Stacey Epps, who's a member of our section, an incredible lawyer. She's also an amazing artist. But in her practice as a lawyer, she represents a wide range of musicians, including legacy art, and has a full scope of a broad scope of the practice, whatever I'm falling apart. But Stacey, I'm so excited to hear Brian, it's great to see you, and Sean, it's nice to see you. And Bernie, we have this panel is like chef's kiss. I'm gonna go sit down.
Thank you so much, Nancy. Good afternoon, everyone. So happy to be here with you. This is such an important topic. It's very near and dear to my heart, both as an attorney and as an artist. And I wanted to frame this conversation legally and practically, right? Because it's important to understand the law around things, but it's also very important for us to have a firm knowledge and understanding of the topic in general, right? So I brought together really, really wonderful group of people I'm so excited to have with me. First, I'm going to let them introduce themselves quickly, but I just want to really talk about, the main issues we have that we're dealing with legally. Who owns AI music, right? That's the question. Copyright Office says human authorship is required, but what counts as meaningful human contributions, right? Who knows? These are things we're working through. Second, AI training on copyrighted music, is that fair use? Is that infringement? What do you know, that's what we're going to discuss. Also, what protects your client's voice and identity? These are also questions, right? For your image, your likeness, your voice. All of these are really important things for us to look at and acknowledge. And like I said, we also want to talk about the practical impact of technology as it continues to move forward. Brian, you want to speak on that? This is the intro.
All right. Okay, so one of the things that we were talking about in preparing for this panel is just about how technology, as it has been introduced over the years, has impacted media. And some ways unintentional, in some ways there are things that you can look back on and it might be a bit surprising. So for instance, because we're thinking about AI, look, it is a new technology. How is this new technology going to be used? Obviously the pros and cons of it. Is it creating jobs? Are people losing jobs from it? Well, there's something that was actually I learned about when Sean and I worked together at Sound Exchange. He's still working with Sound Exchange some years ago. With the introduction and ultimate proliferation of the use of vinyl and radio. It may seem counterintuitive, but in the early days of radio and vinyl, artists did not want their music to be played on radio. They didn't want it to be recorded onto discs and then to be played on radio. Seems counterintuitive now because everybody wants radio play. But the thought was at the time that these musicians who made their money from doing live performances would not have the opportunity to continue to make money doing live performances if people could just turn on their radio and hear the music. And so again, it's a kind of an interesting way to think about it. And with respect to some of the other technologies that have been created on the music production side, there was a lot of pushback from the creative community. So for instance, the introduction of the electronic keyboard, it's a pretty significant amount of pushback from the community. That's not real music that you're making with it. We've heard those refrains with other things like sampling as well. I certainly heard that, in my younger days when my dad said that music I was listening to wasn't real music because, it was just a loop of James Brown, but I think it transcended, right? Right. Never gonna last. Right. Exactly. So I think that it's important to think about framing this conversation with the context of how these disruptive technologies may have some unintended consequences or directions or benefits.
Thank you, Brian. So now I just want to introduce our panel. I'll allow everyone to introduce themselves. Many of them you already know. When they do their introduction, I'd also like them just to say like one sentence or something of their feelings on AI. And we will start over here with Bernie Lawrence Watkins, who's an amazing entertainment attorney.
Thank you, Stacy. And I just want to say it's great to be on a panel with you because Stacy started out her career working for me. We worked together for a period of 12 years. So it's just great just to watch you trajectory over the years. Yes, Bernie Lawrence Watkins. I run a entertainment and intellectual property law firm here in Atlanta, Georgia. I've been practicing for 26 years and have been operating this firm for 24 years. And regarding AI, it's here and you better get used to it.
Okay, so we're so blessed to have Dr. Moya here with us. Unfortunately, she couldn't make it in person. She was coming from New York. I know a lot of you heard about that terrible crash on the runway, so that affected her ability to be with us. Dr. Moya, can you give us a brief introduction and your thoughts?
Absolutely. Hi, everyone. Wish I could be there. I represent the Human Artistry Campaign, and we believe that AI can be a tool to help artists, just like synthesizers, just like electronic keyboards, but it cannot be allowed to replace human art because it's just not the same thing.
I think a lot of people's like introductions are gonna like play themselves down, but you know, she's like an astrophysicist, folklorist. She earned her PhD. I'm sorry,
You said we had two
Columbia.
sentences.
I know, but yeah. So and the Human Artistry Campaign is an amazing organization to maintain, artists' relevancy in these days as being human creators. So wanted to add that. Now, Sean Glover, let's see if you play yourself now.
You know, when they say save the best for last, this is not one of those cases. To be clear. No, I'm Sean Glover. I'm an artist in industry relations at Sound Exchange, and we believe that music should be created by humans. However, AI is a tool. My personal belief is I sit in between Bernie and Dr. Moya. You'll understand what I mean once we get into the conversation.
Okay, and you're not last because Brian Calhoun, who we had speak.
Hey, everybody, really excited to be here. My name is Brian Calhoun. I've worked in music business and really with a strong focus on technology for a few decades now. To provide digital strategy to a number of A-list artists. And I also created a book and tools to help independent musicians called Toolbox. I strongly believe that AI is a tool that we will all be able to use, that the artist can use in the creation, but also it's tools for us to use in the business side as well. So we can talk more about both of those.
And my statement on AI is I do use AI, but it terrifies the living shite out of me, excuse me, as an artist. And there have been times when I've literally cried because I just felt like when certain people use it to create things that takes artists hours of blood, sweat, and tears to create in 1 second, it just sometimes makes me sad. So that's just my like human feeling behind it. But just for a quick legal overview of like where we are, one of the biggest cases right now is, how do you say this, Curly? Thaler versus Perlmutter, the Perlmutter case. It went all the way to the Supreme Court, and they declined the review, upholding the district court and DC Circuit Court affirming Copyright Office denial of an AI, 100% AI artwork piece, meaning it has to be, Bernie, you can tap in wherever you want. It cannot be, they will not do a copyright registration for 100% AI work. You have to have some type of human authorship, and we'll get more into this in our panel. There's the UMG versus Suno case, which is currently active. Really looking at whether Suno's training of its AI model on tens of millions of copyrighted sound recordings without a license constitutes mass copyright infringement, or whether it's protected fair use. UMG versus Udio, they actually settled, which is undisclosed how they settled. I don't know if anybody has any insight on that. I don't know. And there is a UMG versus Anthropic lyrics case based on it's also still active. So really like AI training on music right now, we are in such a space of like, we're not sure. Let's see, let's let the courts decide. And the administration just put out a study, a statement on it saying, I think it was on the 20th, just saying it doesn't believe training of AI models constitutes copyright infringement, but acknowledges there are other opinions and supports allowing the courts to make the decision. We also do have a few statutes like the Elvis Act that's in Tennessee that prohibits voice cloning, right? So that's something there.
There's some irony in the naming of that bill.
The
Joking there
There is. There's the California AB 2602. It's no digital replica of an individual's voice or likeness in place of work they would have otherwise performed in person. And unless the contract reasonably provides a specific description of the intended uses of the digital replica and the individual was represented by legal counsel. And then California AB 1836 protects deceased personalities. So anyone who produces or makes available a digital replica of deceased personality's voice or likeness without consent can be liable. Now that really hit me because I know you all were seeing all those AI videos of like Gandhi and the boxing. I'm like, what the? I mean, anyway, but I'm not gonna get too much. And then we have the proposed federal No Fakes Act. I know many of you are probably familiar with that would establish a federal right for every individual to authorize or deny the use of their voice or visual likeness in AI generated digital replicas. And then Sound Exchange, one of the reasons why I asked Sean to be here is they created an AI opt-out registry, which I want to make sure everyone is familiar with so you can also counsel your clients on this. So we'll get into that later. So did you add anything to that, Bernie?
I think you did
Okay.
an excellent job in terms of how you broke it down. Just wanted everyone to know that you talked about the various states and it's state specific. And so there's no universal law as we know it as related to AI. We have the Copyright Act. That is the law that governs how we determine creative works. And there hasn't been a case today that has been significant enough to allow there to be changes in the Copyright Act. So we just have to apply the law as we know it.
I love that you mentioned the No Fakes Act. I also want to mention the TRAIN Act that the Human Artistry Campaign is in support of for transparency, both on the input end of AI, so what data gets used in their training models, and then on the output end, what content was generated using AI. Would help more audience members know how to engage with their material.
Awesome. So one of the main things we're looking at now, because we do know you can't register the copyright for 100% AI work, right? But then we get to the question of what is meaningful human authorship? What is that? Because we have to counsel our clients, right? When they come to us with a work. And so how do we let them know like what this is? How can we advise them? And I want to ask Bernie that first, you know, when somebody comes to you and says, hey, I have this AI art, you know, for instance, Bernie did the deal, and I never say her name right, Zanaya Monet, right? And it was, in my mind, from my knowledge, right, her client wrote the lyrics, and it's an AI artist who actually performed the lyrics. So when I look at that, and I know the copyright only protects the actual human-made elements, right? It creates a question in my mind of saying, well, hey, she wrote the lyrics, so yes, that should be protected as the composition. But what about the performance, the singing, right? Because it's a, you know, that's a bot, or I would call it. So how would you answer that question, and how would that work be protected, and how can you, you know, convey that?
Sure. First, I'd like to start out by saying, defining what a copyright is. It's a creative work of authorship that's placed in a tangible medium of expression. And the Copyright Office is clear on who the author is. The author is defined as a human in the Copyright Act. So when we're looking at the creative works related to a musical composition and a sound recording, we have to assess what the elements are. So a musical composition is made up of the lyrics, the melody, and the music. And on the sound recording side, we're looking at the performance, the arrangement of the music and the music itself. So to Stacy's point, when we're looking at a sound recording, how can someone who is generating AI work claiming the rights to a sound recording? So my response is, you have to understand the elements that we are identifying. So if my client's vocals performance is part of the sound recording, or if my client's work is part of the arrangement of the recording, then we have a claim as it relates to the sound recording. They can't claim rights on the musical composition part if they didn't write any of it, if they didn't create the beat. So you have to understand the rights that are involved there. So when we're talking about significant human input, you have to be very detailed in the description of how you identify your client's services. There are two forms that we're using when we talk about creative works related to music. We have the PA form, which is for the musical composition. Then we have the SR form, which is for the sound recording. And both of the forms are very similar. There's a very small space where you have to identify what the claim of authorship is. You have to be descriptive in that. And it's a very small space. But there's a continuation form that you can use and attach that to the application, which allows you to be very detailed in your description of the services that are being provided as it relates to that work. So, and if you are very creative and you created both the lyrics as well as the music, and you arrange the music, then you have rights on both the musical composition as well as the sound recording side, and then you can just complete everything on an SR form. But again, everything boils down to the detailed documentation of what your client did. So say, for example, if your client is a producer, and well, let's go back to my client Zanaya Monet, because she was one of the first artists to receive a multi-million-dollar deal and also the first to chart on Billboard airplay. And she received a lot of backlash because people at first was saying that she was it was a corporation that generated this work. So we thought it was necessary for her to reveal who she was and have everyone realize this is a young woman coming from humble beginnings who had a talent and was very creative and decided to use Suno in the process. So she is an author as it relates to creating her own lyrics, and she's a poet as well. So that gives her rights on the musical composition side. Now, when she is creating the sound recording, it's important for her to have her voice implemented into the system. So singing into the Suno system, applying her vocals into the system. And now having Suno create around that sound. And we're now also able to remove the stems, have someone produce the tracks. And now we have the sound recording rights from the producer, which is considered a work for hire. And that gives my client the rights to the work.
So I want to add to that, because I feel like it was interesting how you referred to the artist as Zanaya, as your client as Zanaya. So is Zanaya a real human? That lady that wrote it and put her voice in the thing, is she like PKA Zanaya?
She is PKA in her contract. Okay. She's a PKA. Yes.
So she's considered that artist.
Correct.
She does. Okay.
It's the agreements is set up just like any artist who is signing to like it's a typical recording deal.
So I want to bring that around to, I feel like a lot of it is trust, right? It's trust based, right? Because I could essentially, and I'm not saying you would do this, Bernie, but there are other people that aren't so honest all the time, right? And so how do you, and I want to raise this to you, Dr. Moya, as well, and anyone else on the panel, but how do you deal with that when, you know, a client might come to you and say, yeah, I put my voice in there and yeah, I had somebody reproduce it or whatever, and they didn't really do that. And it's really 100% AI. Like there are these situations where it's like, how do you police that? Or how do you figure out, like, is this really what this person is saying? Like there, it feels like it's no check or balance. That's my thing with it.
Do you want me to respond or do you want her to respond?
I want her to respond.
Me? I'm not a legal expert. I don't know what the legal boundaries should be. I'm here as a creativity expert and a lover of art. And from that perspective, Zanaya should just be a songwriter. You know, like I don't understand why we would need to use AI to go outside the bounds of what our skills are without practicing them. If she wants to practice being a singer, she can do that. So like the creative bounds here, I think, are different than what the legal boundaries are. And as long as she's using an AI platform that is trained on her voice and doesn't steal from other artists, then morally it's also okay, as well as legally. From what I understand about Suno, that's not the case. So I am hesitant to call that morally okay, although legally it seems to be fine. I try to put it into those three different buckets. Is it legally okay? Is it morally okay? Is it creatively okay?
Well, we know, I think, just to add in my opinion, there is no legal okay yet. To me, it is just like, obviously, I don't know what you all think, but from what I've seen, it's the wild, wild west right now to me, you know? And so that's, you know, Sean, Bernie,
Yeah,
come on.
well, okay, so let me step
Damn,
back
I wish
here.
you were here, Dr. Moya. I was waiting on this one.
The thing is, when we talk about Suno and any of these large language models that provide existing music, we know the biggest issue is the music in the beginning was not licensed music, right? So, and the way the music is input into the system, there was no way that you can track who actually created it. So that's a problem because who actually gets the rights to, who gets to claim the rights to that work? And when you're using something that's 100% AI, you can't claim any rights to it. But when you can claim your authorship, you can claim rights to your authorship, but you can't claim rights to anything that was generated through the AI system. So that's the difference. You have to identify on that copyright application what actually is AI generated. What assistance did you use in your work, or what tools did you use? And that part you cannot claim as rights to the work.
So if we had a Transparency Act that would make it so that things generated by artificial intelligence algorithms were labeled, then we wouldn't necessarily have to leave it up to the honor system, and people wouldn't just have to write down in these copyright forms what was done with AI if there was a record of it already.
Well, there are systems, there are companies in place now that are generating those systems. So we are in a time where law, rules, regulations, governance, it's all being created. And we are held up to, we don't know. We really just don't know. And for me, I've been pushing the envelope. And it's been, okay, well, tell me why I can't do this. And at this moment, no one has been able to tell me why I couldn't do it. And when we were able to do our deals, at first it took some time for the deals to close because they had to do their due diligence, especially on the publishing side. When we did our publishing admin deal, they had to do their due diligence, and it came back that all the songs were her songs based on whatever system that they use. But there are systems that are in place. Like I know Universal has something that they are developing, and with companies like Suno and Warner partnering, they now have a license model where you have to, if you're going to use their system, you're now licensing the work. So now, there's the 4 C's that we talk about: the credit, compensation, the consent, and control. And my belief is, out of the 4 C's, control is the most important, because that's where the issue lies. Once these AI generated tools are being used in conjunction with the voice, likeness, image, because you could potentially lose control over those matters. So how do we combat that? And, I've been really doing a lot of reading in this space, and this is not just a copyright issue. This is also a trademark issue. And for lawyers who are practicing in the spaces of technology and entertainment and intellectual property, you really have to, when you're representing talent, you have to push the envelope and try to figure out how things can pass muster for your client, because these companies and these agencies really don't know. They're depending on us as lawyers to work through these issues, and based on making a valid argument, that will determine how far the process goes.
Well, I mean, as a fan and a man, I think consent is the number 1 C. But when you think about, I think the legislation was it's sufficient authorship, and I think the word that's going to hang us up is sufficient authorship, human authorship, when it comes to AI works. There was I'm gonna defer to Bernie and Stacey on this one. There was a cartoonist, a guy made a comic book. He wrote the comic book, but he used AI to generate the images. And the courts is like, the words are cool, but that stuff those images are not. But then the case of Randy Travis, the country legend, who, he had a stroke some time ago, and he's using his voice to create new works. And I think you mentioned it, Bernie, on our pre-call, that they're really, or you Stacey, is going on a case-by-case basis. This is like, we're like building an airplane in the air right now. This thing is taking off, and we're like, oh shit, we need a wing. We need a rudder. You know what I mean? This is where we are. Nothing is done illegally yet, but I think, Black and brown people have been disenfranchised by this business for so long. We somewhat joked about the Elvis Act. They didn't even try to get another name for that act, but we should, really, think about, there's assistive AI, which is all, I tell my mother all the time, like, AI has been here. These are for productivity tools. These spell check. I was like, Ma, the world is not ending. That's what I'm gonna tell you. The world is not ending. But 4 Thanksgivings ago is like what I like to call is when the world flipped on its head, when generative AI came out, where you can be able to make something from something that's already here. And to me, that just ain't right, without getting that consent from that person or persons to go forward. Then you can get into the credit, compensation, and control.
Yeah. Oh, go ahead, Bernie.
I was just going to say, I do believe consent is extremely important. I'm just saying, the big issue is control. How do we control what's happening? And we as attorneys have to figure out how we protect our clients, because that is a big issue. Because when I look at these deals that I'm doing now with not just independently, but with the major labels, the major labels have adjusted their contracts to have AI language, and the language is extremely broad. And if you're not paying attention, you can actually give away rights that you didn't mean to give away, because it's, they say the devil's in the details. And when the language is broadly written, that creates a huge problem for you, because when your client's music is being used and they come back to you and they say, why is my song being used with this avatar? And you gave away the rights when you negotiated that deal because you didn't pay close attention to the language, because it's not written where it's saying AI. It's really, really broad.
But I think once you get the consent, that's when you say, this is what we're going to do. This is how long we're going to do it. This is how much I'm going to get paid for.
Well, the thing is, when you're doing, when you agree, when you sign the deal, you're giving consent. That's what I'm saying. So here's an example. All recordings embodying the performances of artists recorded during the term or submitted hereunder from the inception of the recording thereof, and all reproductions derived therefrom, together with all performances embodied thereon and all materials related thereto, and thereby and are hereby exclusively licensed to company throughout the term and the licensing period, free from any claims whatsoever by you, artist, or any other person. Accordingly, company shall have the exclusive right to distribute and commercially use such recordings and materials throughout all distribution channels now known or hereafter devised, including without limitation, streaming and download services, and the rights to monetize user-generated content on all digital media platforms.
Wow.
So that says it right there.
I wouldn't consent to that.
That's almost so the only thing that you added different there was the user generated content. But now, because of AI, we had that original provision in almost every agreement saying, anything derived therefrom, which is no limitation.
Exactly.
Oh my God.
So that's what I'm saying. You have to really pay attention. I mean, there are ways that you can work around that language, but I'm just giving you an example of how broadly written these agreements are today when you're doing these deals. And if you're not paying attention, it's going to be problematic to you and your client down the line.
Also in NIL deals. Same language.
Yep.
Yeah, no. I was also, as we've been talking about this, there are some companies that are, on the input side. Specifically, there's a company called Gen Audio that claims to be ethically trained, where they have full licenses for everything that the model has been trained on. So I think there are definitely people who are out there trying to do the right thing. I think that one of the biggest challenges is going to be, how do you determine what is and what is not? Like, as we're saying, it's like, sort of the honor system right now. And, we're in a world now where there are 1 million new tracks uploaded a week, right? 1 million a week. And a stat that I heard not too long ago was the fact that 30% of that are AI generated tracks. So,
or sometimes, yeah.
Is right.
Yeah.
It's very significant. So it is a problem, not just for creators and consumers, but this is also a really gigantic problem for the DSPs, right? They're having tons of issues with it, especially when things start, are they going to get in trouble for some kind of copyright infringement? I mean, speaking of lawsuits, Universal suing Tune or what their parent company for, I think some $500 million for infringement issues. Could there potentially be some of the 30% of these million tracks where there's some infringement in there? I think that's also part of the case too.
But I don't see these companies really moving in that direction, because when I say these companies, I'm speaking of the major labels, because they are the ones who determine how the industry works, unfortunately. And as you see, you have Suno settling with Warner. And now they have they created a system to have licensed works. So what I believe is, as we are moving through this process, as lawyers, we really have to work hard and diligently in terms of what our plan is to protect our clients. And when you're doing these deals with major labels, per se, who are offering a million plus, they're going to want certain rights. And they're not going to close the deals without certain rights. It's just like when 360 was an issue. You couldn't close a deal without 360 language. And that's what the major labels are doing today. They're not going to close a deal without AI language. But the question is, how do you limit the use of your client's work when they're trying to use it for training purposes? And one of the ways is to make sure that consent is granted, and also limiting the use to third parties, so that whenever they want to license the work outside of the record label, they have to seek permission and you get to opt out.
I want to ask this, and you may have some thoughts on this, Bernie, but assuming that creatives opt in to allow their works to train the models, when a new work is created, is there ever going to be enough revenue for it to be meaningful? Right? So if you have a new work and it's blending the voices of, 10 different singers and 10 different guitar players and 10 different drummers, and all that create one new work, will there ever be enough for it to aggregate to be enough revenue to be meaningful to anyone other than a major label who already has, someone who's got, a giant catalog already?
No, I think that's a valid point, because when you look at the systems of how they are paying out currently, that's an issue. Creators have an issue, right?
Mm-hmm.
When it comes to streaming, because the artists, they're on the lower tier in terms of the payment structure. So the question remains, is it going to be a blanket license, a blanket license model, or is it going to be a model where they're paying out a penny rate? That's yet to be determined.
I actually know someone in the audience, an attorney who is really working on a system for this. Her name is Atira. And she's really digging in on coming up with a system for this, because it's really where we are now. And everyone is just like, we need a licensing model. We need to figure out this licensing model. Do you want to say something real quick about it?
Okay, sure. Hi guys, I'm Tara.
Putting her on the spot, but it came up.
I'll explain it real quick because I'm actually interested to know how I feel about it. So I essentially took the copyright rule about covers, the compulsory license that we have for covers, and I applied the logic to AI generative outputs, essentially. And then I built out a framework using that as the basis. It started out as legislation, but as we know, you already know what's happening. They don't want to do anything. So I pivoted it to an architecture or a voluntarily implemented protocol, essentially. And it can plug into the already existing distribution systems. It just funnels the money differently depending on what AI model is used. And I created a scale, it's called the AI sampling spectrum scale, that determines how much used, like what was used and how much is used. And I also created a scale that determines essentially like what is the model, what kind of model was used, and it labels the human interaction with the output and the AI interaction with the output. And depending on
what percentage you get from that equation that I created will determine how much you get paid or where the royalty is routed, essentially. To your question about whether that fractionalization will create a amount of money that is more than negligible, my framework kind of addresses that. It's called the minimum monetization threshold, which essentially just says before you reach this limit, we don't even care, how you use it or what was used. Once you reach this limit, whether it's $100, $1,000, whatever the amount is, an appreciable amount of money, then we apply this standard, we retroactively detect, or we go back to what you told us voluntarily, and then it flows through in that way. I'm still troubleshooting it, but I essentially worked through most of those issues already.
Yeah. And that's really the type of thinking, I think, as attorneys. Like, I just love what Atira is doing, because it's really showing us, okay, we can really involve ourselves at this time and really become leaders in this space, and not just, well, what's going on now, and like super reactive to what's, because before you know it, we go to sleep, we wake up, and it ain't no more real artists, and I'm gonna be crying, and I'm like, and that, I mean, and it's so much, I think it's so much trust involved. And like Dr. Moya, like you were saying, and we were talking about the Train Act and the black box. We all know historically the black box was, that amount of money that was unclaimed in the music business that goes back to the major labels, when we all know that it's mostly independent artists who aren't claiming their money. But that's a whole nother topic I'll get into. But they're using that. I don't know why they're using that same term now with AI.
I think we might have originated it, maybe, in the sciences.
The scientists. Okay, that's it.
In computer science, a black box is an algorithm that you don't necessarily understand what's happening within it. So you understand the input and you see the output, but you don't know the middle parts.
So can you explain that in reference to the generative AI and the training? Like, because like we're saying, it's all based on trust. So how do we know, what's going in? And, because you say, oh, well, this person should get credit, like, let's just, for instance, say Victoria Monet, right? With Janaya Monet. I'm not just saying that. Look at her. But I just say it, right? So at what point, how can we say, like, oh, what percentage? It was like 1% Victoria Monet in there, or whatever, Brandy or Monica.
Yeah, that's almost impossible to say. It doesn't mean you can't keep track of it. The AI companies can absolutely keep track of the inputs that they have for the training algorithms and the values of the interlocking nodes in the middle. Like, we understand roughly how the black box works. There's a sequence of calculations based on likelihood. You generate a sample, you figure out how closely that sample matches the real data, and that gives you a likelihood value. And you do that many, many times until the likelihood value increases, so the generated sample looks like the input sample, or whatever your goal is. And some of these black box algorithms have 1,000 layers of nodes that they pass through before they get to the output end. And so it's almost impossible to say, like, this is 2% Victoria Monet, but you can say that that was a node in the black box. You can say that that was a piece of data that was used in training. So we can absolutely track that. The percentage is difficult.
Mm-hmm. Mm-hmm.
Okay. One thing, Atira, and that is amazing, by the way. Just want to tell you, we'll talk after. But at Sound Exchange, Brian and I, we worked there for many years, and we're kind of, Sound Exchange was born because of a piece of technology being created, which is digital streaming. We are almost at the same crossroad now. It started, before there was a sound recording, wax. Artists went to the radio and played. Then a piece of technology came out. Then it went from wax to 8-track to tape to CD to streaming to here we are again. Technology has never been stopped throughout history, and nor will it. But when the digital streaming laws were created, there were a lot of conversations like this. Ultimately, there was Congress did their job and said this new form of music is subject to royalties, and we're going to pay them out. Here it is. But there was one omission now that we get to look back, because history is here for us to learn from it, not repeat it. And it was, there were no artists at the table when these laws were being created. So they came up with this hero to solve, because artists like, oh man, they're stealing LimeWire, Grokster, all the things, they're stealing my music. What are we gonna do? Same vibe we have now. They say, hey, we got it. We got iTunes. It's a place you don't want all those viruses on your computer. We got this. We're gonna make a place where you can, get your music. And then Spotify, all the other things came up out of that. But artists weren't at the table. So this good guy, which is really a villain, was born. But I really implore you all to get your clients to be more involved with this process, because I don't know how many artists in the audience. I know a few. And that's the one thing about Stacy. She's an attorney, she's a manager and an artist. She's one of those rare cases that checks all the boxes. But artists like Dr. Moya and Stacy and anyone, you all need to be at the table so they can hear from you to understand what you all want to see happen and understand how your life works. Because otherwise you're going to have somebody in Congress making decisions on how you should be compensated, if any.
But also I want to address that now we're stepping into an era where people who are not generally creative, all right? Anybody now, if you're a teacher, you're a lawyer, you're a doctor, and you want to create music, you have that opportunity. I don't see that as being an issue. I see as AI is broadening the horizons in terms of the creativity levels.
How does it help someone be more creative?
Because if, for example, what is her name? Kalani? Yes. She was really out there going against my client, saying she's not an artist or whatever. And if she wanted to create or she wanted to write music, why not just shop it to an artist? But as we know, as entertainment lawyers, it doesn't work that way. Those doors are not open to just anybody. You have to have relationships. And if you don't have the right relationships, you're not getting through the door. So with her, she used her platform through social media and created a following. And now on Instagram, she has like over close to 300,000 followers who have bought into her avatar. And they love her songs. And I'm a huge fan of her songs. I think the songs are great. And so again, this was someone who otherwise would not have been able to make money trying to get a record deal, because again, those doors are not open to everybody.
Right. But I want to add to that real quick. I think there are enough artists, real life artists, that work their entire lives and not even enough platform for those artists and enough money and attention. And I feel like the AI artists are taking away money and attention, especially when people don't even know that it's not even a real artist. I've had people share songs to me like, oh, look at this new artist, and it's not even a real person, and they have no idea. And so for me, it's a problem because we were already saturated with a lot of
what?
music
I
and art.
think though, no, you're right. I think though, I kind of agree and disagree with Bernie, because I think they need their own lane though. I think that's some hobbyist shit. You know what I mean? Let them have their thing, because we live in this world, right? We have fast food, we have fast fashion. We have everything is, you can get a car in a second, DoorDash, everything is on demand. I think though, I'm hopeful in the sense of just like we have, we can go to Burger King, get some fast food. Might taste good going in, but that output ain't good. You can't live off that shit. But you're gonna have something like, Whole Foods was born, and them apples are like $10 an apple. You know what I mean? So there's gonna be some people go the whole other way. In the labeling Stacey's talking about, there's gonna be something that says organic. This is real, but there's no labeling right now. I'm not mad at Zanai. Do your thing over there.
Yeah, but I understand how you feel.
No.
This is not an industry about feelings. This is a business. And
It's
it's a
art.
business.
Of course,
how
it's an industry
it's
about
a business
feeling.
mixed with art. And regardless of how you feel about it, you're gonna have to get used to it because that's where we are, honey.
Yeah, I know. I'm saying they can have their business. They can be over there. You can. It's a whole ecosystem for the artificial flavoring.
Yes,
People love that.
But look, like I said, the major leagues are the major players like Universal, Sony, and Warner, and they are determining how we move forward. That's what they're doing, and they're now saying it's okay. So I don't believe that these lawsuits are going to result in a final decision. They're going to work it out, and we will never know what would have happened. It's going to be a system where they work out a deal, and there's going to be a compensation model that's worked out. And I believe there will be a chart system for AI artists. There's actually one now, but it's not connected to Billboard. It's a Billboard acquire. It acknowledges AI artists. But I believe Billboard will eventually do that because they are very interested in what's happening in the AI space. I'll tell you that.
So the one thing I want to say is I'm never going to look at a major label to tell me what's right or what's wrong. I actually came into the music industry. I was like, I don't agree with anything they've done and all the exploitation they've done of artists over history. So I think it's like Sean is saying, it's going to create different lanes of artists, different lanes of advocates that are willing to do certain things and not willing to do certain things. Because for me, the reason I became an entertainment attorney is because of my love for the art, number one, and my love for the human beings that I've seen put their life on the line, blood, sweat, and tears to create this music. And that's just my soapbox, and that's kind of where I'm at.
It's gonna be space for both of you. It's gonna be
space for everybody.
I'm here for the same reason, but I'm here to represent anybody who believes that they have a creative bone in their body and that they want to do something with it. So that's what I'm here. And I'm here to advise them on the law and how to do it properly.
That's right. So we need to open for questions too, because we only have like 3 minutes. And Yolanda, you have a question?
Thank you. So Bernie, I understand, not that I necessarily agree or disagree, I'm like Sean, I'm in the middle. And you're saying that there needs to be a space for those who the barrier entry has been denied. What you described from your AI client, based on there's a person behind it that's creating, that writes these lyrics. I think you said she works with a producer. My first question is, I don't know where the AI part come in beyond the resource, because if she's actually writing lyrics and she's working with the producer, just because at some point she used Sonos, where does AI come in? Because to me, that's not running afoul of the copyright law, even though she may be using some resources to bring it all together. But from what you described, we have a songwriter who limited resources couldn't break through, who's just using an avatar, but she's also at some point working with producers. So that is my first question. My second question is, and to Stacey's point, everybody's point, there has always been a barrier to entry, right or wrong. And again, if we're talking about people who have otherwise been denied, but they are using their own creative gifts, again, what is the issue? Some people are going to always be pushed out. Some people are going to be let in. It's never been, I'm not saying that it's fair, but what are we doing to address that? Because to Stacey's point, there are legitimate artists out there, however we're describing them, whether they're film, script writers, songwriters, whatever it is, who have been pushing through and with their own creative talents. And now they are pressing a button. And this is not like spell check or grammar check, who somebody can create a 250-page book, you know, in 5 minutes, as opposed to somebody who took 3 years to write a real novel. To me, fair or not, yeah, maybe an issue, but there should be a delineation.
Correct.
So, but
yeah. So to your point, so in the beginning, I'm not sure exactly what was being done creatively, but when I stepped in as the lawyer, I'm like, this is how we work through these issues. And I'm saying, as lawyers, that's what we need to do when we are representing talent in the AI space. You come in with a track that's 100 produced AI, you can't register that work. And some companies don't want to touch it. But let me tell you how we can move through that.
So
and resolve that issue.
So if your client is writing lyrics and she's working with a producer, and if the only thing that's hidden is her face, which is not hidden now, how is that AI?
because the music is generated by Suno. So remember, a producer is someone who handles the arrangement of the work. So you when you're using Suno, you're having Suno to build around your input.
It's the vocals you want.
So
Adding a female voice.
yes, so you have to understand how you have to understand how these
Not a sound recording.
you have to understand how these LLMs work.
Right. So we have an underlying composition that is not an issue, but it's a sound recording part of it.
Right.
Yes,
We're gonna take
exactly.
it out.
Take one sound recording, the actual arrangement.
I'm wondering for all of you, does this not just kind of like bring it back to the point that like artists, songwriters, all artists, but in particular songwriters should have like access to know their rights and to know what, like they should be able to walk into a studio, honestly, any studio, and say, hey, I have this song that I've written. Would anyone like to sing it, sell it, and know that their rights are going to be protected if that song pops, so that they can get their distribution, they can get whatever like the rights that they've negotiated or had negotiated on their behalf, and they don't have to turn to things like AI in order to be able to turn a profit on their songwriting. Doesn't that like kind of just feed into like the underlying issue of people being taken advantage of?
Well, not necessarily. The thing is this: generative AI has developed a system to move forward in the creative space quickly and efficiently. And unfortunately, that's the space that we live in today, how we can do things rather very fast. So when, for example, with an AI artist, in terms of the songs, we're looking at product commitment, it may be 50 songs that they have to do in a term, in that term, right? Which is unheard of for a traditional artist, or we're talking about 12 to 15 songs. So you see what I'm saying? And you just have to understand how to work in the various spaces related to AI and the traditional artists. Now, I believe that the AI space is not going to necessarily remove creative artists, but just create an opportunity and a lane for people to move forward who generally did not have that opportunity to begin with. And it's also going to create additional jobs in terms of creative agents. And how do we use that to benefit ourselves?
Yeah, I would just add to that, because I think a lot of the conversation around AI is about it, taking jobs. But there can be instances where they are job creators. I'll just give you an example there's an artist, Neon Oni, which is an AI artist, started making, the rounds and started gaining some traction and some popularity, kind of got outed as being this AI artist. The the person who, put in the inputs or whatever, uploaded the music, ultimately went and hired musicians and to play the music, and they're touring. So these real musicians that are now playing music that was created using one of these AI digital audio workstations.
And that raises the question to me of like, okay, then if the AI made the music and they're just performing it, no one owns a copyright and that's public domain.
I don't know about that part of it.
I mean,
yeah. Potentially, I don't know how much. Yeah, for sure, it's a question.
Right. I mean, if Suno created the music, that's public domain, right? So, I mean, Suno has various tiers, right? You have the free tier, you have the premium tier. With the premium tier allows you to move about in a different way in terms of actually removing the stems and manipulating the work.
So that goes to advising your client, right?
Exactly.
About paying attention to the terms of service more than anything with any of these, platforms that they're using, like Suno, because if they're just, I'm just using this for free, right?
Correct. Exactly.
I'll just say this one part to the young lady. I know we overtime, but hip hop. Oh, one more. Hip hop has a very complicated. We talked about on our call stance with this issue, because, and I'm a hip hop baby, but hip hop took two turntables that went clockwise and say, no, I'm gonna do something else with this. I'm gonna make something else out of this. You know, they took a cardboard and say, yo, this is the dance floor now. Okay, and we took cans of spray paint and say, no, this is a mural. So we remixed, you know, we get into the sampling, you know, issue that Bernie and Stacy brought up earlier. It is not, that's why I said I'm in the middle. It is not as easy as we think this issue is. But again, legislation will have to figure this out.
And I said, why not push the envelope? As attorneys, why not? We're at a point where it's open. Just push the envelope. Just let's see what happens. We just don't know. Let's see what happens. We have the law. How do we use the law to our benefit? Isn't that what we do when we enter into a court and we are arguing a case? We are using the law to our benefit. So the same thing here.
One more question.
No, and we need the precedent.
Yes, I just wanted to ask for each of your opinions on ways. Well, I preface it by saying this. So when Napster and stuff first came out, the industry tried to reject it and they wound up losing out. It versus if they would have been on the forefront of it and worked out, the deals could have been a lot better for the major companies as well as the artists. So with that in mind, what are things that we can do as attorneys or creatives to be on the forefront of AI instead of trying to fight it so much and lose out?
Bernie's doing that.
But each of your opinions on things that practically we can do to be be in a better position with the technology.
All right,
Dr. Moya, that's a great last question.
You want to go first? We have like.
Yeah. Respectfully, I disagree with the premise of the question. I don't think there's any generative AI that everyone should be using. You can use it if you choose to, but even from a business side of things, because this is a business, we know that 97% of people can't tell the difference between music generated by AI and real music made by humans. However, we do know that the majority of people, after they hear a song and are told that it was generated by AI, they like the song less. So I think that that's useful going forward.
Metadata.
Yeah,
metadata.
and how we can fix this maybe with metadata.
Yeah, I mean,
we have to do like a whole day.
That's something we should talk about, because like the amount of information that would need to be recorded, you know, and ultimately parsed out for compensation it's going to be enormous. And also the point about the thresholds for payments, we've already seen moves that like Spotify has made that said, if you have 1,000 streams or less, we're just not paying you. We're just not paying you. Right. Even in the aggregate. DNA. Right. So, yeah.
No, that song DNA is, I mean, just on a side note, it's terrifying. I sound like a fearful person up here. So I don't mean to. But
does she think you're going to be able to prevent it from happening? Like
you're not going to be able to prevent it.
So you got to figure out a way to be in a better position with it.
Let me address that. I would say as attorneys, we need to consider the whole aspect of governance, right? So we need governance in terms of how we move forward properly and ethically, because that's a huge issue and concern in this space. So when we're working with our clients, when we're working with companies that are creating these AI platforms, we have to, as attorneys, help institute policies and procedures so they can move forward in a place where there's consent, there's credit, there's compensation, and how do we properly move forward with the whole governance of this thing that we call AI?
In the least ethical business that you can know of, which is the music business. That's what I'm saying.
Entertainment, not just music.
Entertainment in general. Thank you. Wow,
and that's why we're in this business, right?
Lawsuits.
Just fix it by.
Because it needs precedent. I mean,
yeah, but it all goes back to the Copyright Act, right? So everything goes back to the Copyright Act. Again, we have a governing act. Follow it and figure out how it best works with your clients. Yeah, I know. So that's what I'm saying. There is law. There isn't anything that's happened that causes the Copyright Act to change. There's nothing at this moment, at this juncture. And I don't believe that's going to happen. everything relates back to the Copyright Act. So let's use it to our benefit to help advise our clients properly. And if you are representing an AI client and you have some questions or concerns, feel free to give me a call.
I'll let you go. You got 10 more questions.
One more question. But Sean says, you want to say it? Tell them. Tell your clients to do what?
Oh, to opt out of the registry.
Opt out of that registry
when
if
it's
they
done.
don't agree with it through Sound Exchange.
We're sorry, I saw you back there. You look like you was bringing in a plane. You like,
What I was gonna say is,
We have one more question.
oh man.
Let's go.
This issue, the labels are getting paid on both sides, so they cut deals, right?
Damn it.
I ran into one of the top lawyers at Universal back in the summer before the deals were announced that they cut. I said, "What are you guys doing?" And he said, "We're making deals this time." And I said, "Wow," because the last time y'all were suing college students.
Right.
So then it came out later that they had settled the case and cut these deals, and now Warner's in negotiation to cut. So they're cutting deals.
Cutting deals.
How is Universal trying to sign my AI artist and suing Suno, who made her song at the same time? It's being resolved. It's being resolved.
Yeah,
the
the whole purpose of suing is to put a halt to, or bring awareness and put a halt to it and say, let's work this out. We're gonna sue you for billions of dollars and we're gonna bring you to your knees to make you make a deal.
And so what's
That's what we do when we sue, right?
what Donald has said, although the labels obviously are going to eat more, what these deals are also creating is an income stream for the artist. So when we're talking about consent, they are seeking consent from artists to use the voices as the direction for what Bernie's client or someone else will use to create it, and then there will be income that will go down to the artist if they opt in to have their voice used as, or a producer used as, typically voices of the producers use also as, the starting point for it. So it won't be as one-sided. The revenue breakdown is leaning more towards where it's going to hit those creators, but obviously on the company side, it will not pay the actual people who are using AI. So the people out there using AI, it won't give any income to them.
Correct. Exactly.
Thank you all so much. We need to do a whole day on that.
So good afternoon. That was a very spirited debate. That's going to be kind of tough to follow.
Yeah.
But as my boss, well, first of all, I'm Chelsea Mitchell. I'm a senior associate attorney at Carter Woodard, a sports and entertainment law firm based here in Atlanta. Very excited to be here with these esteemed panelists. And as Brianna mentioned, we're going to walk through a discussion about music distribution deals in 2026. A lot has changed, as my boss Donald mentioned in the back. Labels are entering deals that they never entered before. Artists are choosing to move differently within this space. And so we're going to talk about how the deals are evolving. And we're going to break this down very foundational, I think, just so that you all can get a better understanding of the difference between distribution deals and frontline deals. I'm going to have my panelists tell a little bit about themselves, and then we'll dive into the discussion.
Thanks, Chelsea. John C. I'm a entertainment lawyer here in town. I've had my practice for about 16 years, which is absolutely crazy. I'm the past chair of the section, and very pleased to not have to be one of those planning it anymore, although happy to participate as a panelist. I also have a background as an artist, played in touring bands, was a music writer and a tour manager, and that's the whole reason why I went back to law school, was to practice entertainment law, and very fortunate to have an entertainment law practice. And that's, all we do. It's probably 80% music, some film work, and other odds and ends in the entertainment industry.
And although John is no longer the chair, he still plans these things, as he actually came up with the idea for this panel. So I just want to shout him out. We got a good discussion to go.
Hi, everyone. I'm Arielle Brooks. I'm an entertainment attorney here in Atlanta, Georgia. I practice entertainment, intellectual property, and business law. I'm sure most of you also practice the same because they all kind of fall under entertainment. Some of the artists that our firm represents are Sexy Red, NBA Youngboy, Kevin Gates, Boston Richie, list goes on, as well as producers, songwriters, people in film and television. So everything that has to do with entertainment, we pretty much cover it. Yeah, thank you all for having me.
Thanks, guys. I'm Matt Buser. I'm an entertainment attorney. I'm born and raised in Atlanta, but I'm based in Miami. I have a talent representation firm primarily, largely based in the music industry, but also a little bit in film and TV, fashion, fine art, creator counseling as well. We handle corporate structuring and governance, any kind of contracts, and we do a lot of federal trademark work. And my father, fun fact, is in the audience. He is a commercial real estate attorney. He's never seen me speak, and he just surprised me here today.
Sure, entertainment lawyer, maybe.
Yeah,
Yes,
I
look at
send him
us.
some business.
Bringing families together. I love it.
That's what we're all about.
Yes, we are. And thank you, Matt, for braving the airport world this morning or yesterday to get
Yeah.
here with us. We appreciate
Wish me
it.
luck today.
Yes, pray for Matt if you do that. Yeah, because he's got to go through the Atlanta
We've got pins
airport this
available.
evening.
Pray for Matt.
Yeah.
But yes, so as I mentioned, if you're working this space or even if you're adjacent to this space, you probably noticed that there's been a shift in the types of deals we're seeing, from major record label deals to distribution deals becoming more popular. And so our panelists today are going to kind of walk us through why that's happening, what they see happening, and what those deals even are. So we'll start off with the foundation. And I'm going to have Ariel start us off, ladies first. Ariel, can you tell us, what is a distribution deal in practice? What does that mean?
Nothing about AI, okay?
No AI, but some AI artists might enter into distribution deals.
Very
So,
true.
you know.
We have one.
But, yeah.
So a distribution deal is an agreement where an artist enters into a deal with the distribution company for the distribution of their music, so for distribution services in exchange for a fee or percentage. Distribution agreements are where they license their music as opposed to granting ownership. In licensing their music, they may license that music for a certain period of time, which with distribution deals, it can be a shorter period of time. So that time frame may be 3 to 7 years. Of course, it'll vary based on the artist, their current stature when they're entering into the agreement, but it's typically shorter than what may be for a frontline deal or a traditional deal. In distribution deals, they're also shorter terms. So the term will be maybe 4 to 6 months from when the artist releases their commercial release. So as an example, if an artist releases their project or their music in 3 months after entering into the deal, then they have 3 to 6 months after that for that term to last. Another thing with distribution deals is that they are typically less burdensome or less deliverables that you have to deliver to a distribution company. So some may be 2 projects, some may be for a few records, and some may also be based on the amount of records that you deliver. So as an example for that, you may deliver 24 records in any configuration as opposed to 2 full projects that are 15 songs or however many odd songs. That is also a difference with recording agreements because they are typically more delivery heavy as opposed to distribution deals, which are less cumbersome on artists. As far as the financials, sometimes distribution deals will offer an advance, sometimes they won't. A simple distribution deal will not have an advance. It'll just have a royalty split in exchange for the services of simply distributing the music. Others may offer an advance and may offer nothing else. So there wouldn't be any money for marketing, touring, or anything of that nature. Other distribution deals may offer marketing in lieu of an advance. So again, it's all going to depend on the company. It's going to depend on the artist and their current stature at the time of negotiating the deal, and also you as the attorneys and what you can negotiate. Do you want me to continue? This is a lot.
No, I'm like, you answered all my questions. Thank you for reading the paper.
I think we're done
That's
here.
a lot to say.
Yeah, no, we're going to continue discussion as we go, but I think you laid a great foundation for what a distribution deal is fundamentally. So Matt, I'm going to have you lay the foundation for what the frontline deals are and what those look like.
Cool. Yeah. So frontline deal, and I'll caveat by saying that these deals are blurring these days, and they look very similar, especially if you have an artist with leverage or a particular record that has a lot of data to support it. But I'm going to talk about the traditional model, and it's pretty much the opposite of what Ariel just spoke about. And so it's a longer term, it's a longer product commitment. There's more of an exclusivity piece involved with it. The traditional deals had no licensing, so it would be an assignment of copyright ownership over to the record label. The record label would also contribute different levels of funding in various buckets, and those buckets would be marketing, recording, tour support, perhaps in-pocket advances, legal fees. And now you're able to get a lot of these in distribution deals as well these days, but the traditional model almost for sure provided for all of these different buckets of money. In exchange for that money, there's always a give and take, right? So the traditional record deal had a much smaller royalty. Like the distribution deals that Ariel was just speaking about are a profit share typically, and it's going to be 50-50 or more in the artist's favor, as opposed to a traditional frontline record deal that was oftentimes an 18 to 20% royalty, and that's if you had leverage. And probably 10, 15 years ago, those royalties were even lower, 12, 14, 16%. And, you can get royalty bumps for gold and platinum status or now streaming equivalents, but the baseline royalty was a lot lower than what we would see in distribution deals. The labels also would participate in more of the financials from the artist side of things than in a traditional distribution deal. And what I mean by that is, like, if they're contributing money for tour support, then they may participate in the touring income or other live performance income or brand income. We call those provisions ancillary rights or brand rights or non-record related royalty rights. And so that's kind of the overall structure. You would say traditionally that it was more money, less of a royalty, more control by the label. But again, to caveat, as we do record deals these days, where it's not so much shopping the artist around, it's more about receiving incoming calls when we have a hot artist or a record that's moving, then we have leverage to negotiate these, and they don't really look like that anymore.
Thank you, Matt. So before we move on, I'm just going to ask you all a question. Make sure y'all are following us. Does everybody understand this? Anybody confused?
Should we get in a fight?
Yeah. Yeah, because we don't have anything to really argue about. Well, maybe we might, but just want to make sure you all are picking up what we're putting down before we move on, because I know it can get kind of complicated. Looks like we're good. So, John, excuse me, can you tell us how you go about advising clients in choosing between these different paths? Like, how do you know what fits your client the best?
Yeah, sure. It's a conversation we have to have all the time. Labels will ask, is your client looking for distro or, frontline? And a lot of times that means we have to spend, hours kind of educating our clients on those differences. Sometimes they kind of come in with some, preconceived notions. Sometimes they feel like distro is the way to go. I want something short term, but then they also want a lot of money. And so you kind of, hear more about what they want. Are they really prioritizing money, splits, short license term, and then also kind of figure out who's on their team. Do they have a good manager? Is it maybe just like their friend that they grew up with who doesn't maybe know the industry? Do they have any infrastructure? Do they know that their songs have to be cleared? Because distribution deals, that's on you. You've really got to be set up to clear the music. You're really driving the marketing plan. You're maybe still spending money, to have some marketing done, videos, and some clients aren't really, set up for that. And what I have seen is that, as they do bleed. They've sort of come to a point where they've kind of crossed over, where I've seen some distribution deals that seem like they're really frontline deals, and they may look short term, but there's a long exclusivity tail, sometimes a 12-month period where you can't release any other music except through your distributor. Other times there's super long license period, and it's still not that much money. And so sometimes someone may think that they're getting something good. Oh, it's all good. I got a short term, distribution deal. But when you start going through the terms, it's actually not a very short term, and you get no support. It's sometimes almost like just you going through DistroKid and you may be getting $30,000 up front, but you're also now only getting like 70 percent versus like 92 or even 100%, depending on what your actual plan is. So we really walk them through that. And I guess what that means for them, sometimes 2 distribution deals have match periods. And that's really valuable to these distribution companies. And, sometimes that's really what they're buying is they're basically locking you in so that if your music takes off because of all the work that you're putting into it, because they're, I guess, not really helping you, then they have the first right to kind of lock you in and keep you in the system. And then also at that point, they're in a much better position to hold you in to that system because they often have your whole catalog. Like sometimes they'll want, if you have 18 albums out, they'll bring all that into it, right? And that then stays with them for 7 years, 10 years, and you can't leverage that catalog. So it actually really hamstrings you. Versus Frontline, which is, it can be a, I guess, scarier commitment. It is longer term. You typically lower royalty split. It is more money, but you're also getting some label services. So, at the same time, you've got to pick the best partner for you. And there are some distribution companies who they actually will provide some services for you. And there are some things that they will do to help, grow the pie. And then there are some distribution companies, particularly the ones that are run through major labels where they literally can't provide any services, because if they provide any services, then it kind of takes away from the artist who have signed the Frontline deals. And so you're really getting nothing. So sorry, that's a super long-winded answer, but you really have to have long conversations to figure out what it is that they want. And then you look at what leverage do we have, and you try to get the best terms possible.
Thank you. That was a great answer. And you mentioned a couple of things that are going to lead into the next couple of questions I wanted to ask you all anyways. And one of those is money. You mentioned they come, they want money. They all want money. We all want money. And so how do you help them think through the trade-off between getting that large amount of money maybe up front versus having their long-term ownership? Do you all tend to lean one way or the other? But how would you help a client understand that trade-off?
I can go. I think copyright ownership is always crucial. So for me, that's not much of a conversation with my clients. It's that, hey, we're going to push to own these copyrights. I mentioned the blurring. That, as John pointed out, that blurring can actually go the opposite way, in a negative way. And some of these distribution companies are offering perpetual licenses. So at that point, you may own the asset, but then you can't really sell it, or the value is diminished because it's now a passive asset. You can't move it. So any buyer is stuck in your deal as well. So that blurring happens. The way that I value deals with my clients is I work them backwards. I say, how long do you want to be in this deal? And what kind of product are you willing to provide? Because then I can start building out the recording budget that we need. I say, okay, you want to give them 10 records. All right, well, how much does it cost? Do you have a go-to producer? How much does your studio time cost? How much is your mix engineer? And then I start working backwards. Then I can guesstimate what we need to spend on music videos and marketing materials to build out the marketing budget. And then I start asking about what they need in their pocket to survive and focus to deliver. That's kind of how I work backwards to value any kind of deal.
Great advice. Feedback.
I'll kind of piggyback on what both John and Matt said. It really depends on the artists themselves, where they are personally and where they are professionally. If they are in a place where they're about to be evicted, or they just had a kid or they're on dire straits and they're doing well musically, but not personally, a lot of times they're going to want that money. And so it's up to you to figure out how to best make that situation work for your client who is actually in need of this money. It also matters whether they have a team behind them. If they don't have a team behind them and they are doing well, or they can do much better if they had a team, sometimes it makes sense for them to take these frontline deals and figure out the ownership aspect. Of course, ideally is licensing, but figuring that frontline deal out so that they can have a team behind them to help them to get to the next level of their career. Having a frontline deal versus a distribution deal typically means having a foundation. You have A&Rs, you have a marketing team, you have creative, you have admin, you have everything to work on each aspect of your career versus you having to do that yourself, especially if you don't have a manager who can assist you in getting each aspect of your career kind of started. It's important to take a look at that for your client and know, okay, this is what you need right now, and this is where you are. So it makes sense to put you in this position and figure out how to make it work.
Yes, we are counselors too. So thank you for highlighting that. I also kind of wanted to talk about who's really taking the risk in each of these deals. Is it both parties taking risks with each other? How do you see them? And I guess we'll go back to you, John.
Yeah. So, I mean, any deal is going to be a trade-off, right? Like I mean, absent just extreme leverage, you're never going to get every little thing that you want. And one thing I spend time talking about with my clients is, I mean, every deal point impacts every other deal point, particularly the money, because that speaks to whatever the risk is that the label's taken on or the distribution company. The more money, the more risk. And so they may want to add something in, you lower royalty, you longer license period. Even distribution companies have internal models, and they've got to stay within certain parameters, that are based on their projections early on. And so it's our job to kind of push those limits to, get the most money and the shortest license term, which kind of goes back to talking to the client and seeing what it is that, that they want. And there's really no shame in, wanting a lot of money. I mean, we work for them really. And you often kind of have to put yourself in someone's shoes where, I mean, $30,000, I would love to have it. It's not going to totally change my life, but it may change someone else's life or at least help get them through something, as long as they, understand the risk. And, we have clients too who kind of hear things, right? Like, well, you always want to do distribution, or you never sell you master rights, which, I always fight there. But at the same time, how much money, if you have 10,000 streams per track and someone's offering $1 billion, maybe sell the masters. I don't know. So it just really depends on your priorities and then your reality on the ground, like what's really coming in and what do you need right now.
Yeah, I know we have to do a lot of, setting people straight and helping them to understand what their priorities should be. Well, first of all, do either one of you want to chime in on that?
Yeah, there's also a line of we want to negotiate the best for our clients and get our clients the best deal. And I think part of that is also considering the label side of the distribution side, making sure that they're not feeling like they got into a raw deal. Because I think there is some level of human nature that comes into play with these companies, even though they're major corporations and are sometimes painted as the villain against the talent. But at times, you may negotiate a deal so well, actually, that the company is disenchanted or a little bit unmotivated. And if you don't have a hit right out the gate after you've negotiated a multi-million-dollar deal and your client's deep in the hole, the A&R team starts to see that, the business affairs team starts to see that, and it has effects. And so you want to be cautious about that and make sure that your client knows, hey, I can keep pushing, but there is a level at which people will start to get turned off by that.
That's a great point.
Yes, I feel like most of what we do as attorneys is helping our clients understand things, managing their expectations. And that's the next thing I want to ask about. I feel like we could have a whole hour-long session on how to manage client expectations. But as it relates to these deals, how do you all, depending on the type of deal you encourage your client to enter, how do you manage their expectations surrounding what the label or the distributor is actually going to do for them? Do you find that they expect one thing and get something totally different, or, what does that look like?
So artists are always going to expect one thing, and not necessarily be able to get that. And that's okay. We are kind of the mediator to put them in a place of reality. They are going to always want $1 million. They're going to always feel like they deserve $1 million plus. However, that may not always be the case. So what I like to do is just be as transparent as possible. If we are negotiating a deal with just one company, then the odds are you don't have as much leverage as you may think, because there's not as many labels that are knocking at the door. However, depending on where the artist is, we can still negotiate something close to what they're looking for. But if it's not going to be $1 million that they're asking, then it's up to us as their attorneys to put it in perspective to them and try to negotiate other aspects of the deal that can kind of align with the more that they're asking for.
Yeah. So the other thing too is that frontline deals typically you can't often just drop music, and that's like a big change for a lot of artists who are used to recording a song, you maybe the next day putting it out, or the next week. If you're working through a frontline deal, there are some things that you can do. If you have an album that you really want out, if it's through a major label, maybe they have a distribution arm, they could kind of push it through, extra contractually. But that's something we also have to kind of talk about, that you can't just drop music whenever. It's a long process. And you really, for some legitimate reasons, like, playlisting lead time, they need like 3 to 4 weeks really to properly set it up. You've got to clear the records. Some labels are harder lying about that than some others are. Some they want absolutely everything papered, or it doesn't come out. Other times just email terms, or other times they're kind of fine putting it out. So that's something that's a big sea change if it's an artist who's used to being able to drop whenever they want.
Excellent point, Matt.
Yeah, I mean, and going back to like the financial expectations, one of the questions that I always ask my artist clients when they come to me and they say, this is what I'm looking for financially, how much do you think they'll give me? I always ask them, how much are you making, right? What are you making with your music right now? And sometimes they can't even answer that question. And so for me, that helps gauge and monitor their expectations financially a little bit, because if you're asking for what amounts to, 10, 15x multiple on what you're currently making, it's quite a commitment by the label. And I want them to understand that. And I also want them to understand that that affects their recoupment and the possibility for recoupment. So if you're asking for $1 million and you've made $10,000 in a year, you need to really take that in consideration and make sure that's the right choice.
Thank you. I also, with that question, want to talk kind of about the services that the label versus the distributor might offer, and how do you help clients understand that they might not be getting the same services depending on which deal they choose? And does that play a big role in what your clients choose, do you think?
I'll go ahead. So one is just walking them through both options and helping them to understand what one looks like versus the other. So kind of walking them through what all those terms could possibly be, or if they have two offers, then walking them through all of those terms. And then once you get to the services, it kind of goes back to what I mentioned as far as having a different team for every aspect of your career. So again, at labels, you have marketing, you have A&Rs, you have creative, etc. So that's one thing that you get at labels, but at distribution companies, they may not have in-house marketing departments, and a lot of times they do not. They also may not include marketing assistants in your deal. Some distribution deals may, which are those that include the label services, but many of them do not. So it's on the artist to kind of act as their own team or create their own team when they enter into distribution deals versus when they're at a label. Typically, when their deal is good or the label is working well for them, then all they have to do is worry about creating.
Yeah, it's like that silly Billy Joel song, "We Didn't Start the Fire." I don't think major labels can really ever start the fire. They can sometimes, well, what they do well, sometimes depending on who it is dumping fuel, and also helping push things internationally or more broader national pushes. So, best fit for someone, sometimes it's also kind of, like, what's the genre? Is it pop music? That's something that I think Frontline might be, better suited for someone unless they have a lot of infrastructure already, high monthly listeners that they can, leverage, and someone on their team who knows how to leverage that. The other thing too is we get a lot of, deal anxiety from clients, which is something that Matt and I were talking about last night. A lot of clients are, almost petrified to sign anything because they're, wondering whether it's, too early, and maybe that speaks, towards distribution, or if, it's time to have, frontline services. It's rare that you're not going to be a little bit scared signing any deal. And we obviously can't predict success. Like, we don't really know what's going to happen. And so, either decision has risks. And of course, it's our job to walk the client through what those risks are in each case.
Thank you. You mentioned, I think, something that is important, that as you grow, your needs will change. And so for those artists who are taking a more independent route, when do you think that being independent or entering a certain type of deal structure becomes unrealistic? Is there ever a point that it becomes unrealistic for a client to go down that route?
Go ahead, Joe.
I think, okay, so at a point, labels were very heavy on signing TikTok acts, and left and right, oh, they're viral on TikTok. Everyone's reaching out to sign them. However, at least in my opinion, being viral on TikTok does not identify you as a artist or as someone who is going to have a long music career. So sometimes it may make sense for that person to sign a single deal or sign a distribution deal that is advantageous to where they are in their career and can also help them to actually develop into the artist that they like to be, or just develop their career holistically.
Yeah. Staying truly independent, you really need strong management. And there was a period, particularly in rock deals years ago, where I did a bunch of those, and they had strong management teams. And you then start doing like territory releases. You would sign with one label for the US and one Europe, Australia, and that's just a lot to kind of keep up with.
Mm-hmm.
And so, but you can certainly make more money theoretically doing that, but it's a lot more work. It's a little more uncertain. I think for some artists, it kind of feels like a security blanket signing to someone. What I also tell people is you should really only ever sign to anyone if they are like jumping up and down for you. Like, they really want you. And of course, a lot of it's going to be marketing speak and, selling whatever. And they certainly will say whatever. They'll, shit talk the other labels. And you've got to kind of trust, your gut a little bit, but also be aware that your gut can be wrong. Relationships can change. Like, any deal, if you're doing well, you're probably fine, because then money's coming in, even if it is just a distribution situation, they're going to start adding services in, right? You could renegotiate, everyone's happy. It's really kind of if, no money's coming in, or if you're just barely kind of bringing stuff in, that then relationships can change. So I always say, like, choose good partners, and we've all been doing this for long enough to kind of have a sense of, who really, I always judge labels by how they have treated artists when things haven't gone well for the artist. And there's been a handful of them where I've seen them, really do the right thing. And so I tend to, trust those. Not that I ever push client towards them, but I get asked, all the time, like, how do you feel about them? And I, answer honestly. And there's also a handful that I will not, if a client wants to sign there, I say, you got to find someone else. Like, I've had too many bad experiences there. I can't, in good conscience, you really proceed with this deal. So, picking good partners who have been in the industry for a while, not fly by night, because those ones, they are often more quick to kind of pull the plug. There was a whole slew of like Red Bull record label, or so like NFL player has a record label. Those I personally haven't seen a single one of those actually work out, because they're often too busy. The music industry ends up being too hard, and then they kind of pull the plug, or they freeze you out because they've maybe spent 50,000 and they don't want to just cut you loose. So part of our conversation too is just helping someone recognize, like, which partners, whether distro or frontline, like, really believe in them.
I think, sorry, go ahead.
Okay. I want to just kind of piggyback on that real quick. It's also important to know whether it's one person that's passionate about your artist or it is multiple people at a label. If it's one person, you need to get a secondary person, because what has been happening a lot lately with these labels is just high turnover rate, just big shifts and changes. And what I've seen and has happened to at least one of my clients is their point person, and that person who is super passionate about them, went to bat for them in the label, they are now gone. And so since that person is gone, now they don't have an A&R. We're fighting to get someone on their team, and soon after, that person is let go. Or you may have a different situation where you're kind of your client's sitting in limbo, and now you have to figure out, okay, should this client leave this label because they're essentially not doing what they need to do for them, since they don't have an A&R or a point person anymore, or should we fight to stay? So that's very important. And I always now recommend having a secondary point person on your team to make sure that if in the event of anything happening to your passionate person that you initially had, then you still have someone to go to bat for you.
I always say you got to be good on both coasts and both of the buildings. It's our obligation and responsibility to get to know our clients. I think that's like one of the best ways that we can service our clients and help guide them into these decisions. I mean, I have a number of clients that are under 20 years old right now. And so as talented as they are, they simply don't have the experience to have the knowledge to know what to do. And so we're supposed to give them enough knowledge so that they can make their own decisions. And a lot of that comes from us knowing our clients. John and I are solo practitioners, or we run firms. Ariel and Chelsea both work for boutique firms. And so for us to make money, we have to take on a lot of clients. We have to scale. And so I can also say that myself and my colleagues up here, we take the time to get to know our clients. And, knowing the music, like John's example, if your client's in pop, then maybe we need to go in-house with a big label because we need the radio department. Or if we have a client who is very likable, has a big social media following, has a great live side, maybe we want the brand department at an Interscope or something like that, that's delivered brand deals. So, and then also clients that sample heavy or work with a lot of producers because they haven't found their creative team. we want the administration side of things because our clients get exposed to a ton of liability when they don't clear records properly or when they're supposed to be paying the producers with their own artist accounting, which is, kind of a funny phrase that we have like the, artist math, but it really could expose them to a lot of liability. So getting to know your client is our obligation. And I think that's like one of the best ways that we can guide them.
Okay. Thank you all for that feedback. I want to kind of now discuss, we talked a lot today about evolution and how things are evolving in the entertainment space in general. But as it relates to these deals, I want to talk about the future of these deals and what you all see potentially happening moving forward. Do you see them shifting into more hybrid structures largely, or like what do you see happening?
I hope that we see a reemergence of talent-based signings where we're signing artists because of the development side of things and not so much the data side of things. I appreciate the data side of things. And I think that, John's point, a lot of these companies are really good at throwing fuel on a burning fire. And we need them for that. And I want them for that. But I also want to be able to walk somebody into a label like I used to be able to and not be met with like, hey, Matt, he or she is really talented, but we're not going to be in a rush on this because we have to do it that are on the TikTok top charts right now. And so I'm hoping that's what's going to happen. I do see it with a couple companies because the database signings, some of them have proven very financially detrimental to these companies. I also see that these lines are just going to keep blurring. I don't know that there's going to be this is a distro deal and this is a frontline deal. It's just going to be, this is a record deal and the terms are very similar and it all just depends on your leverage. So I think we're going to come back around to how it looked before, but with more progressive terms overall.
Yeah, I kind of agree. Fully agree.
Thank you.
I think
I only partially agree.
Right.
Here we go. It's getting spicy.
Right. Yes. I think that deals are going to move more into the hybrid space. I've been seeing that a lot already, actually, where I'm negotiating a deal currently where we are doing a license deal on a front line. It's a license, but it is a frontline deal. The term is much shorter, something that you would get in a distribution deal, no ancillary, so no 360 aspect, but it is still a frontline deal. I think labels are seeing that a lot of artists are going the distribution route or being more amenable to go that route, and they're trying to compete or at least trying to, also get in on that money that's there. To that point, a lot of labels are also creating distribution arms. Most of them at this point, so that if they're not signing an artist on the front line or financially it just doesn't make sense, they can take the artist over to their distribution arm and eventually bring them up. I'm not going to call it upstreaming. Bring them up into the to the major side of things. Just kind of locking them in and including a first right to that deal as well, so that they can be able to have first rights on this artist and bring them into their major system when it makes sense financially.
Yeah, and I mean, that's why it's so crucial, especially if you're signing with a distribution arm. If you're doing a distribution deal with a distribution company that goes through a major, you're not for sure locking yourself in to that system, but you're definitely setting them up with the best shot to kind of keep you, because other labels can't leverage back catalog, all that. So it's still important to choose the right partner even then, because you might end up being in that system even if there isn't a match. If there is a match, then you almost certainly would be. The one thing that I would like to see changed, frontline deals, the main problem is that your initial term lasts 3 years sometimes because they keep wanting to add more mixtapes to it, and they almost set it up to dare you to send a breach letter to them and to declare something the album, they will do everything possible to kind of keep you in the initial term. And so then it's well, we negotiated $500,000 on the expectation that it would be mixtape plus one album, and it's 3 mixtapes later now, and yes, it's true. Depending on how things are going, you can sometimes ask for a little bit of a, extra budget, but you really do have to keep staying on top of them and make sure the artist understands that too. I have an artist, he, records very slowly, and he's been in his, initial term for like 5 years now, and it's just absolutely insane. And then the other thing I was going to say too is part of the issue is that, you get distribution companies reaching out to these kids who have 1,000 total streams, and you're like, how did you even find this guy? And it's hard because you've got no leverage. And so in those types of scenarios, unless there's a special circumstance like that, they just really need the 20,000 or however much it is, we do kind of say, hey, if this is all that's out there, then maybe you should stay independent for a while. But it does make it challenging for us because you've got no leverage. And of course, labels and distribution companies, they talk out of each side of their mouth. They say, oh yeah, he's hot, he's going to be huge. And then when you start asking for some money that's kind of commensurate with that excitement, they say, well, he's so new and he's really only has like 1,000 streams. And it's like, well,
and which it's going is it? down. It's going down.
They always say that. Yeah. So, it's hard, like labels and really anyone who has, any money in, any industry, they're going to figure out how to game the system in their favor. Right. And so they're going to always kind of keep coming up with something that looks like something else. But then once you start getting into the terms, you'll see it's actually, really like a frontline deal in like sheep's clothing,
That was going to be my next question is, do you see labels in any way still kind of relying on their traditional label advantages, dressing it up, making it look a little different? Moving forward, do you see that?
Yeah, I mean, and also I'll have competitive deals on the table from distribution companies, and then a frontline label will say, well, we're going to offer $100,000 less or a significant amount of money less because they're like, do you know who we are, right? Do you know what our track record is? And to a degree, I appreciate it. I say, okay, yes, we do, and you have a lot of success. Like, what makes you feel like you're going to have that with my client to the extent that he or she should accept 6 figures less than what I'm being offered by someone else. And so I do see a little bit of that flexing happening. And and then it's tough to make them, put their money where their mouth was when push comes to shove, if they're not delivering after you've made that commitment. And you hope that it works out like that. But then if they sign the next hot thing that takes their attention or takes away your A&R that signed you or something like that, or your A&R lead, you're not in a great place.
I completely agree. A lot of times labels will do the same thing when it comes to your royalties, especially if you're asking for a net profit split. They'll say, oh, well, we're giving so much money, we're going to have to change up the structure of the entire deal. But it's like, do you really have to? Right. It's just a lot of kind of just sideways talking or just negotiating. They're going to talk in their best interest, of course, and we're going to do the same for our client and for us. I think us as attorneys have to let them know this is just not what you're going to do here. We have other offers on the table. This is what it is. We can move some other things around. If not, then we probably won't be able to do this deal. Of course, it's going to be subject to your client and based on where they are in their career.
John, can I add something real fast? The wolf in sheep's clothing on the royalty side of things with major label deals is you can negotiate an amazing profit split. And then when it comes time to talk about the foreign royalty, that changes. And so you have a 50-50 domestic profit split. And then all of a sudden they're like, but we got to do 22% as a royalty ex-US. And so that is every country outside of the US. And you've been sitting here negotiating a profit split. Meanwhile, all the distributors are doing a worldwide profit split, right? And then on top of it, then they say, all right, we'll give you the profit split, but we're going to take a 20% distribution fee on top. And you're like, wait, that's your profit split. That's what you're supposed to be doing. So then you're splitting 70 cents on the dollar. And so there's a lot of little hidden things when it comes to ex-US royalties specifically. Absolutely.
Anything there? Are you good? Okay, so that was great. Thank you. We got a little drama in there. I feel like I'm just kidding.
Try.
But I love some drama. I'm sorry, y'all. But
We get
now,
along really well. What can we say?
oh yeah, we sure do. Does anybody have any questions now that we're 10 minutes out? Yes, Atira.
I don't know how you have any time, Atira. I'm on like 1,000 emails with her, and she's building an AI tracking system. I'm
Sorry.
I ain't know that.
Go ahead.
Claude is my answer. But okay, so this is actually to everybody, but also you guys, and you guys can fight over it a little bit. I put out something on Instagram where I was essentially a poll, right? That was like, why don't we have key man clauses and label and publishing deals, essentially. I got a whole lot of information of people arguing with me about it. But essentially what I try to do is I always ask for it. They hardly ever give it to me. I don't think I've actually ever got it. But I always ask for a key man clause in my label deals and my publishing deals, no matter major, small, whatever, because of that issue, because your person might leave or two of your people might leave, or they might go to another company, and now you're actually competing with whoever they sign over there and all of these things. So it's like just having it out in that way. Essentially, I'm advocating for you guys to push for it, because the only way that they care is if we're all collectively pushing for it, like we all collectively started pushing for distribution deals and fair deals and less 360 terms, et cetera, et cetera. That's really us that's making that change, not them, because we're telling our clients not to take these deals, or we're swaying them on the basis of, okay, you got these 3 or 4 or 5 offers. We're going to go with this one because they're giving us, this, that, and the third, and they start paying attention. So what I'm saying that we all should do, and you guys let me know if y'all agree, is we should all just start asking for them more often, because then we might get them more often.
So Nancy has a question, and I was just going to have someone explain
Nancy's
it.
brought that up with me before.
Yeah.
I can just respond to this because I'm older than all of you and was in the industry. You're never getting a key man clause. You're never going to give it to you.
I feel like you could get anything with enough leverage.
No, you have no leverage. They're never going to, they can find another artist. I have been through the ringer. I have asked for it. The reason they won't give it is because they can't control if someone leaves. And so I had a client that should have been huge. This is true. It's so sad. Should have been huge. Their guy at the label walked in and asked for a raise based on signing them and got fired. And then they brought in somebody else, and the plain white tees became what my client should have been. And so, and then also people can leave. They can just say, I'm done. I'm going back to grad school. I don't want to do this. I want to be a priest.
That's also why I try to get
Such a robust pipeline in this industry. Happens all the time.
But when you think about things that collectively can be done, you have to think about why they're not there, in my opinion. And I just, having been through this 30 years ago, 25 years ago, whatever it was, there's a reason they don't do it.
Well,
I get that. But the issue is that, essentially, I had a lot of A&Rs respond positively because they were like, this actually gives us leverage too. Right.
Yeah.
Fight to keep A&R. You'll fight to
You're going to help us keep our job.
Right. Exactly. And so they were kind of on board with it too. So I feel like if we have enough pressure, we can actually get it done. It's just applying the pressure. Do you want to apply the pressure or not?
Yeah, I mean,
A&R is a problem. Some of the A&Rs are a problem. I will give you that.
I think like in an ideal world, you want to sign in this like sweet spot, a few years after someone new came in. So they're kind of like over I'm going to sign a bunch of stuff, but it's not so late that you're like, he's been there for 4 years. Like, they may kind of like let him go. And I did want to say too, really early in my career, I had a client sign a record deal, and the label president wanted him signed. And I was like, wow, this is really good. This is a great thing. It's the president of the label is the one who's signed this person. It was horrible because there was not an A&R in there because they had brought in their own clients. And so that was a lesson that I learned early on. So
it's really got to be top down, like the full run. Yeah. I mean, it would also be difficult to know who to ask for in that key person clause, I think I totally agree. I push for it vehemently in management deals. Especially because management deals don't have things that there's no accounting by the manager, there's no funding by the manager. They don't have to, all they have to do is advise what's incoming, basically, right? And the scope of services is so limited. So I push very much because we're dealing with that person because of that person, but we go to a label because of so many other things. So I would be pressed to even decide okay, well, if I'm going to Interscope, who am I asking for to be in this key person clause? Because I'd have 30 people in that key person clause, right? To make sure, get two in every department, something like that. But I definitely understand, and I appreciate the poll. I'd like to see the results, by the way.
I completely agree as well. I definitely asked for it. I've gotten something close, so we can talk about it. But
do tell.
Yeah,
It's like, let's all talk about it.
I can't remember the language, but I know I figured it was going to be the closest that I was going to get because I completely understand them not agreeing. But this is the example I was talking about where my client, where their A&R left and things got weird. It's good to have something in there if you can. It's always going to depend on the leverage of the client. But if you can get something in there, at least right now, while we're all still trying to fight for it, at least something close or of similar nature that kind of holds them accountable or at least causes them to make reasonable efforts or best efforts, whatever, in your client's favor, then I think that's still a win.
And the other thing I'll say, that I know we're kind of over time, is that especially if you're doing a frontline deal, but really any deal, get to know everybody there, like the product manager, the marketing team, because even if you can't get a key man clause, if people know you and you're not being super like annoying about it, like they want to help you out, right? And so it's just helpful to kind of know who's in charge of the marketing team, who the product manager is, who the A&Rs are, and just kind of be in contact with them so that if one of them leaves, you still have some other inroads there.
Yep.
I'll add to that. Sorry. I'll add to that and just say, when your client signs to a major, especially try to do a call with their entire team. So the marketing department, whoever is over absolutely every aspect, and also be on that call so that it kind of feels like they're being held more accountable, especially when the lawyer is present. Just so everyone's name, your artist knows everyone's name, management knows everyone's name, and you can use them as a reference for whenever you need.
Yep.
Wonderful. How much time do we have left?
It's time, but we have a break until 2:45. So if you guys want to forego your break and ask questions.
Oh, they look like they want a break.
Take a break. Yeah.
Good afternoon, everyone. My name is Ashley Rouse, and I'm Secretary of the Sports and Entertainment Law Section of the State Bar. I would like to introduce our next panel. It is the Name, Image, and Likeness What's New Since 2024. Nadia Moore will be our moderator. She is an associate at Carter Woodard, LLC, the law firm that I work at. She is our resident sports attorney in the firm, and she's also a volleyball player. So she will be able to really handle this panel and give you all the information that you need. Thank you.
Is this on? All right, here we go. Hi, everyone. As Ashley said, I'm Nadia Moore, associate attorney at Carter Woodard. I do a lot of sports matters with Donald, who's on the panel at the end. Before we get started, I would have each panelist just introduce themselves and talk about what their involvement is in NIL. And we'll start with Jamil.
Good afternoon, everybody. All right, thank you. Just wake up. I know we've been eating lunch. Let's get moving. Should have had a break. Nonetheless, Dr. Jamil Northcutt here. I've got 20 plus years experience in sports and entertainment. Most recently, I was the deputy director with athletes.org, which is the Players Association for college players. Prior to that, I served as a senior vice president for Major League Soccer for 6 years. Player and league advancement, building out their whole player area for them, which caused me to be a direct liaison with a Players Association in MLSPA. Prior to joining MLS, I worked at the NCAA office in football development, which was on the regulatory side. Prior to the NCAA, I was the director of football administration at the NFL office. Did that for a few years. Prior to the NFL office, I was with the Cleveland Browns for a couple of years. Oh, we got a Brownie in the house. Here we go, Brownies. Here we go. And then prior to Cleveland, I was at my alma mater, the University of Mississippi, where I played football. So hotty-totty to those Ole Miss fans here. Sorry, Bulldogs. We beat you the last 2 years. We plan on beating you again this year. So, so nonetheless, so I was assistant AD for internal operations at Ole Miss as an administrator there. And then prior to returning to my alma mater, I worked for the Kansas City Chiefs in player development, football ops, and player personnel. for 3 years. And then prior to that, I was at the Southeastern Conference doing championships administration and marketing. So that's kind of a quick Cliff Notes version. There's a lot in between with all those stops and places with people and faces, but a lot of it that I've done have dealt with players, administrators, coaches, player personnel, executives alike, as well as agents. So thank you for being here, Nadia. Thank you guys for having me, and look forward to our conversation this afternoon.
Yes, yes.
Hi, I'm Andy Schwartz. I'm not an attorney. I'm an economist. I come to the NIL space through a couple of slivers of what I do. I do mostly antitrust economics, and as a result, I've worked on the White v. NCAA, O'Bannon v. NCAA, Rock v. NCAA, Alston v. NCAA, House v. NCAA, and now Patterson v. NCAA, sometimes as a helper of the expert, sometimes most of the time as the helper, occasionally as the expert myself. I also was sort of the catalyst for California's NIL law, SB 206, which has the unusual name of the Fair Pay to Play Act, even though it's not ostensibly about pay for athletic services, which is my preferred term. I guess I'm here because I think that college athletes deserve identical rights to college coaches, and until they do, I want to keep changing laws and get them there.
Good afternoon. My name is Donald Woodard. I am a co-founder of Carter Woodard. I started my career predominantly as a music lawyer, and I still practice music law in a significant way. In 2016, I took 1 foot out of the business and went in-house and worked for USA Track and Field for 2016 to 2020, Deputy General Counsel of USA Track and Field. And that's where I reconnected with my love for sports. I grew up as an athlete and working with track athletes. And during that period, I also learned about NIL and the issue and the issues around it at the time before the guidance came into existence. Track athletes, if they want to sign a shoe deal for training purposes, because that's how they support themselves, they couldn't sign a deal if they wanted to run in collegiately. So for example, you look at Sydney McLaughlin, who came in 2016, 2017, superstar. I'm going in a circle a little bit here. But superstar, and she couldn't sign. She decided to delay signing her New Balance deal for a year because she wanted to run track in Kentucky. And so I, at that moment, made a decision. I wanted to continue to work with young athletes and help change the course of their futures and change laws. Moved back to Atlanta in 2020-ish. Called my friend Yolanda Carter and said, "Hey, we should start a firm." I had worked in large law firms prior. And she took her time responding to me, but eventually we got it done. But during that period, one thing, what entertainment law gave me, and I apologize for giving me this backstory, but this context is important. I knew Angel Reese was not my first NIL client, but Angel Reese was the first athlete that I pursued when I came back to Atlanta. I grew up in DC. She grew up in Baltimore. Personality, I knew she was going to be a star. And so it took me about a year, but we were able to make it happen. So I just wanted to give you that context. And so I'm excited to share this panel with our fellow panelists. I went to Morehouse College, go Morehouse, like that. So that's where I am.
Okay, as you can see, we have a diverse range of professionals here, which I think is really good to have like an overall conversation about NIL. And the way I want to flow with the conversation is just do a quick refresher on like what the House settlement is. I know a lot of us have seen it, but just to give a quick refresher so that way when we talk about what happened with the settlement and then what we're seeing now, it kind of gives a good foundation for that. So like I said, before we deep dive into the current status of college athletics, a brief summary, just quick overview. The House settlement was a class action antitrust lawsuit brought by a group of college athletes who argue that the NCAA and its member institutions were illegally restricting athlete compensation in violation of the Sherman Antitrust Act. There are a few other extra complaints, I guess, in there, but that's like the biggest one. And so the case really challenged the core foundation on whether or not college athletes should be paid because they're generating so much money for the NCAA and their universities. And then even bigger question on whether or not they should be considered amateurs if we do want to pay them. And so with that in mind, I want to start with Andy and to just help understand why this case is so significant. I want to talk about antitrust and pretty much have you walk us through why the NCAA was sued under the Sherman Antitrust Act and what was like the legal reasoning that the courts walked through and ultimately they concluded.
I will do my best. I will ask, and this is intimidating in front of a room full of people who have actually passed the bar to explain the law. But, antitrust economics, we have to know just enough about the law to make admissible testimony. So hopefully I will stay in that tiny lane. You'll forgive me if I make any mistakes. The idea behind the House case, it really flowed from the O'Bannon case. And in essence, it comes down to the first principle, which is why should participation in college sports in any way prohibit a willing buyer and a willing seller from engaging in a transaction involving right of publicity stuff. And why it becomes an antitrust issue is because the NCAA requires all schools to agree that in exchange for participating in the college sports system, they will not allow athletes to. This is circa 2020 or 2018 when the case was filed. They would not allow athletes to sign endorsement deals, and they would agree to boycott any school that did. So these are all the classic pieces of antitrust issue, which is collective enforcement of a private regulation, essentially. And to obviously the restraint of trade and the reasons that the NCAA forever, since 1956 is when the NCAA first enforced rules. They'll tell you 1906, but for 50 years there were no rules against athletes were paid. But the reason that the NCAA has been able to enforce it was primarily because of this dicta in the 1984 case in which that the NCAA lost about broadcast rights, which said, well, of course, athletes must not be paid. And the series of cases that I mentioned in my introduction have been continually asking the courts, well, is that still true? This is a rule of reason case. So I know some of you are antitrust people, but there's per se stuff in antitrust where it's like, we know this is bad. It's so bad. You can't even say, well, I had a good reason for doing it. And that's usually things like price fixing, bid rigging. And then there's a whole bunch of stuff where it's like, well, businesses need to cooperate a little bit. Sports leagues are a great example. The Dallas Cowboys and the New York Giants are separate companies, but if they want to play each other, they have to kind of make a schedule and all those things. And so there's room in the rule of reason for saying, yes, okay, we're restraining trade, but it's a reasonable restraint of trade. And the NCAA's reasoning was no one will watch college sports if the athletes are paid because people aren't interested in their skill. People aren't interested in their charisma. People aren't interested in their dedication. They're interested in the alma maters that are there and the fact that they're doing it for free. We're selling unpaid labor. And turns out that's false. But it took a long time to get the courts to allow those enough experiments to sort of start moving the window. And Alston was Alston was the case that preceded House. And I maybe not doing a great job. Alston simply essentially challenged, is the NCAA immune from antitrust scrutiny with respect to eligibility rules that relate to money? And the court said it's not immune from scrutiny. And it ruled on a very narrow question that had nothing to do with NIL. But at the exact same time, the states, first out in California, and then really importantly, and I hate to say this in Georgia, but the state of Florida really pushed it by in California to get it through the legislature, we had to set a 2023 deadline. And Florida took our legislation, copied it, changed a few things and got a 2020 deadline. So that really sped things up. That got delayed because of COVID, but in the middle of 2021, a week after the Alston case, Florida state law said it was illegal for any association like the NCAA to prevent a willing buyer and a willing seller from making a third-party NIL deal. And that essentially got us where we are on the ground, where the NCAA said, okay, we're not going to enforce it because we just got slapped by the 9-0 by the Supreme Court. We had 3 years where we finally got to have the market tell us, well, do people care if the athletes are being paid? Because if they do, what we'll see is the schools that are, this was a big deal, $500,000 for a quarterback. The prices now are 4 million, 5 million, but half, oh my gosh. Well, so if the NCAA's arguments were correct, we should have seen people stop watching the high paid teams and start watching the lower paid teams. Stop watching FBS, the old Division 1A football, and start watching Division 3 football where they're really amateur, because that's what they want, right? Well, of course that didn't happen. And I mean, that's the thing, is like in 1984, I was in high school. I'm almost 60 now. For that whole period of time, everyone just believed this silly notion that the less an athlete was paid, the more popular it would be. And anyway, I will stop by saying what House challenged specifically in that context was whether schools themselves could agree not about third party, but about direct payments. You are putting these athletes on television. There's no legal requirement to pay them for that broadcast, right? But there's also oughtn't to be any legal prohibition against paying them. Hey, we want you to be the star of this television show we put on called SEC football. And normally when people we want you to be the star of a program, and you might go play for, might be on a different TV show called Big Ten football. We pay you for that. And we pay you directly. We don't say, well, we're going to get some guy who's a fan of the show to pay you. And so that's what the case was about. And 12 seconds more. The settlement essentially set a $20.5 million limit on schools' direct payments, but also reined in indirectly some of the third-party payments. We can talk about it more as we go.
Yes. And actually to kind of continue for when you're talking about the settlement, just for people that don't know what the settlement actually said at the end of this. So they were like, the NCAA, like, you can't restrict pay anymore for athletes pretty much. And so now the major structural changes were that schools can opt in to rev share directly with athletes in addition to scholarships. And that cap for the first year is 20.5 million. And that's set to pretty much go up around 4% each year. So that means athletes continue to make more. There's also new roster limitations that were implemented. We have a new oversight body called the College Sports Commission, which we definitely would talk about. And then also there was a pool of money that was supposed to be set to back pay former athletes that weren't able to benefit from that. Like me, I graduated in 2020. So I was very upset about that a little bit. But yeah, so going off of what new rules and things that the settlement implemented, Donald, from a perspective of someone that works directly with college athletes, how has the implementation of these settlement terms actually looked like on the ground? Like doing the deals with the schools and things like that.
He's laughing. Sorry, brother. Like, give me the tough question. So I will make another reference to my colleague. We represent a legendary hip hop production company called Organized Noise. So what this is organized chaos. The rules around NIL are being set in real time. The infrastructure is being set in real time. I'm in the algorithm on my social media and on my phone. And so every day there's something that pops up about what's happening in the space, a guidance that's changed, a challenge. It is wild. It is wild. And so to stay abreast of this is a constant challenge. Add in universities now are hiring GMs to manage the cap, as you mentioned. So this is starting to look more like professional sports and professional ball. I should start by saying there's a theme that you may feel like is throughout this is college coaches forever, not going to say all, but many of them operated under a mantra that if you're not cheating, you're not trying. Right? So you tell me what the law is and the guideline is, then my job is now I'm going to figure out a way to go around it. That's it still happens today. It still happens. So when there's 20 million cap hit, we have to figure out how to get around the cap. My football team cost me $15 million, but in order to compete in the SEC or the Big Ten, I need a $20 million team. So how do I get the 20 million? We'll talk about that, but it's NIL collectors. There are other ways to do it, but that's part of it. I want to reduce my cap. Well, I don't want to reduce my cap, so I need to start moving money out that was already sitting in coffers before the law passed, down to high school students. Right? So one of my clients was in line to get some money during his senior year of high school before they closed the loop. So this is all happening in real time. Literally, he was probably at the car dealership.
And to add in for that, like I had a client or potential client that came to ask for our services at the firm. But to echo, like you're not cheating, you're not trying, it was a very sketchy deal. And you're still seeing those sketchy deals where allegedly the school offered this athlete like 1.5 million for 3 years at a school that was decent. It was D1, but it wasn't a giant school. But he came to us and said that we had to draft the agreement and that the school wasn't doing that. He also already was receiving payment. And so that's an example of like they're trying to get around still just that cap, even though they still have $20.5 million plus more to spend every year, they're still trying to get around it.
Well, even there, but that's divided among
all
sports.
Exactly.
Right? So at the major football schools, most of that money goes to football, then to men's basketball, then to women's basketball if it's LSU and some of the other schools. And then the rest is divvied up among the other sports. So your Olympic sports, track and field, and others.
And a quick follow-up, Donald, just to emphasize like some of the shift that happened when the House settlements first happened, we saw like a large number of collectives and things like that emerging. But I feel like now with the settlement, you hear less of them. And so can you just briefly talk about, I guess in your experience, what the role of the collectives are now? Are they still a role? Are they what do you see their role?
Well, first, let's define collective for the audience, if you don't know. Collective basically are wealthy boosters that are funding athletics. That's essentially what it is. And when the law first changed in 21, collectives came into existence because the law did not allow the university to pay the athlete directly. So how are we going to get money to the athlete? We're going to funnel it through collectives. There's a lot of drain on going to the same booster every year to spend money on the team, right? So you had paid for the IU team, and that's where it was going. And then when the law changed back now, so collectives are still here. Because again, we go back to my theme that I mentioned earlier, we got to figure out a way to pay this quarterback $10 million, right? So Carson Beck leaves Georgia. We thought he was going to enter the draft. He didn't have a great season. And I thought, he probably shouldn't go in the draft this year. Then I heard he was going to Miami. $10 million package. More than some rookies are getting paid, right? So these college quarterbacks and college athletes are getting paid significant income. But how do you can't take $10 million off the cap, off a $20 million cap, because you got to pay other players or else he's going to get sacked every play, right? So you got to pay the left tackle because that's the blind side, right? So you got to pay him. That's where collectors in NIL comes in. So they still exist, raising money, creating a full package of rev share compensation as well as NIL compensation. But where this gets tricky is, again, if you're not cheating, you're not trying. The CSC came down recently and said, hey, these deals have to be real NIL deals because really they're just disguising it as pay for play. And they were trying to root when the goal was to root pay for play out of college sports. And it's just very difficult to do that because there's so much money in it. And so teams want to win. And you're talking about the SEC and Georgia and Texas and Alabama. What's interesting about Alabama, and I'll stop there. I knew Nick Saban was going to retire the year he retired. I said, he's done. During his era, when he was paid millions of dollars to coach, he had 5 stars sitting on the bench. You know what happens when I can go make $1 million somewhere else? I'm not going to Alabama. So all of a sudden, look at Alabama this year. They just haven't been the same team. The Big Ten is where the money is. Like their alums have real money. So Ohio State the year before was a $20 million team, go to the championship, win it all. So those are some of the issues we're dealing with, and I'll sure have.
And to shift the conversation a little bit as we talk about regulation and the big mess that we're in, Jamil, I want to shift to you and kind of have you talk about some of the legislative efforts that we've seen on the state and federal level in response to the changing NIL landscape.
Yeah, and I think Donald mentioned something that's very, very important before I get there, excuse me, which is pay for play. We keep calling it name, image, and likeness. It's a separation between what that is. In pro sports, a deal with State Farm that Patrick Mahomes does or anybody else does, that's separate from what he gets paid for his performance on the field. And that's what we're seeing, this ugly blend of NIL and pay for play, which is creating a lot of problems and issues around that, which kind of leads me or segues into this whole legislation piece. So anytime you're dealing with laws, you got this 9-0 deal with the Supreme Court around antitrust. There's 3 issues that are happening at the state and legislative level. It's around antitrust, it's preemption, and then it's also employment. So those are the major issues that everybody's chasing at the legislative level. And so you've got people paying lobbyists to be on Capitol Hill and in DC with just various groups. When I was with athletes.org, I was part of that piece of going to DC, meet with the Congressional Black Caucus, organizing our athletes to meet with other delegates and other legislators on Capitol Hill about their experiences. And that's the one thing that's missing in all of this is the athlete's voice. So players associations are coming up now, athletes.org being one of the premier ones, in addition to a few more, but they don't have athlete members. And so the 3 kind of legislative pieces that are coming up, one is big. I'm sure you guys may have tuned in on C-SPAN to see the organization of a Capitol Hill meeting with President Trump organizing some folks around pretty much the SCORE Act. And so that's legislation that is on the table right now. It was killed late September, October, when the Congressional Black Caucus put out a statement, athletes.org, NFLPA. They also had a student from University of Alabama came to speak to the CBC about holes that were in that particular legislation around the SCORES Act, which is a lot. And then they rarely issue a statement. And after we met with them in that meeting, they issued out a statement against that. The bill was supposed to be voted on the floor that day, and then it got pulled. And so there was somewhat of a minor victory during that particular time that happened. And then there's also other introductions. I think, People's Political Party needs to be involved. And so SCORE is primarily GOP based. You got a SAFE Act that's coming out of the Senate. Maria Cantwell, Blumenthal, as well as Senator Booker are trying to support that. And then you also have a CARA Act, which is the College Athlete Reform Act, which Lori Trahan is introducing. She was at that meeting. I'm invited. So as you guys are looking at what's happening in this legislative space, I want you to look at the rooms that are curated too.
Mm-hmm.
So there was only one Black dude at that meeting, and that was Charlie Ward, who's the coach, but he said absolutely nothing. The room was filled with a lot of individuals that did not look like me, who are critical to this, what I call the sports industrial complex, that keeps the machine driving. I know Donald alluded to this earlier regarding football and basketball and them being major revenue drivers that pretty much support and underwrite all the other sports that are on campus. And so we hadn't even got into the whole Title IX issue, but that's something that's coming up from a legislative standpoint. And how are you going to support these men's and women's basketball players as well as the football players? Meanwhile, the Olympic sports, they may suffer there. So that's a conversation that's critical to everything that we're talking about. But as it relates to the major legislative pieces that are out there that folks are looking at trying to come to some consensus on, the SCORE Act, the SAFE Act, and the CARE Act are three of the major acts that are being looked at now.
And to follow up, I'm just going to skip around just a little bit because you brought it up. Athletes.org, which is, I had the materials, and it has the collective bargaining agreement that they created. It's almost like a proposal of like what they think that should look like. Just to follow up, since you brought it up a little bit, can you explain like why we potentially should just pursue a collective bargaining agreement act over a legislative like act, I guess, and what problems are they addressing in the CBA that they're not addressing in the legislative?
So I'll answer the last question first. It's the athletes' voice and their representation and protecting their rights as human beings and as folks participating in pretty much employment. When it comes to the legislation piece, there's ways around the employment conversation. And that's pretty much the caveat that everybody's looking for, that what can you give? So when you sit around a political table, you're negotiating already anyway, okay? We want to do this, we'll pass this bill. If you take this out, you put this in. So obviously everything's a negotiation at this point. And so if it is to go a legislative route and there is to be collective bargaining, which is, okay, so the example would be the NFLPA negotiates the rights on the behalf of the players, and they're in a relationship, a business relationship with the NFL, which is the National Football League. And so they're business partners in a venture that is really going to make everybody a bunch of money. And so they agree on what are the working rules that you could have, practice times, how are you going to treat me as a quote unquote employee, the time I'm going to be spending, the health and development resources that I'm going to be able to get, all the schedule things that's unilaterally made by the NFL. They still run the schedules, et cetera. Now, when it comes to us adding an extra game, then we have to revisit that. And so the parallel to that is, even in the college space right now, they're talking about expanding the playoff. Okay, well, we're expanding the playoff. We got to think about the health and safety of our players who are participating in this game. So I'm coming to camp early, and I'm not ending my season until, it used to be, you were done January 1. Now we're expanding the season, and now we're not done until the second or third week of January. You expand the playoff to more teams. You got to think about what the calendar looks like, what the schedule looks like, and then how much time off do I get to rest my body as an individual participating in college athletics. And so these are the major issues that the CBA will put into the legislation. And then we got this little thing called education, right? That nobody's talking about. And so, and from what I'm hearing from my side of the table is that a lot of the athletes are taking online courses. So what does that mean? That means that they're not developing communication skills to be able to communicate, to facilitate opportunity and building relationships, which leads to what? Opportunity long-term for you. And so you got tons of issues that are happening right now. You may be able to look it up. It's public. One of the athletes, he transferred, I believe, from Ohio State to Notre Dame. And he said, the biggest difference for me was I got to go to class. I got to go to class in person versus going online. And we know there's a big difference between engaging with your professors, engaging with your colleagues in conversation. You guys are lawyers, litigators. You got to be able to communicate and be able to get down in the courtroom. And so a lot of these athletes are going to be missing out on that. So again, I won't labor the point, but you can see what the CBA will encompass as a result of kind of the things that are going on. Because again, when you are an athlete, and I played college football in the Southeastern Conference, they have a demand on your time. And then my research that I completed my dissertation on was the dilemma of career transition of African-American male football players at Division I institutions. And so a lot of what came out of the research is that, athletes are spending over 40 hours a week competing in their sport. That's a full-time job.
Mm-hmm.
And so being able to have other time outside of that to commit to other things, it was tough. And then when you do commit to other things, they look at you crazy, saying, why are you committing over there? You're not really committed to what we're doing. So athletes are in somewhat of a dilemma when it comes to impacting their transition when they get done playing sports. And we know that that's going to end. We know that the average playing career in pro sports is around 4 to 5 years. NFL is 3.2. Major League Baseball is like 5. You've got MLS is around 5. And so it's not a long time. By the time these guys are done and these women are done competing, they're going to be less than 30. Right. And so I got what I call the 54. The average lifespan is around 80 years. You got a lot of life left that you got to live. And so you need to be able to transition after the game.
And to talk about, I guess, the years of playing, I want to shift into something that we see now in the courts and issues that we as in me and Donald also see with our individual players, or we're starting to see, is eligibility. So now there are players suing and saying that the NCAA is violating antitrust law again and restricting how much I can make as an athlete by putting certain rules in place. So for people that may not have played in NCAA, if I decided to go to a junior college for 2 years because I wanted to develop my skills more, do whatever, and then go to an NCAA school, I only have 2 more years of eligibility at NCAA. But now players, you'll see, I played at X community college and now I want to transfer to Georgia State and
Ole Miss.
Okay, Ole Miss. I have only 2 years, which would limit my NIL money. So now they're suing and saying, you as NCAA, you're trying to stop me from making as much money as I can in the NCAA because now I have 2 years versus 4. And so I'm going to shift back to you, Andy. I just would like you to briefly, I guess, explain the claims that are being raised specifically for the Pavella case. Pavella case is also what was in the materials provided. This was like one of the first cases where he sued for extended eligibility. And kind of your thoughts on whether the courts will be receptive to that based on like what we've already seen with House.
Sure. I work on one of these cases, so I'm going to be a little generic. Essentially, anytime the NCAA, so we call these eligibility rules, but all of the rules that we've been talking about were eligibility rules. If you took money to do an advertisement, you were no longer eligible. It's just that these are essentially the length of eligibility rules. When does the clock start? When does the clock stop? And I think objectively, as an economist, I can say that those are less commercial than you cannot make money, which is inherently commercial, but they're not non-commercial because they still involve limiting someone's ability to make money as a college athlete. And so it's people will disagree with me. I would say the money stuff is clear, and the size of the field is on the other side of a non-commercial rule. But in the middle, we have these things like how long can you play? And as I mentioned in the antitrust laws, whenever you're restricting commerce, the question is, are we going to judge this on a per se thing? We know this is bad, and that's not the case here. Or we're going to let the parties discuss the balance between the anti-competitive effect. I would, a school wants me to play quarterback for them for another year. They want to pay me money. The fans will be happier. If you're a fan of Vanderbilt and you saw Diego Pavilla's year, that team would not have been as fun with somebody else at quarterback. So that's a reduction in consumer welfare. It's a reduction in his personal earnings. There's a restraint of trade. The question is it a reasonable one? And on the one hand, the NCAA will say, well, this is college sports and we need to define college sports. For example, and this is the one they like to say, we don't let men play women's sports, but that's a restraint of trade. And yes, and I would say on the spectrum, it's a little further on this side because it helps define the product. And the question is, what's a reasonable way to define a college product so that we don't have guys who are 10-year NFL veterans saying, I need to have 1 year more. I'm going to go play in college. But talking too much. But on the other hand, that doesn't artificially restrict someone who does deserve time to play. And essentially, these cases have been all about it. And I just want to say one thing, which is that in rule of reason cases, the best way to factually, as an economist, to inoculate yourself from the charge that you're conspiring unreasonably is to do a good study outside of the context of litigation. The NCAA shows up in court all the time, and they've hired a new hired gun who yesterday decided that there was a good reason for doing this thing that they did 3 years ago. Do it before and do it legit and find the line, and then you'll be fine because you'll go in and you'll say, yeah, we did a study and the average college student takes 5.5 years. And when we do our graduation success rate, we use 6 years. So we decided 6. You can have 6 years. You can play as much as you want during that. Boom. And then you'll probably be fine because you're basing it in economic and athletic fact. But instead, we end up with these ad hoc things. And so it's a Swiss cheese of litigation. Some judges saying yes, some judges saying no.
Well, and I want to add one thing. So let's be real about what's happening as well. Most college athletes don't go pro. So if there's a prime opportunity to earn money, I want to extend that as long as I can. So there was a case a couple of years ago, I think he was playing for Utah, the quarterback for Utah. And he played 4 games, off to an amazing start, cut a deal, they didn't pay him, and he stopped playing. So they said he quit on the team. But he was preserving, he only had 1 year left. And so it was important for him to preserve that 1 year, go into the transfer portal, which we haven't even talked a lot about yet. Yeah. That's an entirely...
And just to be clear, the rule in football is if you play 4 games or fewer, you can do another year. And if you play 5 games, you can't.
Correct.
But Donald, but to add to that too, it happened too at Virginia Tech. Yes. So it's a different situation. So they've had athletes, they fired their coach after the third game. And so we've had to deal with issues with teams like that, UCLA, Virginia Tech. And so guys wanted to redshirt as a result of that, because it's like, you threw away our season. Why should I waste my year and continue to play?
Well, that happened with one of my clients, Juju Lewis, superstar in Georgia, reclasses to go in early when Shador leaves because they were handing him the keys. Didn't quite happen that way. And so he didn't really get much playing time during the season. Season didn't go well. So they said, we got to see what Juju can do. And he plays well. And they sat him. They said, we're going to redshirt you because we want to make sure we keep that additional year. So he played 4 games, and then they benched him for the remainder of the year so he could have that additional year. So we're looking at, these guys are getting paid a lot of money. And there's no guarantee that you will go pro. Injuries could happen as well. So I'm always counseling families about that. I have an example of a high school athlete I represent a quarterback, coming into this past year's football season as the number 1 quarterback in Georgia, rising up the boards. First game of the season, killed it. 4 touchdowns, 3 passing, 1 running. Second game of the season, torn ACL, out for the season. We had rev share deals on the table. And now we're looking around like, is this deal still going to be here? Again, this is a student athlete, life-changing money for not just for him, but for the family. And we're having to deal with those issues in real time.
Yeah. I'm going to ask one last question for the full panel, and then we'll try to take 1 or 2 questions, hopefully, if you have enough time. And this is just for looking forward. if we were to reconvene in like 5 to 10 years, what do we think the college sports model will look like, specifically thinking about like what role the NCAA will play, because their whole existence pretty much is to preserve amateurism. And as you guys have spoke about, it's a lot of pay for play, potentially athletes becoming employees and things like that. What do you think the future will look like? If you could have a little idea.
You want to start with me?
Yeah, go ahead, Jamil.
We'll start with you.
If I had a crystal ball, I mean, this is tough. This is hard because it's forever changing. I think the NCAA is still going to be around because there's going to be schools that still need a governance structure. I also think it's important to note that the member schools make the rules. They try to point at the blue disc as if they're the ones that's creating the chaos, but it's really the member institutions. They're deciding to come up with the College Sports Commission. They did that. The NCAA didn't do that, and they broke away trying to do it on their own. It's not working, and they're throwing a lot of wet paint at the wall, and these things are not working. But the NCAA gets a bad rap on all the things because they have to do what the schools say because they're just the governing body. The issue with all of these things, and again, getting back to the question is you need a vehicle. You need a vehicle to negotiate a CBA with. And so I think it's probably more 10 years down the line. I don't even know if it's going to happen then because they continue to fight against what could really bring some peace and create some rules and a structure and regulations around the space. But I think we're still going to be in the same place in 10 years. I don't think anything is going to be solved. I think there's going to be progress. It's going to be made. It's going to be short yardage. 4th and 1. Ain't nobody ain't going to be on the goal line. So in my estimation, I think we did that. Because again, you got people fighting the legislative fight. You got folks that's still, I'll use the term, more old school and wants to push this egalitarian model that's non-existent. And then the conferences are really about themselves. How can we benefit? Nobody's talked about conference realignment and the chaos that's caused. So it's a lot of issues that you have to look at, but I still think we'll be at the same point having the same conversation in the next 5 to 10 years.
Yes, so I want to answer this 2 halves, what I wish would happen and what I think will happen. I kind of wish that, like Dr. Northcutt said, that people would be rational and recognize that the long-term health of athletes as people, as students, and as economic actors is some form of a collective bargaining system. I don't think a single union is going to be very helpful. I would hope that each conference would have its own union so that there's still some competition. I don't think that the college athletes would ever go on strike. So it would be a very weak union if there was a single union. What I think will happen, because we live in the world's worst timeline, is that eventually Congress will pass an act that sets us back some, that essentially takes all the stuff that management would win at the bargaining table and gives them that legislatively without have any of the concessions. And so you'll see essentially a shift of money away from the talent, the athletes, towards the capital.
Yeah, I mean, I echo what he said. I mean, I think there will be some form of federal legislation, but it will shift that money back away from the athlete. I mean, that's what they're attempting to do now. There's been this large wealth transfer to folks who look like me. And so we can't really discount that too, like what's happening behind the scenes. I also think, there are conversations around private equity.
Yeah.
Costs millions of dollars to put these championship teams on the field or on the court. And again, we're going to the same boosters every year. We got to figure out a way to earn, to get money in the system. Now, with private equity comes other concerns and control, and they're not really focused on academics. They're focused on the bottom line. So all these other issues. So we're still a few years away. I agree, probably 10 years more than 5, because there's just so many complicated issues around all of these matters.
And one clarification point too on the private equity side, because I'm in the private equity space too. So the private equity lens too is not really about the roster. It's more about the ecosystem of how money is being made. And so you're starting to see, so again, if you pay attention, Atlanta's like one of the best places for a private equity person. If you look at Battery Park, and the ownership group that's there. They own the stadium. They've got all the restaurants that are around, all those different things that are creating the parking decks, the residential areas, the housing. That's what private equity is looking to do in the collegiate space. You've already seen a major deal with Utah and Otro Capital. And so that's what they're probably going to do. So don't be surprised if you see that. But again, they understand that the athletes and that revenue is going to be different. There's also discussions regarding coming in to how can you create these separate leagues. You're already hearing conversations about the SEC breaking away,
Right.
and other folks, getting ready to do their own thing as a result of the chaos that's around. Private equity will probably be in those conversations, depending on how the economics look and how they can benefit from it. But it's not a lens to where they're going to try to dictate everything. Private equity folks know how to make money, but they know how to make money from other consumers outside of the athletes that are expended. They know that the athletes bring people in, so they'll create other apparatuses around it to benefit from that.
And why is there so much resistance from other universities?
Because they're afraid. It's a negative narrative that's out there. But when they see the business case of it, and then there's other piece too, like if I'm a donor, so donor fatigue is a real thing too. So we hadn't even talked about that. So you got donors that are given resources to fund these rosters. And so what am I investing my money into? So private equity can come in and set up other funds and vehicles where there can be other investment resources that will start to give somebody a return of investment. You guys have heard of even with insurance companies. So if I can insure a donor's investment somewhere and an athlete ends up leaving, and then I can cash that quote unquote policy out, then there's still a return of that investment where I can give one time and then let it sit somewhere and generate some revenue that can keep the machine going.
Obviously, there's a lot more that we could talk about, but we're going to open it for questions.
4 minutes. We're giving y'all more
Oh,
time.
amazing. Ask all the questions y'all want. We got 10 minutes. Okay, you were the first one. Can you say your name first?
Sham Lawson.
Okay.
Great panel. I have I guess 2 questions. I guess one for the whole panel. One, is it possible, or are you advising clients to get insurance policies? Like, Donald, for the point that you're talking about, like, oh, the torn ACL and now all this missed potential income, and our teams taking out policies. Like how has NIL changed the insurance business with athletes?
Well, if I have the leverage, I'm negotiating that the school will pay for my client's insurance policy.
Yes,
So-
go ahead. Sorry.
I was just gonna say that there has been a shift in the sense of like I can't remember the athlete's name, but his family put like a $1 million like insurance policy on his shoulder. So that way, like if he's insured. So if he gets hurt or whatever, he's still gonna have like money to cover that in his career.
So from the team and league side or college institution side, yes. So if you look up a company, Players Health, that's one of the major insurance companies. They're selling those policies to institutions, et cetera. And they also sell individual policies to the athletes as well.
That is correct. Okay, my second question is maybe more so for Andy. Do you believe that you know how Jamil said, like, the NCAA just has to follow what the schools are saying, and the schools make CSC and all this, and it's chaotic and it's falling apart. My theory in the very beginning, and Donald can vouch for me, I said that I felt like the NCAA purposely did not create rules so that the chaos could ensue, so that they could turn back around and be like, see, we told y'all and you all ruined college football. We let you do what you wanted to do. And so you all ruined it and go back. Do you think that what this is the NCAA's intent, for there to be chaos?
Yes. I'll say a tiny bit more. European soccer is soccer is the most popular commercial sport in the world, and European soccer is sort of the most lucrative location for it. And there are 5 big leagues. There's the league in England, Spain, Italy, France, and Germany. France is sort of
EPL, La Liga.
Yeah.
You got Serie A.
Yeah.
And
Oh, that's right. You're a soccer man. So I just study it on paper. And athletes in the Italian league, for example,
earn about 70% of the total revenues that the Italian league generates. That dwarfs what any unionized league in America pays the labor force. And it's
Capitalism. I said capitalism.
it's because they have options. And they don't call that chaos in Europe. They call it following EU and competition law. And that's essentially, if you think about it, the things that the NCAA says that everyone says it's chaotic. Well, people are switching teams every year. Well, why don't you sign them to a long-term contract? Well, we don't want to give an employment contract. Well, if you don't want to make a deal that allows you to lock somebody in, then don't be surprised if they're a free agent every year because you set it up that way. And so, yeah. And the other thing, I just really have to say this because it bothers me like crazy, is when people say, this is not sustainable. We can't pay athletes this much. It's going to dry. Like, well, when it dries up, you'll pay them less. And until it dries up, when you say it's not sustainable, what you're really saying is I would prefer to pay less. And if a great example is as the House settlement was coming in, there was a year where people could get third-party payments that were essentially unlimited, and then also sign up for their share of the 20.5 million in revenue sharing. And like you said, schools went out and shoved extra money at people. You don't do that if you don't think they're worth it. And if there's not competition, you only have to pay somebody $1 more, well, plus working conditions and the coaching and stuff, but you only have to beat the next best bidder. There is nobody else offering a 20-year-old quarterback money except for other people who want him to be a quarterback. It's not because it costs more to produce them. It's not because the Russians are buying them to put them in the missile. It's competition within the schools. As long as the price keeps going up, I know it's sustainable because that's where the demand is coming from. And I think it's important to remember, this is not sustainable. This is crazy, I don't want to pay this much amount of money and I don't want to work this hard.
We'll go right here in the corner.
Kevin Gooch from Partner over at Holland and Knight. So who is providing the oversight as to whether something is really NIL or whether it is pay for play? And is there some rubric that's being used to make that determinant? Like, who does that? And then a second sort of shorter question is, with players going to like 5 different schools, does academic eligibility matter at all? I mean, all the credits can't be transferred from 5 different schools. Like, does that matter at all? Make it work.
Yeah.
First part is easy. It's the College Sports Commission. So that part was easy. Second part,
and nobody knows the rubrics they're using. It's a black box.
We don't know.
They're not. So it's we had an athlete that was with us that was at Michigan, transferred to UCLA. Obviously, both institutions are great academically, but some of those hours are not going to transfer. I mean, we've had athletes that have played at 4 or 5 schools. Same with the NCAA tournament. You guys are watching the NCAA tournament right now. You'll see athletes that are at certain schools that have played like 4 or 5 different places. So it's a major issue that nobody's paying attention to. And then anytime you have money enter into a space, there's a gold rush to grab those resources. So it presents a lot of problems. This whole transferring piece, you've got tampering, you've got also rogue agents or unscrupulous behavior that's happening. And so like all these things are problematic in the space.
And like someone echoed in the audience, like they're going to make it happen regardless. They're going to make sure that they can play and be eligible. Like I know we had girls transfer in for volleyball and like she didn't have enough credits for what she wanted to do, but she had enough credits for like art science or whatever it is to just get them in the door. So they're going to make it happen.
They're figuring it out in high school. So it's happening in high school as well.
Okay, everybody, we're going to go ahead and get started on our next panel. Right? Do we have a break? Yeah.
We don't really have a break.
Okay, yeah. We're going to go ahead and get started so that we can go straight to the reception and maximize our time. And please, once we finish this panel, just walk and talk on over to the Glen so that we can go ahead and get in that space and enjoy some cocktails. But to end the day, we have a wonderful panel. We're now talking about a different set of rights with a different playbook, but on copyrights. And we have a wonderful Miss Brianna Smith here from Arrington and Phillips. She's an associate attorney at that boutique entertainment law firm. She is going to introduce herself, tell a little bit more about the topic, and have the panelists introduce themselves. But, buckle up and stay attentive and get ready for some fun after this. This will be fun too.
Thank you, Chelsea. Hi, everyone. Good afternoon. Thank you all for sticking with us until the end. As Chelsea mentioned, my name is Brianna Smith, Associate Attorney, going on my 4th year with Arrington and Phillips here in Atlanta. My primary practice is entertainment with a focus on intellectual property and business law. And Ariel mentioned, you look like a proud mom. She's in the back with her camera up. But as she mentioned, we work with a lot of music artists, producers, labels, publishing companies, and then also small businesses and entrepreneurs. So I'm excited for this panel because we have a great group of panelists. I will let you guys introduce yourself, starting with Shane, and then I'll go with Becky.
Hi, I'm Shane Sanders. I'm the director of the music department at Tyler Perry Studios. And I've been in this business for about 18 years, dealing with music business and legal affairs for television and film.
And I'm Rick McMurtry. I'm a partner with MC Law Group. We're a boutique firm that primarily works with film and television studios. We handle all forms of IP except patents, which I loathe, and do a fair amount of music licensing. Prior to that, I got to work with Shane. We were both at the company now known as Warner Brothers Discovery. So I spent the bulk of my career there, 25 years, wore many hats, including chief and head of music, legal, and business.
My name's Becky Lee. I worked in the music business for about 10 years before I went to law school. Then I worked in private practice for about 7 to 8 years. And now I'm in-house at IHG Hotels and Resorts for the last 4. I have tried to stick my foot in anything music and entertainment related at my current role. So now anytime music or other kind of content copyright situation comes up, I try to get involved so I can do more entertainment law and not just corporate IP law.
So I'm going to just give a brief overview, and then Rick, my first question is going to be for you. But our topic today is recent developments in copyright licensing, trends, challenges, and any regulatory activity. So as a few of our panelists discussed earlier today, copyright licensing is ever changing now, with a lot of technological advancements that are going on as far as digital streaming and placing music in TV and film, and not only what we hear on the radio. So Rick, if you can start by explaining just what is copyright licensing for those who may not be familiar, and the different types of licensing.
That is a very big question, Brianna, but I'll do my best to try to summarize it. And I'm going to focus on film and television because that's really my bailiwick. When you have a film, you are going to be licensing a lot of copyrights. You're going to be licensing a copyright for background art. You're going to be licensing copyright for the music that's put into the program. You might be licensing the script. You might be doing that as a work for hire and then assigning the rights and the copyright to the studio or the production company. You might be licensing any number of elements, visual elements that go into the film or television program. And then when you get those licenses, that might not be all that you need. So we'll take music, for example. And I'm going to go with Whitney Houston, I Will Always Love You, The Bodyguard. So if you want to produce The Bodyguard, you will be getting a copyright license, a license to the composition from Dolly Parton and her publishing company, because she is the composer of I Will Always Love You. You'll also be getting a master license, if the song already exists, from the record label in order to get a license to the sound recording of Whitney Houston singing. And then after you have that license, the production company will then distribute it first in theaters and then on television or through streaming services. And the cable television company, the broadcast television company, the streaming service needs a public performance license to publicly perform that music. And they get those typically through PROs, performance rights organizations in the US. That's ASCAP, BMI, CSAC, and GMR. Outside the US, there are over 200 other collective management organizations that collect license fees and distribute royalties. In the US, those royalties are distributed back to the publisher and the composer. the publisher share 50%, the writer share 50%. Poor Whitney Houston and her record label, they get none of that. Only Dolly and her publishing get the royalties from the public performance rights. So Dolly is the smart one there because she's getting double paid. She got the sync license for the composition and she gets the royalties from the public performance. Fair? Okay.
And so I don't know if this is also in the materials that was distributed to you all, but Rick provided us with this lovely diagram just to help you understand the difference between the sound recording and the composition and where the stream flow comes once a song is released into the public. So my first question, Becky, I'll start with you. How have traditional licensing models, so music, film, TV, photography, how have they evolved in the past few years? I guess that was my second question. I'm sorry.
That's totally fine.
It's your first one today.
So I'm speaking purely, I've worked with artists and musicians and creators in private practice, but what I've seen mostly in the last few years is from the user side. So for me, the biggest change I've seen is proliferation. Because we are constantly getting calls and emails from new collection societies. Beyond GMR now there's All Music, there's another one popping up, and also we have the Motion Picture Licensing Corporation is now asking us for, they're calling them umbrella licenses, which is essentially the same as a blanket license. And MPLC is sharing or recruiting former staff from GMR to kind of replicate that business model. So for us, the most difficult thing is evaluating how our hotels use that music and film and TV. We're a franchisor, so most of our hotels are not under our control so much. I mean, we're obviously quality control, et cetera, but they are franchisees. So trying to evaluate what the risk is, where the liability stands between us and the hotels, how are they actually using film and TV? Is the sound that's being played in public spaces, is it covered by something like music styling or mood media? Or, you know, the PROs are going to say no, because if you have one Peloton in your fitness center, you have to cover that. And so there's just a lot of kind of evaluating who are the rights holders, how do we even track them down and verify? And one thing it's kind of a catch-22 because as technology is evolving for the rights holders to track where their music's being used, the collection societies at least are saying, well, you have no way of tracking what music you're playing, so you have to pay all of us just in case. So it's like, how do we get the technology on that side to kind of catch up with everything else?
And just to piggyback on that, you know, film and television studios have the in the can problem. I can't license The Bodyguard without that song in it. And so if the PRO for that song is GMR, then I have to have a GMR license. I don't control what music is played in advertising and commercials on my television network. So I have to get a license with all of the PROs, and they are effectively a monopoly because I can't avoid them. And yet only 2 of them are regulated, ASCAP and BMI, and CSAC and GMR are not.
Shane, do you want to add anything?
Well, I haven't seen anything change-wise from the things I do day to day over the past few years, but just to go up, you know, to second what they're talking about, it's been kind of ironic to see the proliferation of PROs and sort of the problem of licensing what we all know is more than 100% of the copyright from these public performance societies, while we've had the proliferation of technology that could actually give us a really accurate picture of music usage. Like there are audio fingerprinting technologies that exist that have been around for more than 10 years now, where we could get a really, really accurate picture of exactly what's being aired on a television network, say, but the PROs, when you're negotiating with them, kind of pretend that that kind of technology doesn't exist, and they want to continue to say, like, it's really difficult to know, you know, how much is in ASCAP's repertoire and BMI's repertoire and so on, when there's a lot of technology that would actually make it perfectly clear if we could get all the rights holders to come to the table and agree on using the technology to give us clarity on it. So there's been better technology, but more PROs at the same time. So
Yeah,
it's a
that
big
audio,
problem.
that audio finger recognition technology, I've seen it used both ways. One way that Shane and I used it is to generate cue sheets. So how do the PROs even know who the rights holders are in the music that's in a television program? Where you submit these cue sheets that say, I used this song written by this composer with this publisher. The duration was for this long. It was a theme song. It was score. It was feature song. It was video vocal. You describe all that information, and some poor production assistant is responsible for filling all those out. And you can imagine that there are plenty of errors in them. So we have to go back through and clean them up. Well, we can use audio recognition technology to listen to the feed to then generate those cue sheets to be more accurate. At the same time, rights holders are using audio recognition technology to identify when they believe their music has been sampled or used in other work without a license. And so I've seen claims increase as a result of technology developing to allow for better recognition of use of the music.
So both you and Becky did talk about the proliferation of PROs. I'm going to kind of jump into the Copyright Office inquiry. So what motivated Congress to ask the Copyright Office to examine PRO proliferation, and what problems were they trying to solve specifically?
I think the list of problems they were trying to solve is pretty long, but there were a few main things that they focused on. Before I get into it too much, though, do any of you currently work for a PRO? No. Okay. So I think this is one of the things where the artist side and the user side can agree. Yes, obviously PROs serve a purpose, but I think we can all agree that it needs reform. And so that was kind of the inquiry is Congress asked the Copyright Office to find out what are the biggest challenges from the music rights holder side and from the licensee side. What changes would you propose to how it works? It seems like the theme of today is black box. That definitely comes up with PROs too, because it all goes into a pot and there's some magic algorithm and then the money goes out. And I don't think anyone really knows how that works. So those were the kinds of things that the Copyright Office was trying to find out. And then they collected the responses and reported them over to Congress. And so on my end, we worked with one of our trade organizations to kind of talk about the issues with the hospitality industry. And it's kind of what I was saying before. What are some ways you can actually track what music you're using? How can we beef up, for example, the SongView database and try to replicate that so that we can actually track what music we're using and not just pay all of the PROs as basically an insurance policy? Like, can we actually be more accurate about who we're paying and why and that sort of thing?
Yeah, I think that's a fair summary. As I mentioned, BMI and ASCAP are regulated by the consent decree from the DOJ. ASCAP, CSAC and GMR are not. And ASCAP and BMI would very much like not to be regulated by that consent decree.
Yeah.
And they argue that the rates are pretty established. For general entertainment programming, for example, the rate is 0.375% of gross revenue each. And then CSAC, and that they're thought to represent about 90 to 95% of all publishers between the two of them. But then CSAC and GMR would then represent the remaining 5 to 10%. GMR only has about 136 composers on their roster. And yet they're big names, Bruno Mars, John Bon Jovi. So GMR comes in and says, well, but who we have is more valuable. So even though our market share is low, the value of our music is higher. And so we want to command a higher rate. And ASCAP and BMI then come in and say, look at what GMR is getting for a rate compared to our market share. We shouldn't have such low percentages. And so, question mark. And then you have Becky's problem of, okay, fine, John Bon Jovi showed up in one ad on a television that played in the lobby. Why do I have to get a whole GMR license for such incidental de minimis use? GMR does not care about that. So
it depends too about that, like where and how the song of a GMR use is being used, right? Like you can't just sort of throw a blanket on it and say that every time Bruno Mars is being used, it's that much more valuable than another. If it's a theme song for something, maybe it's more valuable, but it might not just automatically bring more, something you could actually quantify as being more valuable.
Yeah. There's also in the CLE materials, there's a link to both the inquiry and then the Copyright Office's summary of their responses, which I thought was really interesting because there were a lot of creative solutions proposed by people smarter than me who have ideas about solving some of these issues. So.
Okay, so let's diving into another question. So there are about 5,000 comments on what stood out to you specifically.
I think for me, it's the what we've been talking about, which is finding a tech solution to being able to track it, not necessarily pay one-to-one for what songs you use, but at least being able to like look up, like for example, in SongView now, ASCAP and BMI will list if something's 100% them or some other PRO. Mm-hmm. And I think CSAC and GMR are joining the SongView database. But there's just so much there. And so you still, as far as I know, you still have to like look up each song. So if there was some kind of technology where, especially if you're paying Music Styling or one of those streaming music providers for, brick and mortar business, background music, whatever, digital jukeboxes, I don't know, something where all of that stuff is going into a database and it's tracking, this song that you played on Tuesday was 50% this one and 50% that one, or something. Like all the technology exists. I think it's just being able to bring it together.
So Rick, how are fractional licensing and multi-stakeholder or multi-layer licensing, how is that contributing to greater complexity for users and rights holders? And then can you also just explain what both types of licensing?
Okay, wait. I forgot.
Okay. How
it's a compound question, objection. So what is fractional licensing?
Yes.
Let's start with that.
Yes.
So fractional licensing is what it sounds like. You are licensing when a piece of work, a Pitbull song, since we keep talking about music, and I didn't mean to focus solely on music, but a Pitbull song, he's going to sample about 20 different artists in there. So he doesn't own 100% of the copyright in the final work. So you would be licensing out, and with respect to the PROs, they don't represent all 21 people that are on that Pitbull song. So they are only licensing as to the amount of the work that they, have the right to grant the public performance rights. And you have to go out and clear a song. And when you clear a song, you're looking at who are the various rights holders and what percentage of rights do they have in this song. You would be shocked to find the number of times that percentage does not add up to 100. It often adds up to more than that. And then you gotta kind of dig in and figure out. All right, that was.
And then also,
anybody else want to talk about fractional licensing?
No. And multi-stakeholder or multi-layered licensing.
You just mean like multiple copyright holders of a song?
Yes.
That's not going to ever go away, and it's incredibly confusing, and it's just a hall of mirrors all the time. This stuff, it's like people are always bedeviled by this, even me, after doing it every day for however many years I've been doing it. I've got examples within the past week of thinking that I had tracked down all 8 people on a song, verifying it to the greatest extent possible, getting the song licensed, getting everybody paid again for 100%. This was on the composition side, just on the publishing side, getting everybody paid. And then a month later, somebody else comes out of the woodwork and says, hey, we heard that you had licensed this song, and our writer came forward with not just like 5%, they were like, we have 20% of the song, right? This happens all the time. It's nonstop. So multi-stakeholder stuff with music, from what I can tell, I don't deal with any other types of licensing, but it makes it just uniquely difficult. And you can, no matter how great of a job you do of doing your due diligence on things, somebody's always, anything can pop up at any time. And a big thing with it too is music composition copyrights change hands all the time, and songwriters change PROs all the time, and they can increasingly they can do that freely. So yeah, it's pretty wild.
I have a question on that for the film and TV side of it. So fractional licensing is not really a thing with the actual like visual part, right? So, or if it is
not really, I mean, it can come up, there can be restricted. I'm sorry,
Okay.
I'm sitting back and just chatting with Becky. It can come up, but no, usually when you get the copyright license to use the artwork or other visual material within the film itself, it is granting you the rights to use that within the film in perpetuity worldwide in all media now known and hereafter.
Yeah.
And all the things. But there could be some restrictions in the license agreement. Like, I'm not going to allow you to license a clip that features my song for use in a political advertisement. For example, I wouldn't take a CNN clip and license it to a candidate that contains music from a third party. I can't do that.
So would it be possible, kind of the way that, let's say you're on a bigger label and you're using Warner Brothers as your publisher or whatever, and they're administering all of the things. Would it be possible to do away with fractional licensing and then you have like one person responsible for each song and they have to do the accounting and dole
Wouldn't
out
that
the
be lovely
percentages?
if we could? I mean, from a licensee perspective, that would be lovely. Most of the time there's an MFN clause. So there's an MFN between the publisher and the record label on the master side. And theoretically, one copyright owner has the right to license a work as long as they do an accounting to their co-copyright owners, but that's just not the way it works in the music space. You have to go to each one individually, and each one has an MFN with all the other ones.
And publishers often have complicated approval arrangements with the songwriters themselves. Like if you want to license a song from Al Green, that's written by Al Green, you have to go through this really complicated answer list of questions that are really specific that Mr. Green himself has come up with, right? And so you might have rights holders behind the publishers who have got those kind of approval or denial rights.
If you can just explain MFN for people who may not be
Oh, it's
familiar.
most favored nations. So if I'm paying $10,000 to the publisher, then the record label that has the master is also making sure that they are getting at least as much as the publisher is getting. And then if you have multiple publishers involved, they're going to make sure that they get their fair share. So if one has 50% and two have 25%, then the two that have 25% should be paying half of what the one who gets 50%.
So what is the current copyright licensing landscape, and where do you see the most growth in digital performance licensing?
You want me to start? I mean, I can't not talk about artificial intelligence. I'm sure I haven't been here for the whole day, but I'm sure I'm not the first person to say those two words today.
People were
I do think with respect, now we're seeing in more and more licenses, you can't use my work in artificial intelligence when you license that in. Well, that's impractical. Film and television studios use artificial intelligence all the time for things like content recommendation, post-production editing, dubbing, and subtitling, and everything else. And that necessarily requires that you feed in the full work that includes any licensed work that's included among that. So coming to some sort of language that says, look, we can use it for what you would expect, but we can't use it for purposes of generating derivative work of your work, or for purposes of training the AI tool so that it can be trained off of your work. You would, Shane and I have been in these battles together. We just can't seem to come up with uniform language that everybody will accept. Some rights holders are just like bound and determined to say, no, you just can't use it at all. And they're going to lose out because it's impractical not to be able to use it in some way. And I had I don't want to say privilege. I had both the privilege and the burden of being the Warner Brothers rep to SAG-AFTRA in the negotiations around artificial intelligence and the restrictions with respect to using digital replicas and synthetic performers, digital replica being a digital image of a recognizable human being, a synthetic performer being a digital image of someone who doesn't look like any one individual human being. And how do you get paid out when somebody uses your digital replica? And what happens when you use a synthetic performer that replaces that background actor that was in the background scene of When Harry Met Sally in the famous restaurant scene? How do those performers get compensated? And what happens when you don't need as many hair and makeup people because you don't have as many real people that use hair and makeup? What happens when digitally alter the content so that the performance that you gave me that was in front of a bucolic scene, I suddenly put you in front of a Trump rally, and you don't want to be seen at a Trump rally in the film, but I've digitally altered it to change. And when do you have the right to do that? I'm kind of segueing into copyright licensing will eventually get into some of the same places. Like, how can you use my work? I need you to be more, concrete about how that work is used and whether you will be altering the work in any way using artificial intelligence. And what are my moral rights in that work? If I were in the EU and your alteration of my work in some way, I think there's just going to be a lot more impact from AI on copyright licensing in general.
I think you summed it up pretty well. I've seen in some of the agreements that we have as far as copyright licensing and like the intellectual property, it is hard to find perfect language, but like adding little caveats and of course asking for approval on certain things if you are using the specific company that we just did a deal with for one of our clients. But we kept the language in and provided a caveat for like approval, and then the artist is also able to just opt out of it completely. And if the company does want to license it, they'll ask for approval from us. So AI is a lot, and like I don't think it's still here, but it's not going anywhere. So we have to get used to it. With that, so what impacts, positive or negative, does this current environment have on smaller artists or like independent creators?
I mean, this is from the other side from where I am now, but we've seen that the digital fingerprint stuff is being used on social media now too. And so as much as it's an inconvenience, or we've discovered something that we didn't know about in my current role, I think it's good that an independent artist who's released their song has a way to figure out where it may have been used without, it's basically the reverse image search. Like you've got that now for music. And so I think that's a good thing because then you can go find ways to get paid where you wouldn't have been paid before.
Yeah, I think it's tough because you can use artificial intelligence to generate music cues that are not significant to the score or the show itself. Small musical licks that show up in a program, and we don't care as a licensee whether that was. Well, I shouldn't say that. I don't care personally, Rick McMurtry, whether that was generated via AI or via some no-name small artist who sat down for a few minutes and figured it out. At the same time, the creative community is kind of arm in arm, RIAA, and they're saying, no, you can't use music generated via AI or artwork for that matter. Again, I don't mean to focus solely on music. But the truth is it's not going anywhere. Analogize it to in the late 80s, early 90s. I was a bank teller. That was my, college job. And ATMs came out. And, now all of a sudden they came to the bank tellers like, oh, don't worry. People will still want to come in the bank and see their favorite teller. You're not going to use your job. Well, 2 years later, I was an ATM repairman, not a bank teller. The reason is, ATMs were ubiquitous. They were open 24/7. They're more accurate, if I'm honest. You don't have to get out of your car in most cases to go to an ATM. The same is true of AI. Like it is convenient. It is quick. For low cost kind of things where I don't need Diane Warren to compose that song, or I don't need, Banksy to provide this artwork. I do worry that for the smaller creators, that AI is going to have a disproportionate impact on their kind of entry level work.
That raises it. You also mentioned moral rights, and I was thinking about something that came up recently where one of our hotels is having a mural painted on the side of their hotel. And then do those apply? Does VARA apply if we post pictures of that hotel on our website and then they're digitally altered? Like where's that line going to be? So I'm really interested to see how some of those issues play out. I'm sort of pro because I have to be, because our marketing team is like, we want to generate everything with AI. And I'm just like, okay, they're going to move fast and break things. And I have to make sure they don't break the wrong things.
Yeah.
So Shane, this question is for you. Regarding trends in major studio consolidation, so the competition over Warner Brothers, Amazon buying MGM, what licensing issues or changes do you all anticipate within the next few years as these consolidations continue?
Well, with studio consolidation, I hadn't really thought about how that would affect licensing stuff. Good question. I don't really see it particularly having an impact on what music rights holders are doing with their licensing practices.
Content licensing out studio, the color produced studios like.
Oh, you mean like that kind of stuff? Okay. Well, I mean, we're gonna have, a lot fewer people to talk to that have a lot more leverage, I guess, unfortunately, right? If you're like we are, Tyler Perry Studios is essentially a production company of its stuff and not a distributor. So we're going to be at the mercy of fewer and fewer distributors in that sense, which I don't think is a good thing. You would hope to see, with the proliferation of digital distribution technology, not such a consolidation. I think it would be better for people in our perspective to have more avenues to pursue with that. I think anytime you've got that kind of consolidation of artistic work like music and movies, it's not really a good thing. I think it's going to make it more difficult for smaller studios to make movies for many, many
That was
reasons.
one of my next questions. So how do you think that will impact the smaller production companies as far as their ownership in certain things as well, like the copyrights and intellectual property?
Yeah, I mean, they're gonna, if you're a small movie studio that's trying to sell something, you're gonna have to sell it outright rather than license it to these people, because they're not gonna negotiate with you about that, obviously. I think it's bad for small studios, and it's bad for, daring content, right? That's how I see that. Like when I hear about the Skydance Warner Brothers Discovery thing, I just think there goes, more opportunities for good experimental groundbreaking movies to be made that'll get seen by a lot of people. So I kind of think of it from that perspective. Yeah, I think that's what I would say about that. It's not good for smaller creative studios.
Okay. So regarding ready-made content for licensing and the evolution of licensing strategies on streaming platforms, for example, streaming platforms are rapidly becoming more creative with licensing their IP. So K-pop Demon Hunters, it was released on Netflix at first, and then they immediately went straight to like theatrical releases, and they put things in stores as far as like that you could get all within a few months. How do these strategies affect the traditional licensing route, and where does this leave the initial creator as the deal passes through like numerous companies and hands?
You want me to start?
Yeah, that's more your role.
So obviously those windows have shortened. So traditionally it was in theaters, 6 months, then it goes to premium cable, then basic cable, then broadcast. And now first of all, those windows have shortened dramatically. Second of all, sometimes they're flip-flopped like K-pop Demon Hunter. And so, obviously the theatrical distribution world is shrinking. I'm sure you watch far more movies on streaming services than you actually go to the theaters to watch. So the licensing of the theatrical window has shrunk both in duration and in the value and how much you're paying for that. And then from a streaming perspective, you're going to want very broad rights and a lot of exclusivity if you're paying top dollar to stream, something big, right? And you don't want encroachment in that premium cable or broadcast cable or premium cable, basic cable broadcast. You don't want any encroachment into that. And so I've seen in a lot of the content licensing for the streaming services that they're being very express about what those windows are, what it encompasses, territory of distribution, everything like that.
And I guess that goes to like another question too. It kind of touches on it. How are broadcasters, streaming platforms, and hospitality businesses, how are they adapting to the growing complexity of the licensing requirements?
I can speak from the hospitality side. We're just having to constantly evaluate, kind of like I was saying a minute ago with MPLC. So the way that, I don't know if any of you are familiar with them, but the way that they work is they have producer clients. So they're kind of like, they're trying to act like a PRO, but it's just different because it's not the same kind of rights that they're really dealing with. And so MPLC came to us and said, you're definitely showing film and TV on your television screens in your hotels. You need to be paying a license to us. And we had to kind of take a step back and say, well, hang on, who do you represent exactly? And they give us just a list of producers, but then there's something like Warner Brothers on there. And it's like, well, what does that mean exactly? Because that doesn't mean necessarily that you have every single Warner Brothers title in your catalog. And we also talked to them about, mostly it's like if you're at a Holiday Inn Express, for example, if there's a TV on the wall, it's probably showing the morning news. It's not, it's not really showing like the Big Lebowski or something. So we're trying to figure out, how are our hotels actually using this stuff? And then there's the added layer of the cable company has their own licensing terms about the broadcast license. And so did they already cover public performance, or do they only cover the broadcast from Xfinity to the hotel and not hotel to a room full of diners or whatever? So for us, it's more about, we're just constantly surveying the hotels and the brand teams, because the brand teams can set the standards for what kind of music is played in that hotel. They want a certain sound, or they want a certain feel, or they're going to dictate that a hotel hosts movie nights, for example, which they don't really do. But we've got to have some kind of visibility into what our licensees are doing so that we can figure out, is that our responsibility? Do we need to have these blanket licenses in place, or do we just let the hotels, if it's variable enough, do we just let the hotels make those decisions? So it's just a lot of constantly surveying and figuring out what's going on.
Yeah, as there are more and more distribution partners and distribution outlets, it's a hot potato as to who has the obligation to get the public performance license. So right now, fast television channels. Do you guys know what I mean when I'm talking about that? Free ad-supported television, like a MeTV or something like that. Is it the programmer who's responsible for getting that license and then passing it on to the fast distributor, say Philo TV, for example? Or is it the fast distributor who's responsible? And the PROs are basically like, we don't care, just somebody pay us. And so then, we're coming up with an industry standard for fast right now. It is not settled. Generally, we kind of say if the programmer is programming the channel, then the programmer is responsible for getting it through to the viewer, public performance license. But if the programmer is merely providing content, that the fast distributor then creates a channel around the Western channel, and I license Gunsmoke to them for that, then the fast distributor is responsible. What the PROs don't want is having to figure it out. They want some stability of knowing like whose door to knock on when they're seeking a license.
And for like programmers, what do you mean
Like
specifically?
if there's a NBCU has the A-Team fast channel. And so NBCU is the programmer of that channel. It just runs, by the way, at what you might expect, reruns of the A-Team from the 1980s. And so programming the channel is simply a matter of like putting back-to-back episodes of the A-Team on the channel. Whereas if I had a Western channel, then and I licensed Gunsmoke from one distributor, from one rights holder, and I license, why can't I think of another Western, Lonesome Dove, the movie, from somebody else, and then put it together in a Western channel. I am programming the channel.
Gotcha.
And therefore should be responsible for getting the license.
Thank you for clarity. So do you all, due to the increased competition among PROs, but do you feel like that is benefiting or burdening the licensees, and in which ways? What ways?
From my personal perspective, disclaimer, none of this, I'm not speaking on behalf of my company. My personal perspective is it's too much. It's just gotten really out of hand, and more and more of them keep popping up, and they're making the same argument. Well, you don't know what you're playing, so you have to pay us just in case. Like, you're creating that problem. It's making it harder for me to track who has what, and you want me to pay you for this, completely opaque business model you've built, and they won't guarantee like a certain point in time where their repertoire is fixed. So for the newer ones, they'll just say like, well, we don't update our member list in real time, so good luck. And it just makes it really challenging. So for me, I think kind of like what Rick was saying, if we're going to open it up to competition, open ASCAP and BMI need to be in there, because it really is completely imbalanced, and there's nothing to stop more of them from popping up, because all they do is they call and they strong arm you and threaten lawsuits. And they'll put the Copyright Act statute in the email to the hotel owners, and the hotel owners are like, we don't know what to do with this. What do we do? And we've got to kind of figure out, how do we give guidance without, in the franchisee example, we can't give them legal advice. So we have to kind of give them guidance without doing that. So from my perspective, it's just gotten completely out of hand. And as much as I don't want to say there needs to be more regulation, there just something has to give at some point.
So I know you all mentioned, so we know BMI, ASCAP, CSAC, and GMR here in the US. And then there are like over 200 outside of the US. So the newly formed PROs, are they all outside of the US?
No, all music's here. There's a sixth one. I can't remember the name of it. It's here. Yeah. And is it?
It's called
It's not
PRO.
confusing at all.
Oh, okay.
And there are actually more, it used to be that in each country there was kind of one central one and it was easier to keep track. Like I would just go to the BMI website and look up their partners and figure out, but now those are also growing. So we got an email from an agency in Sub-Saharan Africa that said, we hold all the rights for all music in Sub-Saharan Africa. And I'm like, well, I need you to be more specific because that could be a lot of rights holders. That could be a lot of countries. Like you've got to give me more information. So I think people outside the US now are watching how it's expanding here and trying to duplicate that business model.
Well, I was just going to say, I'm a musician and couldn't be any more of an advocate for artists and songwriter rights and having PROs do what they do. But the PROs can't have it both ways and make all these demands and have everything be so purposely opaque. Like the fact that even the two that are operating under consent decrees, ASCAP and BMI, the way that they calculate and pay royalties just between ASCAP and BMI is completely different and not really known to anybody except the people who work in those offices. That's crazy to me. And so they're not doing their member songwriter and publisher members any favors. Maybe at some point it was working, but it has gotten out of hand. I mean, like he put it perfectly when you say it's gotten out of control.
Well, Shane, you and I have had examples where you have an ASCAP writer and a BMI writer on the same piece of music, and one pays out a lot more than the other, for the same performance.
Exactly.
Like you don't know why it's going that way. And as more PROs have cropped up, it's not that they've eaten into any slice of the pie. They've just tried to make that pie bigger. And we keep going back and saying like, it's only one pie. You can have your slice, but that means somebody else's slice is smaller. And yet it doesn't seem to be happening that way.
And we also know, and I'm not going to name any specific names of the PROs, but that they just don't pay their members equally and really fairly, right? I mean, I know that ASCAP and BMI writers just have different experiences, especially like it's sort of known with certain PROs that if you're a bigger name songwriter, you're going to get paid more than if you're a smaller name and an independent, right? So it's not equal.
We had a situation I think it was my first couple of years of practice where we had to change the writer credit information on an ASCAP account, and one of the co-writers had passed and didn't go through probate. And so they were able to give one co-writer her share and then a kind of a publishing share. And then his part, it was just like, they said, well, you have to go through probate. Like we can't just add him or add his estate's information. And so I'm sure that's not the only situation where that's happened. So who knows where that's going. It's just like going back into the pot, I guess. So.
Well, the process, so we've been in the process for a few of our clients too, and it takes a long time, but you basically have to, and for one of our recent clients, they didn't even know that he passed away. He's been now. So when we reached out to kind of see like, okay, can we change the money to go to his estate because his family can't manage that account anymore. It takes about 6 to 8 months, they told us, and they suspend everything. But now I don't know what they do internally as far as all of the songs that are in his catalog. But you kind of have to let them know, or else it just it's money and it goes wherever it goes, into that black box, I guess maybe. So we are going to wrap down. Thank you. We are going to start winding down. I am going to ask maybe 1 or 2 last questions before we open it up for questions and answers from the audience. So what industry examples best illustrate the rise of direct licensing, hybrid publisher / duetty is a good example?
Yeah, that was one of the ones that reached out to us to kind of talk about not only on property music, but also social media. And it's, ultimately it's up to our brand teams to choose what kind of sound they want for each brand. So we can't tell them you have to use this, but the more they see the consequences of trying to follow the current licensing scheme and be compliant with all of the different copyright laws, the more they start to really look at direct licensing solutions and being able to license music for multiple different channels and worldwide, et cetera, the more they kind of warm up to the idea. So, and I think that's also an opportunity for independent artists, because if you go, for example, to a Kimpton hotel, maybe you do want to hear more emerging artists and not as much Taylor Swift. So, you know, as from a compliance standpoint, like, yeah, we want more direct licensing. And then from a brand standpoint, can those two considerations come together at some point? So I'm looking forward to seeing how some of that plays out.
And I don't know if everybody understands what you mean by direct licensing. It's when you directly license the public performance rights from the rights holder. You don't go through the PRO. And where we've found that useful, where some of my clients have found that useful is particularly with live programming, mostly news and sports. It is when you have 24/7 news. So it's, you know, new programming all throughout the day. You still have to prepare cue sheets and submit those. And so if you're using library music, for example, so you have commercial music, what you might hear on the radio, you have composed music, what you hire a composer to produce as original music for you. And then you have library music, which is music that's not something you might hear on the radio, but it's music nonetheless. It's just not popular commercial music. So you can license that library music directly for live programming when you don't have time to prepare cue sheets.
Direct licensing for film and television, it's like the only people who really are going to be trying to get direct licensing done are distributors, right? So if you're a production company or a studio, it doesn't benefit you at all, and you're not going to want to pay the additional fees you're going to have to pay to get direct licenses. And it's kind of amazing, like anytime the topic even comes up even in a work for hire deal that I'm dealing with somebody, if we broach the topic at all, there's kind of this offense taken where they're like, oh, you want to take this revenue stream from us, even if it could. It's always potentially the case if you're selling the copyright to music you're making in a work for hire commission situation, that taking the upfront direct license payment could actually make you a lot more money than you would ever make from a PRO collection standpoint down the road. It just depends on how much PRO revenue is generated by. But it's, you know, it's just funny. I see with television stuff, it's just, it's not really something that can happen unless you're a distributor. You're not going to have the funds to do it or the motivation.
For our last question, what practical steps should rights holders, licensees, or plea counsel, what should we take next to prepare for the changing licensing environment?
Oh, that's a tough one. I think for me, if you're on the licensee side, like I said, just keeping it, you know, constantly surveying what your clients are doing. If you have clients who use business social media accounts, make sure they understand how the commercial music library works. You just have to constantly be reading the case law and watching what's going on and trying to figure out where the biggest risks are, because they're changing day to day.
Yeah, I'll pick on artificial intelligence again. I think just making sure that you get the reps and warranties that you need, so that you cannot register AI generated works as copyright. Now, the question is, what is AI generated versus AI assisted? And it's going to be a while before I think that's figured out. But I need my content to be protectable. And if the theme song for my new show is 100% AI generated and I can't register as a copyright and may not be able to enforce any rights against it, then I've just lost a valuable income stream. Just think of the theme song from Friends, by way of example, the amount of royalties that song has generated, apart from, the show itself is pretty phenomenal. And yet if I, can't enforce against it, what's to stop anybody else from playing it out? And
Remind me of the question again, because I was listening to what he said, I forgot.
What practical steps should rights holders, licensees, or council take now to prepare for the changing licensing environment?
If you're a rights holder, control all of the master recording and publishing to the greatest extent possible, period. And that's the thing that I would say with, like you were talking earlier about independent artists and technology. You know, I don't see enough people who are independent songwriters and performers who are fully grasping the capabilities that are available to them to control and protect and just be the master of everything that they create. I'm amazed at how I don't see as many young people, creators, as I would expect or hope to see, who are taking advantage of all the power that they have in the industry now. Because if you're capable and have the time and the wherewithal creatively and whatever to write and produce and perform and record and release your own music, you really should make sure, because it's now more than ever, you can be educated and control all of it and demand. You don't have to get people to help you make money off it. So try and take as much control of it as you can.
So we are going to open the floor for questions. Okay. One question. Anybody? You guys had questions for everybody else to do that?
No,
We were here all day. Brian?
Hi, my name is Brian Hadamil, and I'm a third-year law student. I wanted to know, y'all mentioned moral rights. I know that they're not waivable in France. Do you think in the US they're not waivable just because of capitalism? I know that.
Oh, why do I think?
100%. 100%.
Question?
Yeah, he asked why moral rights are waivable in the US compared to other countries. And he said, is it capitalism? Which 100%, yes. I've talked about this with some attorneys from Mexico. They just can't wrap their mind around how limited moral rights here are in the US. I think we did the bare minimum to comply with the Berne Convention, and then just it's good enough. So
to add on, it's interesting. The debate around incorporating copyright into the Constitution included a very heated discussion about moral rights. And there was a decision not to. So there's a reason we don't have moral rights. I mean, it's part of USA Inc. I'm not sure it's capitalism because France, they're all capitalist places, but it's the United States specifically left moral rights behind in the Constitution. We don't have it. So that's why it's waivable here.
I've never thought about it. I just know that's the truth.
I can just say that when you're talking to people about these issues in Europe versus the US, you know, there's more of a basic understanding or their accepted understanding of what's kind of right or wrong about it. Here, I think it's more like, oh, there's no right or wrong about it. And when I talk to people in Europe, they see it as an ethical. You know?
Yeah, it's just to show your perspective, right? Like, I'm like, you signed it away, my friend. You took the check. You know, I bought the painting. If I want to burn it, I'll burn it. You know, I paid for it. But that's just not the way Europeans at least think about it. Like, that is my baby. I'm allowing you to adopt it, but you can't murder it.
Well, thank you all for coming to our panel today. I hope you guys, y'all are getting ready. I'll talk fast. I hope you guys enjoyed all of the panels today, and that you will join us for our happy hour next door at the Glen, at the bar in the Glen, and for more events from the entertainment and sports section.